Morning, everybody. Welcome back. Welcome to Thursday, day 16 in the Karen retrial. We get to start with more Alessi Cross. How could a day be better? How could a day be better? I was so enthusiastic about this cross-exam that I went back to look at Maureen Hartnett's testimony from the first trial just to see if I could maybe get a little preview of what's to come. What does he still have to work with? And so I'm going to share with you a little bit about what I found. But first, before we do that, so many of you asked me, tagged me in this clip where it sounds like maybe Bev is calling Mr. Yannetti an asshole. I got it, guys. We're going to listen to it. And let's see what you guys think. Let's see what you guys think.
Did Michael Proctor reveal to you that he and Kevin Albert had socialized together by drinking alcohol in his cruises?
Sustained and jurors, I'm going to ask you to strike that question. Disregard.
I need to be heard at sidebar.
I will hear you.
It's right at the end there. Very difficult to hear.
Did
like right here. Asshole. It's very quiet. It's very quiet, very difficult to hear, but it sure does sound like asshole, doesn't it? It really does. That said, I'm not sure that it's Bev. I'm not 100% sure that it's Bev. It sounds like it's coming from a different location. We had kind of just heard her voice in the microphone. Obviously annoyed. I will hear you at sidebar. She had previously denied the sidebar. Now he's asking for it. She's granting it. It sounded like it might have come from a different microphone. So not 100% sure that was Bev, but I sure did hear us. I think someone did say that. You got to be careful near those microphones. This is another area where defense might have a little bit of advantage in the trial when it comes to the hot mic, because you're really used to it being there. You got to turn it off and on. You got to cover it. You got to get away from it constantly throughout the trial to talk to your client. Your client's up there in your ear. You can't have the mic picking that up. You got confidentiality. So you just are often very cognizant of that microphone. If you're not the defense attorney in the courtroom, may not just be so conscious of the location of that microphone all the time. So yeah, it does seem like somebody got busted. I'm not 100% convinced it was Judge Cannoni that got busted, but somebody got busted. Some of you caught that in real time. That was a good catch. I didn't catch that in real time at all. Very hard to hear, but sure does. Sure does sound like somebody saying asshole. Well, let's talk about Maureen Hartnett and where this cross-exam is going. I'm so excited about it. I mean, you know, I'm a huge Alessi fan by now. He's very technical with cross and so effective. It's a pleasure to watch him do what he's doing. And he's able to do it with the confidence of somebody who knows. He's there to present information, and he's going to be able to get it in regardless of what you do. And this is just often the best approach that you can take to a cross-examination. You win the cross in prep. You already know everything that's in their report. You already know everything that they've said before, all of their previous testimony, what they've relied on, where the problems are. And you've gone through and you've identified what parts of that are helpful to my case. And that's what you're using your cross-examination to elicit. So that's that skill of being able to turn the opponent's witness into your own witness, which is just so much fun when you're able to do that. It's so much fun, so satisfying. And it's because he's so focused on the facts that he's so effective. Mr. Alessi is probably the smartest person in the room, like most of the time in most rooms that he's in. And so that gives him a big advantage in dealing with experts. But you can see, for example, like his most difficult adversary so far really has been Jessica Hyde. And that's because she's also very smart woman. She's, thinking ahead past where he's at with his question. She already knows where he's going. She's so eager to jump in and cut him off and explain. But Jessica Hyde's limitation was that politeness limitation. She was able to be moved around, so to speak, managed with the politeness battle. So this is how Alessi controls the pace and range of the cross-examination. He has his tools, right? His fists. He's got his facts. Those are his fists. Those are what he's going to land. But how is he going to land them, and what is it going to look like? That can come down a little bit to the style of the parties. With Jessica Hyde, you can see right away. Oh, she's polite, professional. She has that professorial kind of demeanor. And so that's what you can work on. You can use that against her. Okay. She's concerned about being polite. Then you use that to point out, well, you're interrupting. Need to let me finish my question. Oh, she'll back off. So the facts though are what he really has to do the damage. So Maureen Hartnett, nowhere near as smart as Robert Alessi, and so he's able to manipulate her a little bit more easily. He was already planning to show that side by side of the photos, guys. He was already planning to show that, but got her to beg him for it. Oh my Lord. I'm sorry, but anybody who criticizes Robert Alessi as an attorney, I would just like to know, how many times have you gotten the state's expert to ask you to present your evidence supporting your position? How many times have you pulled that off? Gotten them to please put it under my nose, make it hurt. Oh, such a gift. So, what are some of the facts he's going to have to work with today? Couple that could be significant. We know from the last trial, Maureen Hartnett failed a proficiency exam. So this is a fairly standard cross-examination subject for an expert. If you are not competent at your job, then that goes to the weight that the jury should give your evidence. So she had failed a proficiency examination in 2002. It involved the identification of a hair. And, her explanation, she did not recognize a root on the hair. And so she got some extra work from her supervisor. They talked her through it, showed her, here's what you look for and stuff. And then she did another test. And so now it's all fine and good. I don't know if it's the most dramatic thing out there, but it is a fact. It is conventional to use something like that in cross-examination. I expect Mr. Alessi to do that. What I'm interested in is, how does he do it? Does he have a way to make that land particularly well? We shall see. Went back and revisited the swabbing, all the swabbing and the sampling she did, particularly of John's clothing back in the first trial, because they really rushed over that with Mr. Brennan, didn't they? He didn't even mention those shoes. But in the first trial, very clearly, there was at least one blood stain on the sneaker. All of her tests of this clothing came out with the confirmatory positive for blood. So found blood on the sneaker. That's, for me, like a critical fact. Hey, this is pretty much dispositive for me. Man is on his feet when that blood landed on his sneaker. You're going to have a hard time convincing me he was in any other position than that. The number of stains that were there. We just kind of, brushed over. Oh, there was some staining and stuff like that. But there were 4 separate stains on the jeans and 5 separate stains on the t-shirt that she tested for blood. And an important part of the blood pattern, in my opinion, there was no blood on the inside of the sweatshirt, on the front of the sweatshirt. And the reason why this matters is because that's a potential explanation for why is there blood on his t-shirt, right? He shouldn't have blood on his t-shirt unless maybe it seeped through the sweatshirt and onto the t-shirt. But if he gets out of the car, Karen's car, wearing his sweatshirt, she hits him with the car, he falls and dies in the snow, there should not be any blood on his t-shirt unless it just seeped right through. There's no blood on the inside of that sweatshirt, so it did not seep through. That is not the source of the blood on the t-shirt. So why is there blood on his undershirt? How did it get there? Commonwealth's going to have a hard time explaining that one to me as well. Another fact that came out in the first trial, we know what's coming with the scrapings, right? The scrapings, the spatula that she did to scrape off the items of clothing, put the debris in a glassine bag, but she mixed up the scrapings between the t-shirt and the sweatshirt. So now we can't identify what came from what. And we also learned in the last trial when she received the t-shirts, they were both in the same bag. So we don't have a good, isolated sample when it comes to the upper clothing, the t-shirt and the sweatshirt. You can't distinguish what came from what because no care was taken to keep that separate. So that has the potential to be important. Also, with the evidence processing, collection, chain of custody, etc. She testified in the last trial that the items she personally collected at the Canton Sally port, she took with her back to the lab. But the other items, particularly the clothing items that were submitted, they were sent on March 14th. And that's basically when the chain of custody starts for those items. So we already heard Mr. Jackson kind of hinting at that previously with Trooper Buchanan, Sergeant Buchanan. And Buchanan was like, it's fine. They were in the Norfolk County DA's office. What's the problem? Well, not secure. Who knows where they are? Who knows what condition they're in? Who knows what they're being exposed to? That's the problem. That's why you have security and a chain of custody. So all those things I think are likely to come out. There was one additional fact that I found though. I'm like, this never went anywhere in the first trial. There was zero follow-up to this as far as I remember. But I do wonder if Mr. Alessi is going to have something to say about this, being a man who does his homework and looks into things. When Maureen Hartnett swabbed the right arm of the sweatshirt, John's sweatshirt, she swabbed the holes, the areas around the holes. She took 2 swabs, and the purpose of that was to be able to submit that for DNA testing. And what she found in those swabs was what was called keratinized tissue. She called it keratinized tissue and DNA. She had no idea what the source of it was. That's really all that was ever said about this subject. Just a very quick drop on cross-examination, keratinized tissue and DNA. She doesn't know the source. So I looked into this. What is keratinized tissue anyway? Where is it? Guys, it's gum tissue. It's gum tissue. It's the tissue that protects, kind of holds your teeth into your gums. It's gum tissue is what keratinized tissue is. So this was the armholes, all this was sort of a big deal in trial one. They did the DNA testing, and remember, they didn't find any dog DNA, but what did they find? They found pig DNA. They found pig DNA. And then the proctor jokes were legion. They proliferated. And it was really funny. They found dog DNA or pig DNA, no dog DNA. But guys, there's gum tissue. There's gum tissue. So, I mean, I was able to, I was able to find this out. Okay, I will grant it's not like the only place on the body where you're going to find this specific tissue, but it's probably like it's the first thing that comes up. It's the first thing you look for. It's most common. It's gum tissue, guys. So if I could find that out, Mr. Alessi has found that out. And, we already know we're waiting for the defense case. We know they have so many other experts. They have another pathologist. They have, other experts, other medical folks. Have they followed up on that keratinized tissue that comes from gums? Oh yes, and dogs have it too, guys. I even read one of the first things that comes up when I look at keratinized tissue is some study where they're looking at because it's shows up with implants, with dental implants, and so they do a bunch of experiments on dogs to kind of test the implants and the healing and different techniques and stuff like that, and they are evaluating the keratinized tissue in the dog's mouth. So it's right there. It's right there. That's a good fact for the defense. Oh, there's some gum tissue. Gum tissue of the type that dogs also have, along with some pig DNA is what they find on these holes in the arm. Couldn't make it up. It was just dropped there, never followed up on in the first trial, never went anywhere as far as I remember. Just keratinized tissue, and then it was gone. Looking through my notes, I see that. Oh, let's check that out. Who'd have known? It's been there the whole time. Gum tissue. So I have to expect that Mr. Alessi has figured that one out. He's on to that. Going to follow up on that. And then the rest of the stains, both just to elaborate on how much blood we're talking about, where the blood belongs and where it doesn't, just to start the jury thinking about these types of things. What is blood doing on the top of his shoe? And then also foreshadowing, because we know from Andre Porto, I think his name was, the DNA expert. He's the one that went in and did all of the DNA analysis for all of these different items. And there are mixed multiple contributors to some of these samples. So that's going to be foreshadowed. That is coming down the road. So those are the basic facts Mr. Alessi has to work with. Those are his weapons. There's some good ones. There may be others. He discovered the reflection. Reflection didn't get brought out in the first trial. Mr. Alessi apparently found that one on his own. And that was a good one. And that damaged her. That damaged her credibility. Honestly, I don't know if the reflection, the fact that she misidentified the reflection in the photo, damaged her as much as her trying to talk her way out of it did. Well, I'm not sure what that is. I can't, looks like sometimes I use the same letter multiple times. I might mark the same thing, but it's a reverse. How often do you use reverse letters to mark your stuff? The trying to escape the inevitable, I think, is what hurt her more than anything else. If she had just, laughed it off, acknowledged, oh my gosh, look at that. How funny, ridiculous. It's a bad photo. here this whole time. I thought it was 2 separate markers, but you're right. It's just a reflection on the tailgate. It's not ideal, but it's way better than digging in and trying to pretend that this is something that it's not. That it's not what we can plainly see with our own eyeballs. It clearly is. Oh, herder. And so a lot of this stuff, yeah, it's good facts, but also I'm just intrigued to see how does it land? How does it land? Does he have more tricks up his sleeve? The way he walked her into asking for the side-by-side photos that he already had that prepared, guys. There's a reason why those are the 2 photos he showed her to identify. He had picked them out. He already planned to do that. And he got her to ask for it. Ask for it. Oh, man. Just makes it so much more effective. Why, yes, if that would be helpful. That's the beauty of his method. Using the experts' own words, their own findings, their own observations, taking those and turning them into your case. Using it for your case, making this expert your expert. That's the beauty of it. You get to stay on that high ground. Yes, we're just here to help you. I'd be happy to help you. You'd find that helpful. Looking at the side by side, that's remarkable because I think that would be helpful too. So let's go ahead and take a look at it. Already planned to go there. So this is not easy stuff to do. Maureen Hartnett, I mean, I don't know how many times she's testified, but dozens easily. These lab witnesses, it's fairly routine for them. I do it a lot. They're very practiced. She might not be, the sharpest analyst that they have over there at the crime lab, but she's not a dummy. She had to go through college. She had to, do the training. She knows some basic scientific stuff, even though she doesn't know what's on the underside of a car. Interestingly, she did know more about what's on the underside of a car in the first trial. Bring that up. She mentioned the drive shaft and the transmission. Those things are both under there. Drive shaft is probably what's going to be most in your face. Like if you're right under the middle of the car. It's if you avoid the differential, but she's not an idiot. Definitely not an idiot. But she's not the most, intimidating expert he's ever come across. So with his skill, I expect she's going to be a pretty easy target. So I can't, I'm excited. I can't wait to see. I know what you have to land. I know what's in your toolbox, but I want to see how you do it. Are you going to be able to showboat a little bit? He showboated a little bit yesterday with that side by side, and it was fun. We enjoyed it. I want to see if he's going to be able to showboat with any of this stuff. Guys, that keratinized tissue. Couldn't believe when I saw that. Couldn't believe it. You couldn't make this up. You couldn't make it up. It's gum tissue. They have gum tissue right there on John's sleeve. Where did that come from? How did the taillight do that? No. Come on, guys. Come on. So, looks like they're getting a little bit of a late start today. Not the nice timely beginning to court that Judge Bev has treated us to so far this week. Not sure if there's guys, has there been anything else that's come out? Anything else that's come out over the last few hours about the case? We went over that video of her calling him an asshole. Not convinced it's him, but I definitely agree. I heard that. I heard asshole. don't think there was anything else real interesting that I saw in the commentary. What do you guys think? Oh, the ripped pocket, guys. Somebody left a comment on yesterday's video that I saw. I do like to, by the way, go through and try to, I can't always read everything, but I do like to scan the comments at the least. But it sometimes just, gets a little bit overwhelming if there's a lot of stuff. But anyway, I did happen to see this one yesterday. I want to see if I can find it because it was very good. It's dealing with the pocket. Because we've been kind of talking about this ripped pocket and what could that be from, and could that be trying to get the phone out, or what is it? And somebody mentioned in the chat yesterday, it's not uncommon for first responders to cut open the pocket to be able to retrieve the wallet. And so we thought, okay, that's possibly an explanation for it. But then remember that CF McCarthy's video? Isn't he sticking his phone in and out of that pocket? And apparently this person went and checked.
Was now opening 18.
You are unmuted.
I was told council wanted to see me.
Of
Okay.
course we'll have a sidebar. Why I don't have to finish my comments as soon as they start court. So this comment, anyway, person indicated, went back and looked at the CF McCarthy's video, and he's putting his phone in the other pocket. Whereas his jeans have that kind of wear pattern. You stick your, like we were saying, like, surely this is a creature of habit type of thing. People tend to stick the same thing in the same pocket. And hadn't occurred to me, but great point. Yeah, you stick your wallet in the same pocket all the time, you might create a wear pattern. Because you're sitting on it, it's rubbing, and it's probably not filling up your entire pocket. It's just a part of it. And so that pocket apparently shows a wear pattern. And the user also zoomed in on the photo that was in evidence of the little bit of, the tear, the back of the jeans, where you can see a little bit of the tear, not so much as when the pants were held up, but you can see it. Examined it. Very convinced it is a cut and not a tear. And I have to agree. I mean, I haven't gone back and looked at it myself, but I definitely agree. Like, I would think visually that's going to be a very obvious difference. You're going to really be able to tell, is this a slice? Is this something that was done with a sharp object versus this was torn? Because I mean, we've all torn our jeans, I'm sure. Some people do it on purpose, very fashionable. And it frays. I mean, that's the whole point. It frays. There's loose thread. It's a very, thick thread that's used in denim. And so it's very obvious when it frays, and it comes apart pretty easily. You're going to see those severed ends. It's just very, very clear when it's a tear, versus if it's a cut. It's just going to be a lot smoother. So I thought that was somebody followed up, man. Somebody went to the source, looked at it, and gave us some information. And so if that's the case, I think I'm now buying this explanation. That's what it's about. The EMTs just cut it to get the wallet out. Makes sense. And that's part of why I appreciate the chat so much, because you guys have all this knowledge. You guys know EMTs. You guys are EMTs. You guys know how this stuff works. You have all this different information that you can share, and it just helps us interpret what it is that we're seeing. So I really, really value that. Hey, Rob is in the chat. What's up, Rob? Good to see you this morning. I'm going to pull him up. Law and Lumber. By the way, it'd be legal malpractice not to renew your motion to recuse, even just for preservation of the record. Imagine that'll be sidebar this AM. Well, if she's the one that called him an asshole, you're going to have to bring that up. Yeah, I think you'd have to bring that up. If she is the one, I don't know if she was. I buy that it could have been the girl at the prosecutor's table. ADA McLaughlin. It didn't necessarily sound like it was coming from the same place as Judge Bev's voice was coming from. And you just hear it on the mic, it's weird how that works. It's very hard to describe, but like sometimes you just hear things come in from different sides and with different tone. Like some mics have more like air space in them. I'm not an audio person, so I don't even really know like the words to use to describe what I'm talking about. But you can just kind of hear it's a different mic, it's a different location. I'm not convinced it was Bev's mic, but if you
All
think
right, so
it
the door,
was,
please.
yeah, you probably need to raise that. Probably going to be pretty important to make that record. So remember, guys, at this point, there's been no motion to recuse since before the first trial. So if they think that there's evidence of Judge Bev being biased, any point between before the last trial and now, they have to raise it. They got to make an issue of it. They got to make a record of it. They got to ask for a remedy and then see if they get it. That's the only way you're going to preserve any of that, to be able to potentially raise it as an appeal issue. That she should have recused herself. She had a conflict. She showed an appearance of impropriety. You got to make that record. If you don't raise it first in the trial court, you waive it for purposes of appeal. So that's what Rob was talking about there as far as preserving the record. Yeah, you need to make a record. Very important step to make sure that you have given the trial court the opportunity to fix its own mistakes. If you don't do that, then the Court of Appeals tends to look at you and go, well, that's a nice sandbagging effort on you, but you could have raised that at the time. And if you had done that, perhaps it would have been fixed at the time. So they're not going to reward people for sitting on issues and then keeping them in the back pocket for appeal. Nearly everything has to be first presented in the trial court. So they want to raise anything having to do with bias since the first time they asked her to recuse herself way before the first trial. They're going to have to ask again, and they're going to have to show their new justification if they want to make that an issue. I really don't know if they do or not at this point. I mean, the fact that they haven't kind of suggests that they've dropped it. They're dealing with the situation they have. They've found their way to cope. They worked it out. I mean, even Mr. Jackson, who she seems to, particularly have some antagonism against. Although, actually, I don't know, Mr. Yannetti, she really does seem to hate Mr. Yannetti. She really does seem to not like him. He's the one, she accused of playing to the cameras over there in the first trial. Remember, address your argument to me, Mr. Yannetti. I'm the one you have to convince. Not that court of public opinion over there. But even Mr. Jackson, they figured out how to work around it. They see what she wants and how she wants it done. And when he does it that way, she helps him out. So not clear to me that they are really pursuing that. And I mean, I understand it's a extremely difficult burden to meet from an appellate standpoint. For all intents and purposes, you have to show actual bias, because that's what would make the error harmful. If she just looks bad, but it doesn't have any effect, they're not going to do anything about it. So you pretty much have to show actual bias if you're going to get any kind of relief like that on appeal, and that's extremely difficult. Extremely difficult. Talked about that before. You're typically, showing an extremely close and intimate relationship with one of the parties, one of the participants. You're showing a financial interest in the trial. It's very unlikely they have any of that. And so one possibility here, this is strategic. They have made the decision that they're very unlikely to be able to meet that burden on appeal. And given that, is it really serving us to continue raising it in the trial court? Or does that maybe just run the risk of pissing her off even more and making it even harder? Making it even harder to deal with her on a day-to-day basis. You don't want to make your Your ultimate task here, your primary goal is win this trial. I mean, when the trial takes precedence over preserving the record for appeal, preserving the record for appeal is your backup plan if you
You are
don't
unmuted.
win the trial. Goal number one is win the trial. So sometimes you have to choose between what's going to help me do that and what's gonna solidify my backup position if I don't. They could have just decided, hey, it's going to make it too hard for us to win this trial if she's constantly in our way because we pissed her off, pointing out her bias, over and over again.
Yay. All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Good morning again, counsel. Good morning again, Ms. Reed. Good morning, jurors. We thank you for your patience. Once again, we worked out something here this morning rather than having you watch us over at Sidebar. So we appreciate your patience. I do have to ask you those questions. Were you able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone said no or shook their heads. Thank you. May we have Ms. Hartnett, please?
I'll remind you, you're still in the room.
Yes. Good morning. Good morning.
How are you this morning, Ms. Hartnett?
Go right ahead, Mr. Alessi.
Thank you, Your Honor. Good morning, Ms. Hartnett, and welcome back this morning.
Good morning.
Welcome back.
Your
Enjoy
Honor,
your time
if I
with us
could
today.
please have Exhibit 145 that is in evidence
Okay.
published.
Yes.
Mr. Wolk?
145.
Ms. Hartnett, you will recall discussion about the taillight from the Lexus that was discussed on both direct and cross-examination yesterday.
Yes.
And you recall the discussion with regard to the weather that was in existence on or about January 29th. I'm not going to go into it at all. I just want to sort of refresh and reorient to where we were on that topic. You recall that?
Yes.
And I am now going to reference specifically what you referred to yesterday, I believe, as the inner part of the taillight, sometimes the inside of the taillight. Do I have that parlance correctly?
Yes, that's correct.
Thank you. So my question is, did you find any sand or salt
Road
or
grime
any other debris
of any
in the
type?
inside portion of that taillight?
No, I did not.
Now, and you can take that down. Thank you, Mr. Wolf.
No road grime.
You recall discussion about shards of taillight? Do you recall that discussion at all in your testimony?
No, I'm sorry, I do not.
Okay. I wasn't certain whether we had that parlance. So my question is, to your knowledge, was there any testing of any taillight alleged to have been found at 34 Fairview for biological material?
No, there was not.
Didn't even look. Didn't even look for blood on the taillight.
And could you just please state what your definition is inclusion when you refer to biological material?
Those items were not processed in the criminalistics unit for any type of biological, meaning they would not tested for blood, semen, saliva, or a skin cell collection.
I'm sorry, I missed the last part that you.
Or a skin cell collection.
Or a skin cell.
Now turning and changing topics. There was a T-shirt and a hoodie of the decedent. Do you recall that?
Yes, I do.
And are you okay with my parlance of T-shirt, the yellow or orange T-shirt on the one hand, and then the gray hoodie sweatshirt? Is that an acceptable parlance for you?
Yes.
So with regard to those two items, if I could, Your Honor, have published what is already in evidence, Exhibit 151 and 150, and Mr. Wolk, if we could please put those side by side.
Now let's do another side by side. Let's look at where the blood is on both of these items.
Already, so is it correct that what's on the left is the right sleeve of what we refer to as the hoodie, and on the right is what color would you like to call that T-shirt?
Orange, please.
All right, so the orange
Orange,
T-shirt.
please.
Is that what we're looking at up on the screen?
Yes, so it's the right sleeve of the gray hoodie and the back of the orange T-shirt.
Thank you. Am I correct that you included a handwritten note on your report that you found, quote, debris from each of these two items, or from these two items collectively?
I don't handwrite notes on my report, so I'm just confused about where you're asking that.
Okay, I'll ask a different question. Hopefully it will be clear. Did you find debris on either of those two items of clothing?
Yes, I performed a debris collection on each of those items and combined them.
I'm sorry, it's not your fault, it's mine. There's a HVAC noise I can't hear. If you
So
could
can we
speak up
turn the
just a
air
little.
conditioning off, please?
I'm okay
I
with
can
it.
speak
It's
up.
just
I'm
if you could
sorry.
speak up a little. I don't want to
Of course.
discomfort people. Can you move the mic?
Yes, I can speak up. My
If you could
apologies.
speak a little louder, that'd be great. Thank you.
Yes.
Can you repeat your answer, please?
Can you repeat the question? I apologize.
Sure. Did you find debris on these articles of clothing?
Yes, I took scrapings from each of these items of clothing and combined the debris. Yes.
Combined the debris. So we don't know which of the items the debris came from.
With regard to scrapings, can you describe how the term scrapings relates to these two items these two items that are on the screen?
Yes. Scraping is the mechanism I use to remove any debris that was remaining on both the sweatshirt and the T-shirt. I held each up over my lab bench. I took a long metal spatula and scraped any debris that was on these items into a small glassine packet.
Is it correct that you do not know where the debris came from specifically, other than it came from one or both items of both of these two items?
Yes, that's correct.
So the debris could be from just the hoodie, it could be just from the T-shirt, or it could be a combination of the both?
Yes, the items were packaged together, so they were already commingled. So there was no way for me to determine which debris came from which item, and it would be misleading to label them as such. So I combined them.
Exactly where my next point was going to go to. Thank you. And
Thank
my
you.
next questions. So what, if anything, were these two items contained in when you got them?
They were contained in a brown paper bag and they may have been contained in a larger box, but I don't remember off the top of my head.
So when you got them and you saw them for the first time, using your term, they were commingled together, correct?
Commingled.
Yes, that's correct.
And was there any debris in the bottom of the bag?
There may have been. When I examine something on my bench, I also shake out the bag to ensure that nothing is left behind and that everything is examined and accounted for.
Now, am I also correct that there is no description of the actual debris that you found? For example, you didn't specify whether it was little fibers, little hair, little pieces of this or that. Do I have that correct?
Correct. I did not do any examination. I just packaged it.
And therefore, you didn't note whether any of the debris was a plastic or a plasticine nature, correct?
Correct. That would not be part of my analysis.
And there was no marker put on any part of the debris that was recovered. Is that also correct?
I labeled the debris with an item number. I'm not sure what you mean by marker, if that's what you mean.
Parts of debris, in other words, there wasn't separate identification or markers for separate pieces of debris.
No, I did not separate out the debris.
There was no photograph taken of the debris?
Not by me, no.
Do you have knowledge of whether there was a photograph taken of the debris by anybody?
I do not.
So you have, as you sit here today, you have no knowledge that there's a photograph of the debris.
That's correct. I do not.
When you received the hoodie and the T-shirt that's depicted as 150 and 151, they came in together, commingled with some debris at the bottom in an evidence bag. Is that correct?
I'm not sure if there was debris at the bottom of the bag. What I can say is that there was debris on the items and I did shake out the bag. I don't have a memory of anything coming out of the bag. I don't know.
So there could have been debris at the bottom of the bag when you shook it out. You just don't recall.
Yes, correct.
If we could, Your Honor, please have Exhibit 154 already in evidence published.
This is from yesterday. This is one of the
Let's keep it there
stipulated
for a
ones.
moment, and then I'm going to ask Mr. Wolk for you to zoom in. Ms. Hartnett, do you recognize this
Evidence
generally,
bag.
and then I'm going to have it zoom in so you can read it, as an evidence bag?
Yes.
Now, Mr. Wolk, could you please zoom in, starting from the top, so that Ms. Hartnett can fairly read this? And if you could, Ms. Hartnett, just take a moment to read it, and then I'm going to ask you some questions, but I want you to have a fair opportunity to read it. Let me know when you're done.
Okay.
And if we can then scroll down, Mr. Wolk, so that Ms. Hartnett can fairly read the rest of what's on there.
Okay.
Thank you. Now, Mr. Wolk, if you could just leave it where it is now. With Your Honor's permission, I don't see a need to keep the lights off, can have that on, but if
That's
Ms.
great.
Hartnett
Lights
needs
on,
it,
please.
you'll just let us know. So is this the evidence bag that the T-shirt and the hoodie were in when you received those items?
To the best of my recollection, yes.
You see the name of collected by someone there. Can you read who that states it was collected by?
Yes.
And state what that is.
It says TPR Proctor.
And are you able to conclude what the TPR stands for?
Generally, we use that to abbreviate trooper.
Right. So that is former Trooper Proctor that it says
Former
collected by, correct?
Trooper Proctor.
That is what's written on the bag, yes.
And the date of the collection, if we can just, Mr. Wolk, just focus in on that. Thank you. The date of the collection is January 29th, 2022, correct?
Yes, that's correct.
Is it a fair conclusion from this evidence bag and your experience on the matter to conclude that former Trooper Proctor was the person who collected the evidence and put it in the bag?
I have no knowledge of who actually collected and put in the bag. I can only read what I see on the monitor.
In terms of, and if we could, Mr. Wolf, please take that down and put back up the side-to-side images and depictions of the T-shirt and the hoodie. Do you know the journey, if you will, of those two items before you received them?
No, I do not.
The debris that you ultimately saw on the hoodie and the T-shirt, and that which may or may not have also been additionally in the bag, do you know where that debris would have been picked up from?
No, I don't know the source of the debris.
And you were not provided with information as to the potential source of that debris, correct?
No.
I got an idea.
Were you aware of whether or not the debris, whether those items had been on the floor of an ambulance or a floor of a hospital?
No, I do not have
What
any
about the floor of a
information
Sally
like
port?
that.
After somebody's gone a little cracky on a piece of tail
Is
light?
it important to maintain the sanitary condition of evidence generally to avoid contamination?
We do our best to avoid contamination once we receive items into evidence, yes.
And what are some of the protocols that are used to avoid contamination of evidence generally?
Generally, wearing gloves, putting items in packaging, bleaching any materials or utensils that we're going to use, or using disposable materials, sterile materials when possible or necessary. We also wear lab coats when processing evidence.
Is another protocol or technique to separate out pieces of evidence to prevent cross-contamination?
Sometimes we will separate pieces of evidence. If the items are already mixed in with each other, then the items are kept together, can be kept together.
Do you know the chain of custody of either the hoodie or the T-shirt?
I only have record of the chain of custody from when it was delivered to the lab.
So before any delivery to the lab, you do not have knowledge of the chain of custody of either of those two items?
No, I just know which detective unit dropped the items off.
And which detective unit was that?
Norfolk Detective Unit.
What I would like to now do is to, we can now take that down. Thank you, Mr. Wolf. I want to sort of speciate, if you will, separate out the evidence
The vocab on this
that
man.
you have talked about so far.
The parlance.
So that it's clear what you submitted and what may have been submitted by others to the lab. Do you understand that concept generally?
Yes.
Thank you. So what I'm going to do is to give categories, and if you would be kind enough to say, I submitted it by some other person, that would be helpful. Any items that were collected from the vehicle, who submitted those to the lab or brought them to the lab?
I did.
The swabs from the red Solo cups.
I submitted the swabs.
The drinking glass that you were presented with at Canton PD.
I submitted that item.
The two clothing items that we just saw on the screen, the hoodie and the t-shirt?
Those were submitted by the Norfolk Detective Unit.
Were there also any fingernails that were part of the investigation and that you had knowledge of?
Yes.
Describe what those were, please.
Fingernails may be collected at the medical examiner's office, and they're clippings from the top of the fingernails of the victim.
And were those submitted to the lab?
Yes,
And by whom?
by the Norfolk Detective Unit.
And the phrase known blood standards, are you familiar with that phrase?
Yes.
Can you tell the jurors, please, what that means?
A known blood standard is a sample of blood that is collected from an identified person.
And which person were those known blood standards related to your knowledge in this matter?
We received a tube of blood that was identified as belonging to John O'Keefe.
And with regard to the fingernails and the known blood standards, who submitted those to the lab?
The Norfolk County Detective Unit.
So am I correct to conclude that for those items that you submitted to the lab, you knew sort of their journey, if you will, but that those items that were submitted by, I think you referred to as Norfolk County, was your parlance?
Yes, correct.
You don't have knowledge about those other than that they were submitted by them?
Prior to them arriving at the lab, correct. I have no knowledge of what occurred, where they were stored or anything like that before that.
And no knowledge of those items not submitted by you would include no knowledge of the chain of custody of those items, correct?
No knowledge prior to them being received into the lab. That is correct.
Your Honor, if I may have a moment, please, it'll
Okay.
probably be 30 to 45 seconds. Thank you. Bear with me, please.
Is that it? Oh, thought we might get a keratinized tissue bomb.
So the questions I have for Ms. Hartnett at this time, thank you for answering my questions, Ms. Hartnett.
Thank you.
Interesting.
All right, Mr. Brennan, any redirect?
Yes.
Nothing about the blood on the shoe either. I don't like that. I want the blood on the shoe. That's very important to me. Me. This is about me, guys.
You mentioned that you had an opportunity to observe a paper bag that had red Solo cups in it,
Yes, that's correct.
and the red Solo cups had a coloring of red in the cups.
Yes.
You'd never seen blood preserved in cups like that before?
Objection, Your Honor.
To the form, sustained.
Had you ever seen blood stored in cups
Bleeding,
like that
getting called
before?
out.
No.
Do you know the circumstances of storing that blood?
Can you rephrase that question, please?
When the blood was stored in the cups, do you know the circumstances?
Sorry, Mr. Brennan.
It's the same question.
Can we have a sidebar, please? It's important.
Okay,
You know the circumstances. Alessi's objecting because that would call for hearsay. She doesn't know. She doesn't know the circumstances of it, the snowblower and the scooping it into the cups and the having to hunt down the Stop and Shop bag because of the snow. That would have to be told to her. So it would be hearsay. He could present it as like a hypothetical. Would this excuse or make sense as a collection method if hypothetically we're in the middle of a storm and they found it on top of the snow, and for whatever reason Gallagher decided 15 minutes to go to PPD to get evidence collection kits would be too long.
The coloring in those cups, do you know firsthand what that comprised of, what the item was?
Are you asking me if I knew what the contents specifically of the cup
Yes.
were? No, I do not.
And so the red cups with the red spots stored in them, do you know the circumstances surrounding the effort made to try to preserve that evidence?
Can you just be more specific in what you mean by circumstances?
Sure. Do you know where those red cups came from?
I was told they were collected from the scene. I don't have firsthand
Told.
knowledge of the
There it
collection.
is.
And you weren't at the scene that morning, were you?
No, I was not.
Do you know that what the circumstances or the challenges were that morning?
No, I'm not aware.
You said that you respond to active scenes and sometimes, like in this case, after the event happens?
Yes, that's correct.
Is there a difference when you're at an active scene as opposed to when you arrive at a scene that is past the event?
I would say multiple units are working at the same time, attempting to document, preserve, and collect evidence.
You were asked a few questions about the top back of the Lexus SUV.
Yes, that's correct.
When you were first asked the question, you were asked if you had studied that area, and you said you didn't recall if you looked at that area.
I did look at the area. I looked over the entire vehicle, but I didn't know anything specific in that area, no.
When you say you looked over the entire vehicle, did you look over the back of the vehicle as well?
Yes, the only part I did not look at was the roof of the vehicle.
Did you study all sides equally? Did you spend time with the entire vehicle?
I believe I made an effort, yes, to look at the entire vehicle.
Really got to know each other.
When you studied the back of the vehicle, not the right side or left side, the back middle, did you find any hair?
I did not note any hair, no.
Did you find any scratches?
The only scratches I noted were ones that I had spoken of previously on the right.
When you looked at the left side of that Lexus, did you find any dents or scratches?
Nothing that I noted, no.
Did you find any hair on that side of the car?
Not that I noted, no.
Did you find any dents, scratches, or hair anywhere but on other than the right side quarter of that Lexus?
I did not note any. I also did not examine the interior of the vehicle.
You said that you removed the hair. What do you do after you remove the hair?
The hair is placed into a small glassine envelope, then placed into a larger manila envelope, and then I signed and sealed it, gave it the appropriate case number and item number, and then secured it in our storage room.
Can that hair be further tested?
Yes.
Is that something you would do or a different person?
I don't perform testing on the hair. I performed a microscopic examination of it, and then additional testing can be performed by a different unit.
Let me ask you some questions about where you found the hair. You saw the two different angle pictures yesterday that you described.
Yes, I saw 2 pictures of that hair yesterday.
You were also shown some video where the car had snow and ice on it. Is water a conduit? Does water
A conduit?
ever act as
For
an
what?
adhesive?
Objection, Your Honor.
Watch the form of the question.
Okay. Why don't I show you a similar video that you were shown yesterday, but we've clarified it so it's more clear. I'm going to actually
Oh,
take a look at video
Clarified
125.
video. This is more clear, huh? You sure about that?
Can we stop that, please? And can you see that's 5:51:54 p.m. on 1/29/22?
Yes.
When you first saw this vehicle, it didn't have that snow on the right back near that taillight, did it?
Objection, Your Honor.
Ask it differently, Mr. Brennan.
When you saw this vehicle for the first time, did it have that snow packed into the back right of the car?
No, to the best of my recollection, there was no snow on the vehicle when I saw it.
And the hair where you found it, you see the red back taillight, the piece of red that's showing?
I do see that, yes.
In reference or relative to that red, was the hair to the right, left, below?
I don't recall at this time.
Okay. Do you see the ice or snow on the right side quarter panel of that Lexus?
I don't see it on the quarter panel. I'm not sure what you're speaking of.
If we could move that video forward, please, to 702. And then to 749, please. Stop. Go forward just a little bit, please. Stop. Okay. There's still remnants of snow. Did it look like that when you first saw it?
No, I believe I did not see any snow on the vehicle when I saw it.
If you could fast forward, please.
He's going to show this again. Snow falling off the car. He's trying to say no snow fell off the car where the hair was. That makes it more logical
Thank
that
you.
it survived a blizzard.
You can take that down. Thank you. You were asked if you had any information about when damage occurred,
Yes, that's correct.
and you offered us you don't have no idea, right?
Objection, Your Honor.
I'll allow that.
No, I do not know when the damage occurred.
You were asked whether or not damage existed on that car prior to that day, prior to January 29, 2022. You remember that question?
Yes.
Did you know there are ring videos of that car from January 28, 2022?
No.
I want to show you some photos and ask you a few questions. If we could have 147C, please. If you could close up. Do you remember what that's a picture of or a photograph of?
Yes.
What is it?
That is a tear that was on the right sleeve of the gray sweatshirt.
The threads coming from the side of that hole.
Yes.
Those threads, could you pull those threads and pull them out by hand if you wanted to?
Can you repeat that question?
If you pulled on those threads, could you pull thread from that hole if you wanted to?
Objection, Your Honor.
I'll allow that.
I don't know. I didn't attempt to pull at them at all.
Did you examine them to see if they were woven or loose, those threads?
Yes.
Okay, and what were they?
They were loose. The fibers had started to separate up from the shirt. Separate and weave. I don't want to say they were separated from the shirt completely. The weave was starting to separate.
If we could have photograph 57. '57, 57.
5-7. Defense is definitely winning the tech battle.
Are those the red cups that you saw?
Yes.
And what color is the fluid inside?
I noted there was red-brown stains inside.
Okay.
Thank you,
Did you
English
see that
Kate.
white object, the
The
rag
distinctions
or
that
the
matter.
paper towel?
Objection, Your Honor. Go.
Yes, sustained.
Well, you were asked about, you can take that down. You were asked about who had custody of items. You only have custody of items once you receive them, right?
Yes, that's correct.
If somebody had access to that rag and dipped it in those cups and then smeared it on the taillight, and you went and tested, would you potentially be able to find that red liquid on the taillight?
Objection, Your Honor.
It's sustained.
If strands of cloth were pulled from those clothing and placed in the taillight area, would you know when they were placed?
Objection, Your Honor.
Sustained.
When you get to a scene and you examine an area, if you don't see it firsthand, is there any way you can date when items are placed on an object?
I'm sorry, can you
Sometimes.
ask that one more time, please?
Sure. When you look at an area like a taillight, if you found blood or cloth or another item in that area, would you know when it was placed in that area?
Objection, Your Honor.
I'll allow that.
I think there are really just too many variables to say either way.
And if an item like blood or cloth was placed in that area, is that something you would be looking for in your examination?
In which area?
Say the taillight, for example.
If there was an object placed in the taillight, would I be looking for that? I would be looking for any item evidence. I'm not specifically looking for anything. I'm just looking for anything that would potentially be evidence.
She's so confused.
Thank you. I have no further questions.
Anything further, Mr. Alessi?
Briefly, Your Honor.
Ah.
If we could, Your Honor, have 147C republished.
Let's look at that hole again. Why not? He did not bring it up. That's why he objected to scope, and that was sustained by Judge Cannoni. He was I mean, I don't know if he was allowed,
Would it be
but
acceptable to move it along if Ms. Gil, oh, you have it? Okay.
But he did
If we
state
could
it.
have Ms. Gilman, I have just
Scope.
one question, Your Honor.
beyond the scope of
Thank
the
you very much, Ms.
cross.
Gilman.
I-
147C, I believe it.
Okay, I think you already had it up there.
No, it's this one. Yeah,
Okay.
exactly. Thank you, Your Honor. Do you recall Mr. Brennan asking you just moments ago a question about this depiction?
Yes,
And to be clear, this is the right sleeve of the gray hoodie, correct?
yes, that's correct.
You didn't perform any analysis of this area of the right hoodie, did you?
I performed damage analysis on each of those tears on the sleeve.
Right, but you didn't perform an analysis as to the source of that item, what it could be, correct?
Can you rephrase that question, please?
Sure. You didn't do any analysis of what could have caused that hole in the sweatshirt, did you?
No, I did not.
No further questions. Again, thank you for answering my question.
All right, Ms. Hartnett, you are all set.
I wanted to correct something from the record yesterday. I wasn't sure when was appropriate to do that.
Okay, do you recall which lawyer asked you the question?
Yes, Mr. Alessi asked me the question.
Your Honor, are we going to proceed along with that?
So why don't I see you outside?
Thank you.
That's awkward. Want to correct something from yesterday? Don't know what. Don't know if it matters. Weird for the jury to hear that. But I guess it happens. Well, nothing about the bloodstain pattern, nothing about the blood on the sneaker. It didn't get mentioned yesterday. Nothing about the keratinized tissue. Nothing about the failed proficiency exam. I don't care at all about not mentioning the failed proficiency exam. To me, that's it's just kind of nothing, kind of petty. If she was doing a hair root analysis and there was a question about whether she misidentified a hair root, then perhaps you'd bring it up. But just as a general, you were sloppy with this other thing, therefore what? I mean, that's kind of the problem with it. It doesn't obviously lead to
All right, so Ms. Hartnett, I am going to
Here.
let you step down because questions from both sides are completed.
Okay,
So
thank you.
you, though.
never mind. Lots to wonder about that, jury.
Okay, Mr. Brennan, who is your next witness?
Next witness is Dr. Scordi-Bello.
Okay.
May I?
Yes.
Dr. Scordi-Bello. So, rumors that he would not call the medical examiner are now, I don't know, debunked. Calling Dr. Scordi-Bello and her undetermined conclusion as to the manner of death. So maybe he's going to call Proctor too. Rumors were kind of hand in hand.
Why don't I see counsel at sidebar, please?
Not sure what we're seeing her at sidebar about, but hey, I see we have a new buffer zone order out. So I'm not going to look at that right this second, but once we go to recess, maybe we'll pull that up and take a little look. She had been given that deadline, right, by the First Circuit, and it gave me such joy to see them place that responsibility squarely on the side of the court that issued the unlawful order and the prosecutor who had requested it. Show what you are doing to fix this situation with a sort of unstated, implied, or else. Not sure what we are sidebarring about here.
Also should be able to speak to the court and jury in case they're here to the truth, the whole truth, and nothing but the truth, the whole truth.
I did. Good morning, doctor. All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Good morning. Could you please introduce yourself to the jury?
Good morning. My name is Irini Scordi-Bello. That's spelled IRINI-SCORDI-BELLO. I am a medical examiner employed by the Commonwealth of Massachusetts.
How long have you been a medical examiner for?
In the state of Massachusetts since December of 2016. In general, I have been a medical examiner since 2008.
Did you attend medical school?
Yes, I did.
Where did you attend medical school?
I completed medical school in New York City at the Mount Sinai School of Medicine, now known as ICANN School of Medicine.
Did you attend a residency?
Yes, I completed my residency in anatomic pathology at the Mount Sinai Hospital.
Is that what you specialized in during your residency?
Yes.
After your residency, did you go right to the medical examiner's office or did you work anywhere else?
After my residency, I completed a one-year fellowship in forensic pathology that was done at the Office of the Chief Medical Examiner for the City of New York. And then I went to work as a medical examiner.
Is there a certain type of doctor you are? Do you have a particular?
Yes, I am a forensic pathologist.
What are your duties at the medical examiner's office?
My duties and responsibilities at the medical examiner's office include performing examinations and autopsies to determine the cause and manner of death in cases that fall under our jurisdiction.
How many other doctors work with you at the medical examiner's office?
I think there's close to 20 of us. I don't know the exact number.
The medical examiner's office, are you responsible for all counties in Massachusetts as far as doing examinations and autopsies?
No, I work, my primary location is in Westfield, Massachusetts, where one of our satellite offices is, and we cover Worcester County and the entire western part of the state. There's 3 offices in the state, the one in Westfield, the one in Boston, and the office at the Cape, in Cape Cod.
You mentioned that part of what you do is to try to determine manner and cause of death.
Yes.
I use the word autopsy generally without too much detail. Can you describe for the jury what the process is when you're trying to determine the manner and cause of death?
You would like me to explain what an autopsy is?
Please.
An autopsy is a large surgical procedure with 2 main parts. The external examination, which is an examination of the outside of the body, where we document physical characteristics such as hair color, eye color. We document any identifying features such as scars or tattoos, height, weight. And then we also document any signs of disease or any signs of injury on the body. The second part of the autopsy is the internal examination, where we make surgical type incisions on the body and we examine the internal organs of the neck, the chest, the abdomen and the pelvis, as well as the head and the brain. Part of the autopsy procedure, and this depends on the kind of case we're doing an autopsy on, might include other studies such as taking evidence, toxicology, which is done on almost every case, and any additional dissections or any additional steps we might feel we have to take. But that's in general what an autopsy is.
Do you ever seek the assistance of any other doctors or professionals that have specialties in your determination in an autopsy about manner and cause of death?
Yes, absolutely. We often, well, like I mentioned before, we perform toxicology on almost all our cases, and those samples are sent to the toxicology state lab. We also have a board-certified neuropathologist and cardiac pathologist in our office, and very often we will consult with them in determining cause and manner of death.
Are cause of death and manner of death the same or 2 different things?
They're 2 completely different things.
Can you explain to us what the difference is between the 2 of them?
Yes. Cause of death refers to the disease or the injury that initiates a sequence of events that ultimately leads to someone's death. So that disease or that injury can be a natural disease such as atherosclerosis or coronary artery disease, or it can be some sort of injury. The manner of death has to do with the circumstances that led to the death. So there are 5 manners of death that we use in our practice. The most common one is actually natural. Natural means that the person's cause of death, the disease that killed them, was due to natural causes. And that would include heart disease, diabetes, cancer. All those are natural processes that take place in the body that lead to death. And so the manner of death is natural. If trauma or an injury is involved, then we have to decide then let me back up. If trauma or an injury is involved, then the manner of death is no longer natural. And therefore, it could be that the trauma was inflicted in an accidental manner, in which case the manner becomes accident. If it was inflicted by another person with the intent to cause harm, then the manner becomes a homicide. And if the trauma, and when I say trauma, I should include both physical and chemical trauma, chemical when it comes to intoxications due to drugs, etc. If the trauma was self-inflicted, then the manner of death is suicide. So we have natural, accident, homicide, suicide, and then the 5th one is what we call undetermined or could not be determined. That is when the circumstances in a case are not entirely known or clear to us, and the information that we have does not support one manner of death over another. In that case, we classify the manner of death as undetermined.
She was not
When
the
you
Emmy
are
on Birchmore.
conducting an autopsy and making an analysis and attempting to reach a conclusion, you said when you looked at in a case, is your case and what you do different than procedure in a prosecution's case?
Can you repeat the question? I'm not sure I understand.
I can. When you're making your determinations about cause or manner of death, do you have any limitations?
Okay, so the cause of death is something that is determined by the autopsy. That is my opinion or our office opinion as to the disease or injury that led to that person's death. So that is, I don't have any major limitations unless we're dealing with cases where, the body's decomposed and we're not able to do, all the testing necessary. But in most cases, the cause of death depends on my findings during the autopsy. The manner of death, yes, there are limitations because it's circumstance driven. And so the circumstances might not be known to us at the time of the autopsy. They might not be known to us ever. And therefore, while the cause of death is my medical opinion, the manner of death depends on information I get from other people.
Are you always able to reach a conclusion on manner of death?
No, that's why I said that in cases that we cannot, that manner of death is classified as undetermined.
I want to now ask you about whether or not you examined John O'Keefe.
Yes, I did the autopsy on Mr. O'Keefe.
When you examined Mr. O'Keefe, did you work with a team or by yourself?
No, we always work in a team. The team is made up of the medical examiner and a medical examiner's assistant that helps with the actual performance of the autopsy, especially when we examine the head. And then, of course, we work with the toxicology lab and, in this particular case, our neuropathologist.
The medical examiner's office, is that a division of the Massachusetts State Police?
No,
Is it a division of the Norfolk County District Attorney's office?
no,
Is the medical examiner's office independent?
yes.
When you conduct an autopsy, are representatives of law enforcement or district attorney's office able or allowed to attend an autopsy?
Yes, they're usually allowed to attend the autopsy if they wish.
Is that an uncommon practice?
No, it's not uncommon.
Would you remember when your autopsy of Mr. O'Keefe occurred?
Yes, I performed the autopsy on January 31st of 2022.
If you have notes,
Yes, I do.
I think you'd be able to use them, but we'll just want to indicate that you're reading from your notes if that's the case. Thank you.
So you can use your notes, doctor, just.
Thank you.
Thank you, Your Honor. When you began the autopsy of Mr. O'Keefe, do you know who, if any, representatives from the Massachusetts State Police or the Norfolk County District Attorney's Office were present?
I don't remember their names. I do believe there were 2 individuals, and every person who attends an autopsy has to sign a log, and their names would be logged in our records. I don't remember their names.
What is the role of law enforcement relative to the actual physical autopsy? Do they have any role?
No, they're not part of the autopsy. They don't have a role. Their role is to observe. Sometimes they will ask questions, and based on my findings, they might, go on and do their investigation.
Does your office photograph things of interest like injuries on the person that you're doing the autopsy on?
Yes, we do.
Is law enforcement allowed to take their own photographs as well?
Yes.
Did you in fact memorialize your findings in this case?
I did.
Are there a number of different ways in which you memorialize your findings?
Yes.
I'm sorry.
I took notes, physical notes, pen and paper. There's a report that's issued within 90 days of the completion of the autopsy, and then photographs, digital photographs.
You mentioned a report is due in 90 days. Is that often referred to as an autopsy report?
Yes.
Why 90 days?
That is the standard that is set by the National Association of Medical Examiners. We're part of NAME, and therefore we try to have a finalized report for all our cases within 90 days, because we know that families are waiting for these reports, and therefore we do our best to finish a report within 90 days.
Did you in fact complete a so-called autopsy report in this case?
Yes, I did.
In addition to the autopsy report, well, included in the autopsy report, do you make handwritten notations about locations of injuries?
Yes.
And share with us how's that done. Is there a picture or a graph?
There's a diagram, a body diagram that we use to mark the location of injuries.
May I approach, Your Honor?
Yes.
May I?
Yes.
Do you generally recognize what these documents are?
Yes, these are my diagrams from Mr. O'Keefe's autopsy.
And could you just very basically describe each one of them?
Some of them. Yes, the first one is a body diagram. A lot of things have been whited out, but it's the diagram that I would use to make note of any injuries. The second one is a diagram of the face and the skull. I would also use this diagram to make notes as to any injuries on the face. And the third one is a diagram of the inside of the skull, what we call the base of the skull, as well as different views of the brain itself. Again, I would make notes to point out different injuries.
As you are noting injuries in your autopsy report, these diagrams, they start off blank
They start off blank and then they're filled out as we go along.
and you fill out all the details you find important in your report?
Correct.
For reference, and to assist us, I have some blank diagrams that I may ask you to point out things on the blank diagram for us.
Okay.
And Your Honor, I'd ask permission, I've spoken to defense, to use these simply as a chalk.
Sure.
No objection, Your Honor.
Alessi.
Before you begin an
Alessi.
autopsy, do you seek any medical records if available?
Yes. When a case is called into our office, depending on the time and the day that it is called in, our intake department, who are the people initially on the phone taking the information, will start asking for both medical records as well as police reports. So in the morning, when we start the autopsy, it's possible that we have some records. Sometimes if a decedent is brought to us from the hospital, there might be some records that come along with the body. But to answer your question, yes, we always ask for medical records, what we call PCP records, which are primary care physician records, any records from a hospital where the decedent may have been, and investigative reports, police reports.
Do you recall whether you had access to John O'Keefe's medical records from Good Samaritan Hospital?
I did have access, yes, in the day, I believe the day of and the following day.
May I approach, Your Honor?
Yes.
Subject to any later redactions, I would move the Good Samaritan medical records.
No objection, Your Honor.
Exhibit 155.
This time I would move for identification all photos of Mr. O'Keefe's injuries at Good Samaritan Hospital for identification.
Okay.
Exhibit JJ for ID.
Further, this time I'd move for identification all OCME, Office of Medical Examiner photos.
Exhibit KK for ID.
Thank you.
They're probably not going to show us the autopsy photos, guys, on the screen. They didn't last time.
Your Honor, at this time I'd move all CSSS autopsy photos for identification.
May I just have an understanding of the evidence?
With the court's permission, Ms. Gilman, if you could put up the diagram, full body. If you could enlarge that a little more. Thank you very much. Could you explain this to us?
Yes, this is the diagram that we use during every autopsy. As you can see, we note the name of the decedent. Every case has its own number. In this case, it was 22-1697. And then we take note of, as I mentioned, during the external examination, physical characteristics such as hair, eyes, teeth. And then on this diagram, we would note any scars we see on the body, any tattoos we see on the body, any injuries we see on the body, and any therapeutic interventions. Those would be things that are sometimes done either by emergency medical personnel or at the hospital. Everything would be noted on this diagram.
Now, if you could take us through, I'm going to ask you, we'll go body part by body part, if that's okay. I'm going to ask you to begin with Mr. O'Keefe's face, the front of his face. And if you could enlarge that, Ms. Gilman. Thank you very much. Did you notice any injuries on Mr. O'Keefe's face? And if so, could you I think there's a pointer available for you, doctor. If you could
Yes.
point out on the diagram what you observed.
So on the diagram, well, first of all, there was medical intervention on Mr. O'Keefe that included an endotracheal tube that had been placed to help him breathe. But once all the intervention, all the medical devices were removed, I observed on his right upper eyelid a 1 centimeter laceration. So as we're looking at the diagram, this is the right side and this is the left side. So on his right eyelid, there was a small laceration. I also observed abrasions on the anterior and the left aspect of the nose. So the nose would be here on the front and the left aspect. Abrasions are scrapes. Lacerations are tears in the skin. I should probably explain that. Then there was some bleeding and some swelling of the eyelids of both eyes.
Does that complete your analysis?
For the front of the face, correct, yes.
May I approach, Your Honor?
Yes.
Doctor, I'm showing you a photograph. Do you recognize what's in that photograph?
Yes, this is a photograph of Mr. O'Keefe's face.
Does that photograph depict any of the observations or injuries you made that you just described to the jury?
Yes, it shows the small laceration that I noted during the autopsy on the right eyelid. You can see some of the swelling and some of the bleeding over his eyelids. And that's pretty much all I can see because it's a side view.
Is there an apparatus?
There is what we call an endotracheal tube, as well as a C collar or a C stabilization collar. That's something that would have been placed on him by medical personnel.
All right, we'll just get evidence and ask for instruction.
Okay.
Look different, Your Honor.
All right. So, folks, during the testimony of Dr. Scordi-Bello, photos will be introduced to you. They're photographs of John O'Keefe that Dr. Scordi-Bello from the autopsy. So you'll have them in the jury room with you. I'll put them in an envelope, or I'll ask that they be put in an envelope. So if you don't want to look at them now, you don't have to. At some point, we'd ask that you make sure you look at it. These photos are not pleasant, and you may find that they're graphic. But what's important for you to know is that your verdict must not in any way be influenced by the fact that these photographs may be unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence and not based on pity or sympathy for Mr. O'Keefe, which might be occasioned by these photographs. So consider the photographs only as they draw your attention to a clinical, medical status, or to the nature of Mr. O'Keefe's injuries, or to the nature of the incident itself. So they'll be displayed up on the screen for you as well.
The last exhibit is Exhibit 156.
Thank you.
Yeah, they're not going to show us these photos on the screen.
Doctor, can you point out the injuries you were describing by using the diagram, or when you were using the diagram?
So the laceration, the small laceration that I previously described would be here on the right upper eyelid of Mr. O'Keefe. You can see some discoloration that's bleeding under his eyelid and would I would describe as swelling. The endotracheal tube and the neck collar are also present here. And the other injury, which I noted, was on the front and left side of his nose, which you cannot see here because this is looking at the right side of his face.
Take that down, please. You mentioned that there was something about his eyes that was notable.
Yes, there was bleeding or hemorrhage, as we call it, on the eyelids, as well as swelling.
I'm going to ask you more detail about that later, but was that observation important in your ultimate diagnosis or conclusions? Yes. May I approach your honor?
Yes.
I'm showing you another photograph. Do you recognize that?
Yes, this is another picture showing Mr. O'Keefe's face. Again, the medical intervention is present, and you can see more clearly now the discoloration on the upper eyelids.
Is this vantage point helpful for your ultimate conclusions and diagnosis?
Yes.
Your honor, move this in down.
No objection, Your Honor.
Exhibit 157.
With the court's permission, I'd like to show this to the jury.
Yes.
P645, please. Doctor, could you point out what was significant regarding Mr. O'Keefe's eye area?
So I noted that there was discoloration, that's bleeding, that's blood, that's under those eyelids. The eyelids appear puffy, that's what we call edema or swelling. And then also there were two abrasions, two scratches on Mr. O'Keefe's nose. You can see one here and then the other one on the more front part of his nose.
Okay, could you take that down, please? If we could move down a bit to the chest and stomach area, did you make any observations about this area, Dr. Scordi-Bello?
The observations that I made on the chest were that there was, as I mentioned before, there were defibrillator pads on the body, and there was an abrasion that's very commonly seen in people who have undergone resuscitation. Internally, that abrasion and the whole resuscitation apparatus was associated with some anterior rib fractures, which are also seen in cases of resuscitation, but I didn't make any other notes in terms of trauma on the chest or abdomen.
Okay. I'd like to move to the arms and the hands. If we could come down just a little bit. Let's begin with Mr. O'Keefe's hand or hands. Did you make any observations regarding Mr. O'Keefe's hand or hands?
Yeah, did you?
Yes. On his upper right arm, I noted that he had a superficial abrasion. So it would have been, you can
Could we move that down a little bit?
move it
please?
down a little bit. Yeah, thank you. Doesn't seem to be doing a very good job. Okay, somehow doesn't want to.
Sorry if that's not working well.
It's projecting here, but not on the actual picture.
Okay. There may be a second pointer.
I can do it here.
Okay, great.
Yeah. So on the right upper medial arm, that would be the inner side of his arm, there was a superficial abrasion. Again, that's a scrape. Then on his right posterior arm and forearm. So not exactly on this aspect of the arm, but on the back side of the arm, which would be in the back of the diagram, there were multiple abrasions, which I described as ranging from 2 to 3 millimeters and up to 7 centimeters. Then, yeah, if you could move the diagram down, please. Again, there is a back to this diagram. I don't know if you could put that on the screen. There we go. So this is now the right side and this is the left. I noted that there were 2 bruises on the back of his right hand. Also a faint scratch on the back of his left hand. And then moving down to the lower extremities or the legs, if you could please show the front, there was a small abrasion, a small scrape on the side of his right knee.
May I approach your Honor?
Yes.
Dr. I'm handing you a photograph. Do you recognize it from that photograph?
Yes.
What is it?
This is the back of Mr. O'Keefe's right hand, I believe.
Is that fair and accurate depiction of how his hand appeared when you examined him?
Yes.
Will this is evidence, please?
No objection, Your Honor.
Okay.
Exhibit 158.
What's the gaslighting explanation for that going to be from
I'd
the
show
Commonwealth?
P647 to the jury.
I guess we get to see the hand.
And could you explain, you said there were 2 bruises. Could you point those out for us?
Yes. There's one here and one here.
Did you attempt to assess those to determine whether you could conclude or opine on a cause of those?
No, I did not. Well, I take that back. I'm sorry. So this particular one has 2 small little pinpoint defects in the middle, which we sometimes see when emergency personnel tries to get access to a vein for fluids, for intravenous fluids. So, but I did not put that in my report. I just described it as a contusion.
Is it common to see that type of coloration where medical personnel put intravenous or other types
On
of
a dead
support into
person?
somebody's hand?
Yes, it's very common for the skin to bruise when someone tries to get access to a blood vessel.
The
In a
other
dead person, is
coloration
that common?
That is unrelated to those 2 small points.
The heart's
Would
not
you have a
beating?
description of what those are?
No.
I'd also like to show you exhibit number 1. Exhibit number 1, please. Thank you. You use the word superficial. What does that mean?
Superficial means that the abrasion is on the superficial layers of the skin, usually the epidermis and sometimes the dermis, but there's no penetration of the skin.
When you're assessing to determine whether there's any penetration, do you measure the length of the wound?
I don't know. Ask
The
your
abrasion?
mom.
Penetration would be measuring the depth. If there was actual penetration, I would have to measure how deep into the skin. For example, when we assess stab wounds, we have to measure the depth of the wound. In this particular case, you can see that these are scrapes or scratches and there's no exposed underlying fat or muscle. And therefore, to answer your question, I measured their length and gave a range, but I did not measure their depth.
As a routine practice during an autopsy, doctor, if there was penetration or depth, would you, as a routine, measure that?
I would make a note of it.
Indeed, make a note
Are
of
there
the
any
depth
such
of the
notes in any of
penetration.
your autopsy findings or reports about depth?
No, I
Oof.
did not make a note on the depth of these ones.
Do you have an opinion to a reasonable degree of medical certainty as to how those superficial abrasions occurred?
I do not.
And I asked you about the hand, which we just saw, and I should ask you the same question. Do you have an opinion to a reasonable degree of medical certainty how that coloration, aside from the medical intervention, do you have an opinion to a reasonable degree of medical certainty how the other discoloration happened on Mr. O'Keefe's hand?
I can state to a reasonable degree of medical certainty that that's a bruise, a contusion, but I cannot tell you how it occurred.
And to summarize finally what we've been through so far regarding the scrape on Mr. O'Keefe's right eye, can you provide an opinion to a reasonable degree of medical certainty how that scrape occurred?
No, I cannot.
You mentioned for us that when you looked at Mr. O'Keefe's legs, you observed bruising on his, or a small scratch on his right knee.
Correct.
I don't want to summarize it. Can you describe that
Can we turn the
more
lights on,
specifically?
please?
Thank you.
Yes, I described it as a 0.5 centimeter abrasion on the right lateral knee.
Did you see any marks or abrasions on his left knee?
No, I did not.
Was the mark scratch on Mr. O'Keefe's right knee on the inside or the outside of the knee?
It was on the lateral aspect, which would be the outside.
Thank you. May I approach?
Yes.
Doctor, I'm handing you a photograph. Do you recognize what's in that photograph?
Yes,
What is it?
this is a picture of Mr. O'Keefe's lower extremities, his legs.
Is it a fair and accurate depiction of how his knee appeared when you did the autopsy?
Yes.
Don't have to look at the evidence, please. No objection, Your Honor.
Okay.
159.
Thank you.
We heard about
Court
this in the
submission,
last
I'd like to show
trial.
the jury 9467.
Yes.
Don't think we've heard about it in this one, but that is in fact what they did.
You
They went
used
in
the word
through his,
lateral and
like,
you talk
shin
about
bone.
abrasion or a scrape. Could you look at this photograph and could we enlarge it, Ms. Gilman, and could you point out to the jury and explain what it is that you saw?
Yes, you can see the abrasion here with a little bit of adjacent discoloration, but this is what I was describing.
If you could zoom back out, please. And you didn't see any similar type bruising or abrasions on the left knee?
No,
During your autopsy, did you notice any injuries internally to Mr. O'Keefe's rib area?
yes, I did note that there were rib fractures on the anterior, that would be the front, of his 4th and 5th ribs.
And so would that be his left or right side?
It would be both the right and the left, and it would be the part of the rib that is closer to the sternum.
Is there a number of ribs that had fractures or are they connected as one?
Two.
The
She said
fourth
two.
and the
4th and
fifth.
5th.
Both on the
Stop
right
lollying.
and the left, close to the sternum.
Have you, in your experience, seen ribs fractured during first aid or medical intervention?
Very often, yes.
Given your experience and your study of Mr. O'Keefe's body, do you have an opinion to a reasonable degree of medical certainty how those rib fractures were obtained?
I believe those rib fractures were due to resuscitation.
And you have that opinion to a reasonable degree of medical certainty?
Yes.
I'd like to show you a different diagram, one of the head area. If we could enlarge the bottom right. Thank you. Using that diagram, could you assist us, doctor, and explain to us any observations you made about the back of John O'Keefe's head?
Yes. The main observation was a laceration that is a skin tear on the back of Mr. O'Keefe's head to the right of midline. So this was the midline. The laceration was somewhere here, is what we call the right occipital area. And associated with that, there was an abrasion over it that would have been here. So this was what we call a compound injury, an abraded laceration.
We'll turn in a few moments to your autopsy observations about the inside of Mr. O'Keefe's skull. But first, I want to just show you a photograph relative to what you described to us. May I approach, Your Honor?
Yes.
Showing you a photograph. You recognize what's in that photograph?
Yes, this is a picture taken at the time of autopsy. This is the back of Mr. O'Keefe's head. The hair has been shaved off so that the injury can be clearly photographed, and it's a laceration with an associated abrasion.
Thank you. Your Honor, I move this into evidence.
Okay.
No objection, Your Honor.
Exhibit 106.
Sure, that keeps coming, please.
When you examine the laceration, do you measure it?
Yes,
And did you measure it in this case?
I did measure it.
How long was the laceration?
I measured it as 2.5 centimeters, which is close to an inch.
Do you examine a person's body before you begin to intrude? Do you examine the outside of a person's body first, or is there a certain procedure or order?
Yes, the external examination is done first, and the internal examination is done second.
I want to show you that photograph that you just recognized, and I would like you to explain what you see to the jury. Ms. Gilman, with your assistance, thank you.
This is the laceration that I noted, and this is the scrape that's associated with it.
Take that down, please. After you make observations, what are your next steps in an autopsy?
The internal examination, after the external is performed and pictures are taken, then we proceed to the internal examination of both the, as I mentioned before, the torso, the body, as well as the head.
I'd like you to take us through the internal examination. Did you have a chance to look internally behind the laceration you saw on the back of Mr. O'Keefe's head?
Yes.
And when you did that, could you describe for us what you saw?
Yes. The way we examine the head is we make an incision with a scalpel behind the ear from one side to the other. That allows us to reflect or pull back the scalp, and that will expose the skull underneath. We do this carefully so that we don't disfigure clearly the face. And when we reflected or when we pulled back the scalp, I noted that there was blood, what we call hemorrhage, under the laceration or associated with the laceration on the back of the right head. And then furthermore, there were skull fractures associated with that laceration, abrasion on the right side of the head.
Were the skull fractures in the same or different area?
The skull fractures were in multiple areas of the skull, what we call the base of the skull. Imagine the base of the skull is sort of a bowl, and the brain sits on top or in the bowl. When the brain is removed, you can have a very good view of the base of the skull. So when the brain was removed and we were able to look at the base of the skull, I noted that there were multiple fractures that appeared to be originating from the area of the laceration, or what would correspond to the area of the laceration.
When you made your examination of the fractures in the skull, did that lead you to your opinion, or was there more you needed to look at before you came to an opinion about the cause of death?
Well, that was part of the findings that led to my opinion. But yes, I removed the brain, and as is our protocol, I saved the brain in a special solution called formalin that allows the brain to become a little harder so that our neuropathologist in Boston could go ahead and examine it. Because when I did look at the brain, I noted that there were injuries. There was bleeding on top of the brain. And therefore, I saved it. The brain ultimately went to our Boston office, and our neuropathologist, Dr. Stonebridge, examined it and issued a report.
Did you engage in any type of analysis on your own about any injury to Mr. O'Keefe's brain?
I noted the kind of injuries I could see superficially on the brain, and I have looked at the brain after it was fixed and pictures of it, but I did not issue a report on it. The whole point was for our neuropathologist to examine it closely and issue a more detailed report.
I have a few more photos. Would now be an appropriate time for a break, Your Honor?
Yes. So, jurors, why don't we take 15 or 20 minutes, okay?
15 to 20 minutes.
We'll all rise for the jury.
I remember Dr. Stonebridge from the first trial. There's that tattooed, lots of tattoos, very Gen X or Gen Y looking doctor, young. I think, they're just gonna let the jury out and not do anything else, but we'll just make sure. Yeah, I don't know that there was going to be any way they could get around calling her. But here we have the kind of overall description of the injuries, right? Some scrapes and a big, cut and fracture in the back of his head. Some bruised hands, the chewed up arm, and a small scrape on the side of his knee, and that's his injuries. That's what was so obvious now to Trooper Buchanan that we're dealing with a car accident, that he had to go to Dighton to look at Karen's vehicle at that point. This just confirmed for him that they were dealing with a motor vehicle collision. What do you think about that bruise on the right hand? I remember that coming up in the first trial. There's the bruise on the right hand with the little pinpoint marks on it. And yeah, it does look like a puncture, doesn't it? But we heard in the first trial from the ER folks that they I forget what the name of the procedure was, but like they literally drill into his shin bone to get fluid into him. Like they don't put it in a vein like you might for, I don't know, a person whose heart is beating, I guess. So there was nothing that the EMTs identified that would have caused that. I also have a real big problem with the fact that his heart had stopped by the time there was any medical intervention at all. And when your heart is stopped, you won't bruise. The bruising is the seeping of the blood out of the broken blood vessel. But you need, the blood pressure caused by your heartbeat to cause that to happen. So, dead people don't bruise. So, what does that mean, guys? What does that mean? How does that fit into the story? It sure does look like a puncture. Somebody who's a first responder in the house maybe try to stick an IV in John's hand. I mean, he didn't seem to have that at the Waterfall or CF McCarthy's or anything like that, did he? I don't know. Quite a curious part of the story, because certainly didn't hear anything from the medical examiners about trying to get an IV into the back of his hand. Not sure how that bruise would have been caused after his heart has already stopped and never been restarted. Don't know. Weird little puncture. It does look like a little puncture, doesn't it? Almost like little vampire teeth or something. Tiny little vampire at some point. I don't know. It rode in on the pig, maybe. Well, yeah, guys, we are full into the technical case. That might mean more Alessi. Getting him for this cross too. Very excited about that. Let's go ahead and take a minute to go over and look at what has happened here with the buffer zone. The buffer zone. We got the supplemental order regarding the buffer zone is out. So let me make myself a little small. Oops. A little smaller here so we can read it. So here's what they've done. They have supplemented to simplify any potential First Amendment issues related to the buffer zone restrictions. First, for all of the reasons cited in support of prior orders and based upon the parameters of this dispute as narrowed and described in the decision, all orders of this court remain in place insofar as they apply to courthouse property. We're going to go back and look at the opinion if we get a chance, just to see exactly what they had held and what they had called for in terms of modifications of this order. But essentially, there was not really a dispute about the court's ability to monitor its own property and make decisions about that. Second, prior orders remain in place as applied to pathways, including public sidewalks and roads through which and at which times trial participants enter and exit the courthouse. So pathways through which they enter, but at which time, this is some strange language. I'm not sure because it's grammatically a little bit off. At which times, but you're not referencing a time. Unless the prior order says like only when they're entering and exiting. Does that mean you can do it at other times? Not entirely clear to me from this language. Third, noisy protests, including those using amplified sound, honking horns, or loud screaming and yelling that are intended to interfere with the administration of justice or are intended to influence any judge, juror, witness, or court officer in the discharge of his or her duties are prohibited within the buffer zone. Noisy protests that are intended to interfere with the administration of justice. We're going to talk about that. Fourth, the display of written or graphic materials that are intended to interfere with the administration of justice or are intended to influence any judge, juror, witness, or court officer in the discharge of their duties are prohibited within the buffer zone. And fifth, any person whose activity has been restricted by an officer enforcing this order may request review by a judge of the Superior Court, which request shall be heard as expeditiously as possible. Quiet offsite demonstrations on public property in areas and at times that do not interfere with trial participants' entrance into or exit from the courthouse and that do not interfere with the orderly administration of justice and that are not intended to influence any trial participants in the discharge of their duties are specifically outside the scope of the buffer zone restrictions. So that is the new order. So let me ask you guys this. Having now read this order, do you feel that you know whether you can wear a Free Karen Reed t-shirt within the buffer zone? Do you feel that that is clear from this order? Can you wear a Free Karen Reed shirt inside the buffer zone? Is that clear? See, here's the problem with it. And this problem, from my perspective, it's a problem with enforcement. It's a problem with, is it clear enough to guide law enforcement about how to make specific decisions and so forth? You know, how are we applying this rule with respect to any particular people? The problem that I see is with the intention. The order as it's written, this new modification makes it clear you can wear a Free Karen Reed t-shirt within the buffer zone as long as you don't intend to interfere with the administration of justice or influence any judge, juror, witness, or court officer in the discharge of their duties. As long as you don't intend for any of these improper things to happen, you can wear the Free Karen Reed t-shirt inside the buffer zone. Likewise, you can yell, shout, honk your horn, as long as you're not intending to interfere with the administration of justice or influence any judge, juror, etc. So it's the intent that has now been made the limiting factor. And that derives, let me get the order up here. That derives very specifically from what the First Circuit found. I don't know if you guys can see that. Looks like it's okay. So I'm just going to walk through this a little bit quickly to get the point. So we had these. We have the order that didn't allow vehicles honking, extended the buffer zone, prevent the interruptions and distractions. Because people in the courthouse could hear the voices and the horns and so forth. So then people sought to demonstrate. They challenged the order. It went through court. They set out the legal standard. You got to show reasonable likelihood of success on the merits. So first off, they conceded they don't challenge the order as applied to courthouse property. That's why the first provision, everything dealing with the courthouse property remains in effect. Plaintiffs aren't challenging that. Doesn't seem to be any real argument that the court lacks authority to do that. There is quite a bit of, law establishing the judge's authority to maintain order and decorum and so forth within the courthouse property. They can tell you don't get to wear a specific t-shirt, like you don't get to go into the courtroom wearing a Justice for John O'Keefe or a Free Karen Reed t-shirt. It's not appropriate in that forum. So nothing challenge applied to the courthouse property, nothing challenged with respect to the pathways through which trial participants enter and exit the courthouse. So that's why that part of it is somewhat restricted as well. And finally, they disclaimed at oral argument any legal argument in favor of noisy protest. So they're not asking for the right to make noise. On courthouse grounds, they don't dispute some demonstration or beyond courthouse grounds, at least some demonstration-related conduct is permissible, such as picketing, intimidation, disruption of court proceedings, and public disturbances. So ultimately, the nature of the challenge is that plaintiffs want to engage in quiet off-site demonstrations on public property in areas and at times that do not interfere with entrance and exit, don't interfere with the administration of justice, won't influence any trial participants. So here's kind of where this comes down. They're relying on the Supreme Court decision from Cox versus Louisiana. And that is a case dealing with the authority to regulate picketing near a courthouse. And so in that particular case, the statute said it's a crime to picket near a courthouse with the intent of interfering with the administration of justice, et cetera, et cetera. Court held that's okay. That statute is consistent with the First Amendment because it is narrowly tailored to just the problematic speech. And it's not reaching speech beyond that. Why? Because of this limiting factor of the mens rea requirement. Mens rea is guilty mind. It's the intent to cause the interference. So because they had that limitation, the Louisiana tailored the statute to target the type of speech that most threatens the judicial system. That is to say, speech intended to affect mob law and thus to infringe the substantial state interest in protecting the judicial process. So you're intending to interfere with the judicial process, then that restriction is okay because that's the interest that is being furthered by having, limitations on protest in the first place. This order, by contrast, seems to lack a mens rea requirement, i.e., it likely applies equally to speech directed toward random passerby and speech directed towards trial participants. Plaintiffs do not appear to ask us to allow them to engage in the latter type of speech. At oral argument, they indicated they seek only to engage in quiet off-site demonstrations on public property in areas and at times that don't interfere, etc. And so these fresh clarifications bring into focus plaintiffs' argument that Cox's tailoring holding should not control this case. And with plaintiffs' position now clarified, we think it prudent to vacate but not reverse the district court's denial of a preliminary injunction, remand the case for further proceedings to determine how the order has been interpreted and applied and whether the lack of a mens rea requirement renders the order insufficiently tailored. So then they go on. State court could, entirely of its own volition, further simplify any potential First Amendment issues by amending the order to introduce a mens rea requirement as in Cox, i.e. by limiting the order to demonstrations directed toward interfering with the administration of justice or influencing trial participants. Based on the representation, such an amendment would allow plaintiffs to engage in their desired quiet, off-site, non-obstructive demonstrations while minimizing the risk that demonstrators will improperly interfere with the judicial process. No costs are awarded. So guys, that's basically what the First Circuit told them to do. Told them if you just bring in a mental state requirement, that will solve the First Amendment issue because that makes it narrowly tailored. But here's the problem with it. Okay, it might narrowly tailor it, but how are police to determine what is your intent when wearing a Free Karen Reed t-shirt in the buffer zone? How are they to know what your intent is? this is the part that's a little bit difficult to navigate, and that's why it's not necessarily 100% clear. Okay, so often the best proof of somebody's intent is their actions. They teach you in law school this kind of maxim: a person intends the logical and probable consequences of their actions. So, for example, common example that's used, if you point a gun at somebody, at their body, and you pull the trigger, even if you say, I didn't intend to shoot them, if you engaged in volitional acts, you can infer the intent from the fact that they did it. Like, what else were you intending? Oh, well, I was intending to scare them, perhaps. Well, then you look at the total circumstances. Did you check to see if the gun was loaded? Did you rack it? Things like that. But you can infer intent from people's actions. So that's what happens most of the time when police are arresting somebody on a crime that requires a mental state. For example, a person has been caught breaking into a house. Burglary is a crime that often requires proof of intent to commit a crime inside. So how do police know if they're going to charge you with burglary or not, or if they're just going to charge you with trespassing because you're in a place where you don't belong to be? You don't belong. You don't have a right to be there. They're going to look at your actions. What were you doing in the house? Were you sticking things in your pocket? Had you made previous comments about needing to break into a house to steal something, for example? How are they going to establish that? They're going to look at your conduct. So one possible way to interpret this order is that police will simply look at what the protesters are doing. If you're just passively wearing a t-shirt inside the buffer zone, that's not necessarily going to prove any sort of intent to interfere with anything. But if you're approaching the pathways while the jurors are coming and going, if you're yelling while they're coming out of court, things like that, that's what they may rely on to establish intent, to distinguish between who is protesting in the lawful way that this order allows, and those who are exceeding those limits, those who are demonstrating an intent to interfere with the administration of justice or influence any judge, juror, witness, etc. Are we going to trust the cops to do that, to make those fine distinctions? I don't know. I don't know that we are. I just don't know that we are. Don't know that that's a realistic expectation in light of the realities that are taking place on the ground out there. If they do, and they knock it off, okay, you're perfectly allowed to wear a free Karen Reed t-shirt within inside the buffer zone. You just can't do something that demonstrates an intent to interfere with justice, influence witnesses, etc. Then maybe problem solved. But it's not entirely clear to me that if they wanted to infer intent somehow, more broadly, that they might not come up with a basis to do that, and therefore, harass or intimidate people who are wearing free Karen Reed t-shirts inside the buffer zone, but not yelling, not going near the pathways, not doing any of those other things. Do we really think police can't come up with a reason to say you having a t-shirt, a free Karen Reed t-shirt on within the buffer zone and doing something is going to be a proof of intent? I'm just not sure that I really value this distinction from an enforcement standpoint. I don't know how law enforcement is supposed to credibly distinguish between people wearing free Karen Reed t-shirt with intent to interfere and people wearing free Karen Reed t-shirt without the intent to interfere, unless that is very strictly tied to specific conduct showing intent. like engaging in the specific activity that was addressed in the opinion, doing it at the pathways, at the witnesses, things like that, then I think we might be onto something. But otherwise, if I'm a protester, I'm somebody out here in this area, I'm not 100% sure, not totally confident that I have the right under this order to go out and wear a Free Karen Reid t-shirt in the buffer zone. It's not clear, because how are police ever going to confirm or deny my intent one way or the other? At best, you have circumstantial evidence of it based on what I do. But how might that be distorted? Well, because I sat there all day. And so clearly I was waiting for people to pass by, hoping that they would. I mean, I don't know. But I don't know that we can fault this from a legal standpoint, in the sense that it does seem to carry out what the First Circuit told them to do: narrow it, put a mental state requirement on it, and that would resolve the issue. So that's what she's done. Seems to be in compliance. Perhaps a bit unsatisfying. Now, I don't have the original order like readily available. I do see that Turtle Boy has posted. He says, going to do a quick write-up on this now, but make no mistake about it, this is a massive win. The buffer zone as we know it has been completely revamped. Supporters of Karen Reid are now allowed to go back to where they were last time, outside the church, and sit and watch the trial. Anyone who is told they can't do something inside the buffer zone can request a hearing with a Superior Court judge immediately. Auntie Bev got punked down by the First Circuit Court of Appeals. So at least from Turtle Boy's perspective, they feel confident that this order is allowing them to do that. I think that's reasonable. I think the order, should allow them to do that. The question is just, is it going to definitively prevent people from being hassled by police if they're wearing, carrying signs, wearing a Free Karen Reid t-shirt inside the buffer zone? Not crystal clear to me that it will, but I can agree that it probably should. It's just, as we know, when it comes to Norfolk County, what the law is and how the law is enforced are not necessarily the same thing. But she met her deadline, that 48 hours, to go in and get the order modified. So that is some progress, at least. Well, I'm going to take the time to go through some of your comments and questions, guys. Mickey P. John's niece testified Karen Reid initially said, I dropped him off and asked for Jen's number. Backed her version, not Jen McCabe's claim. Karen said she left him at the waterfall. Interesting. Yeah. Probably there's more detailed information out now than from what we saw yesterday about what John O'Keefe's niece testified to. So I haven't seen that, but this specific thing would tend to back up Karen's version more than Jen's. I dropped him off. Yeah, you didn't drop him off at the waterfall. Fighting Usyk, did you say tweezers? Tweezers to get that hair, overcome that resistance. What resistance exactly? Miriam, not related, but could you talk about the SCOTUS hearing today? Love you, looking like a baddie as always. Well, you're too kind. Oh boy, hate to admit I'm not sure I know what the SCOTUS hearing today is. Oh, it's the birthright citizenship. Yeah, I haven't watched the argument, haven't read the briefs. This is the executive order, right? Challenge to the executive order. Does the executive order give you the power to limit birthright citizenship? Seems highly questionable to me, but I haven't dug into this one from the legal standpoint. So that all I can really say about it, sorry, Miriam, is it's happening. It's going on today. There should be a lot about it in the news. but it's not an issue I've looked a whole lot into at this point. Summertime, when do you think Commonwealth will end their case in chief and defense will begin presenting their case? Looking forward to that. Thanks for your great commentary. We got to be getting close, right? We seem to be shifting into a different phase of the Commonwealth's case where we're moving away from eyewitnesses, first responders, investigation, etc. And now we're finally getting into technical stuff. John's body, the autopsy, what we know from that, and then presumably accident reconstruction, the data from Karen's car, and those types of pieces. I don't know where else they would have to go with stuff like the investigation. Proctor, for example, do they need to call him? I'm not sure they did. I kind of feel like they got in everything they really needed through Buchanan, and defense made him pay the price for that. You want to be the Proctor surrogate, then we will treat you as the Proctor surrogate. So not sure anything else is going to come out from that piece of the investigation. If that's the case, then we should be wrapping up pretty quick. Maybe into this week, early next week. Kind of hard to say. I mean, Scordi-Bello is going to take a little bit more time. And then obviously Cross of Scordi-Bello is going to take more time. She alone could be the rest of the day today. Not impossible. Probably unlikely, I think, just given, how much she's already gone through. Probably hear from Dr. Stonebridge again. She was, like Scordi-Bello has indicated, she's a specialist with neurosurgeon, neuroscience. She's the brain specialist. So they'll probably bring her in to testify about some of those issues, but maybe not. Maybe not. Remember, the Commonwealth has their own brain guy now. So maybe they'll call him in instead. Talk about the contra coup injury that Mr. Brennan has discussed. Maybe they won't call Stonebridge. But those kind of seem to be the minimum. So if they get all that, then yeah, probably early next week sometime. That would be my best guess. I'm excited about it too. Very much looking forward to that. Deep state thrombosis. I think Bev does non-speaking objections so she can sustain without a reason on the record. It'd cut down on the sidebars if they were speaking too. Yeah. If they're allowed to even just state the basis so it's clear. One, it's clear what my problem is when I'm making the objection. And that's either, viable or not. Preserves my record for review, like the defense argued they should be allowed to do. And yeah, they should. But it just makes everybody not have to guess. For me, the party that's asking the question that doesn't know what the basis of the objection is, I don't know what your problem is. So I don't know if I should just try to fix it. If it's a formal issue, if I should try to lay more foundation, or if you've got some kind of more fundamental problem with what I'm doing. I'm supposed to, be reading your mind. And, there's lots of room for difference of opinion on some of that stuff, difference of perception. We just talked about earlier this morning when Maureen Hartnett was on the stand and they were asking questions about, did you have any information basically about the circumstances leading to the red Solo cups? And there were objections to that. Alessi objected. They ended up having a sidebar. I'm like, yeah, that's calling for hearsay. That's the whole problem with it. Of course, she wasn't there. She doesn't know. All she can do is repeat what somebody told her. And it seems to clearly be hearsay. It's being offered for the truth, right? You're asking about the circumstances. She only knows the circumstances from this hearsay information. So if you want her to describe it, it's because what she was told, you want us to think it was true. But they come back after the sidebar and continue to ask the questions. And what does she say? She say, well, I was told this is how it was. Well, yeah. I mean, that's what I anticipated the whole time, but it doesn't seem like that was the subject of what's going on up at the sidebar. So there can often be lots of different things going on with the question and why it might be a problem and stuff. It would just make so much more sense to be able to say object, hearsay, object, lack of personal knowledge. I mean, whatever, just your short identification of what the issue is helps you make your record, puts everybody on the same page. And I think you're absolutely right. It's so that her reason isn't stated. So she's not nailed down to having made any particular ruling. And that means that any ruling that would justify sustaining it, that will cause her to be affirmed.
Back in session, you may be seated.
So you wanted to see me?
Yes, please, Your Honor.
Okay, over here or?
Quick to a sidebar. Carolyn Smith, new here, love your channel. Was any DNA obtained from anywhere other than pig DNA? Thanks. They did recover DNA from the clothing, from John's clothing. Some of that was the mixed sample, mixed source. We talked a little bit about that yesterday, how if you have a mixed source of blood, it's very unlikely it's a mix of blood and touch DNA. So like grabbing the shirt, moving him into the ambulance, stuff like that. It's very unlikely because you have a massive discrepancy in the signal strength that you get from the amount of DNA that's in blood versus the amount of DNA that's in, 1 or 2 or 3 skin cells, few skin cells, that gives you touch DNA. So that tends to hint that we're talking about mixed blood. I wonder if that's going to be developed more in this trial. As far as non-human DNA, it was the pig DNA that was ultimately recovered from those holes on the sleeve of his sweatshirt. The puncture-looking wounds. No dog DNA, but there was pig DNA and apparently keratinized tissue, which who knew is commonly found in the gums. Commonly found in gums. But they didn't get into that. So that's we get what we get. Linda LW with a super sticker. Thanks so much for that, Linda. Appreciate your support. Bev's Hoff Day. Did they test the Lexus for keratinized tissue? Yeah, I mean the Lexus looks like it might have a little periodontal disease or something. Might have some issues with the old seal on the gums of that Lexus. Better check that out. Carolyn Smith, also we hear jury comments, so it could have come from them. Oh, I didn't even think about that. The asshole. I haven't heard jury comments. If you hear one, call it out to me. I haven't heard anything that I could identify as a jury comment. But I mean, yeah, there's mics all over this courthouse, so seems like there are potentially a few different sources. I don't think it was Bev. It didn't sound like it was coming from the same place as her voice. And she's also very aware, of the microphone, I would expect, but maybe not as much as the defense lawyers. Carrie T, it's Canoni's courtroom. We all heard it. It needs to be addressed, and it's on her to do so. Well, from a decorum standpoint, yeah, it really should. You shouldn't be making comments like that. If you're making comments like that, not just the risk that it's picked up here on camera and the entire world hears it, but if you're not careful enough, the jury can hear you. The jury can see you. Maybe somebody on the jury is a lip reader. You shouldn't be calling people assholes while you're in open court. Generally, improper behavior. Haas long to lie. What is Bev reading and writing all the time? I don't know if she's taking notes on this case. Sometimes it looks like she's up there like working on other stuff. Just kind of flipping through things, maybe taking care of some other reading, some other case. I don't know. It's not uncommon for judges to be up there taking their own notes of things that are said, particularly because you're needing to keep track of certain things to guide your later rulings. So for example, when we were seeing all that setup with Jen McCabe during Alan Jackson's cross-examination, setting up a lot of future impeachment, that's the kind of thing you might need to take a note of. What exactly is her answer? Because her answer tells you what door has been opened. And it may put some limit on that in terms of what he could then elicit from a future witness. So not uncommon to keep records of things like that throughout the course of a trial so that you can make the right ruling later. When you're presented with something he wants to present as impeachment, has that foundation been laid or not? But I don't know if that's what she's doing. I don't know if she's up there playing tic-tac-toe. No idea. No idea. Not sure that probably her notes are not public record. Generally, they're not judge's notes. Not a part of the case file or anything like that you get to request. Tara Rayner during Hank Brennan's open. We will not prove Karen Reed tried to kill John O'Keefe. We don't intend to prove she intended or wanted to kill John. That's doubt. Well, it's doubt as to murder, certainly. Like, why are we even proceeding with a murder charge if that's your theory? Arguably, if he did say that, it's in quotes. I don't remember him specifically saying that, but he might have. If he did, that would seem to suggest bad faith in pursuing with a murder prosecution, because intentional killing is an essential element of that charge. I don't know if it's in my notes, but yeah, that's why the manslaughter is the backup position, because manslaughter is not an intentional killing. So yeah, that's definitely doubt as to murder. No question about that. Redondo Beach, I'm obsessy with Alessi. You're not the only one. Get that on the t-shirt, somebody. We're all obsessy with Alessi. Jason McClellan, as others noted, why no badge number on the tag? She knows a hood, not a tail light. I don't know. I don't know why they don't use their badge numbers. That would make sense, particularly if there's bad handwriting or something like that. I don't know.
Tori, I'm going to give you those. Those were both marked for ID. So one will be coming into evidence and one will be a chalk. So you may need to have them available for the witness.
I see a note there. Someone's saying, Andrea, he did say it in closing. All right, let me look. Let me look at my notes. Gotta get through the preliminary instructions.
You consider stand wherever you're more comfortable, doctor, for now.
I see. So the murder too. We're not going to prove that she tried to kill him or wanted him dead. The intentional act was driving backwards. So I don't know what that means. I don't know if that is that same maxim I was just talking about. Intend the logical and probable consequences of your actions. And so we're making an inferential case for murder on that because he is, he's clearly arguing, oh, she backed up intentionally. But she was trying to what? Scare him? She's trying to scare him, and that's her intent. That's not murder. And so if that's your theory, I'm not sure how you get to murder. Not sure how you get to murder. So good catch on that that quote from the opening. I did in fact find it, roughly there in my notes. I'm not going to try to prove she intended, tried to hit him. Then I don't know why we're here on a murder charge. I don't know why we're here on second-degree murder. Let me maybe take a look at something else. Murder 2 has 3 ways of committing it. The defendant intended to kill John, or intended to cause grievous bodily harm to John, or, this is the one, intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. I remember this now from the last trial. It's his 3rd way of committing murder in Massachusetts. That's awfully close to manslaughter. Like, it's very hard to tell the difference between reckless but non-intentional infliction of death and then whatever this 3rd version of murder is in Massachusetts.
Doctor, when we left off, you had described all the injuries to the exterior of Mr. O'Keefe, and we had talked about your observations of both the fractures in his skull and also your observation of Mr. O'Keefe's brain. You mentioned earlier that you use other resources, other testing. Did you ask for any type of assistance on toxicology analysis for Mr. O'Keefe?
Yes, it is routine and it is protocol to submit toxicology specimens to the lab for examination.
May I approach, Your Honor?
Yes.
Thank you. Doctor, I'm handing you a document. Do you recognize that?
Yes, this is the report of toxicology from the State Police Crime Lab for Mr. O'Keefe's autopsy.
Have you seen that document before?
Yes.
Is that a fair and accurate depiction of the report you saw before?
Yes.
All right, introduce this as the next exhibit, please. No objection, Your Honor.
Thank you.
Exhibit 161.
Thank you. I have that in front of me. Sure. Thank you very much.
Thank you.
Want to tell us what it says?
In your experience, Doctor, are you familiar what the toxicology report and the testing involves?
I'm sorry, what was your question?
Are you familiar in your experience with what is involved in a toxicology test?
In general terms, yes.
And if you studied Mr. O'Keefe's toxicology report, was that important or part of your analysis in your ultimate conclusions?
It was one piece of evidence that I took into consideration, yes.
In the toxicology testing, is there a search to see if there are any type of drugs or medications in Mr. O'Keefe's blood?
Yes.
Okay. And was there any?
There were no prescription medications. There were no illicit drugs in his system.
In a toxicology, is there also a testing for blood alcohol content?
Yes.
What is the difference between ethanol in heart blood and ethanol under 1102?
In vitreous humor.
Yes.
So we usually submit multiple specimens for toxicology. Some of the specimens are used for screening of classes of different drugs, and then other specimens are used to confirm, the presence and quantify a particular drug. So in this particular case, the lab tested the heart blood, which showed that it had an ethanol level of 0.21 grams per deciliter. And they also tested the vitreous, which is the fluid that sits behind the eyeball. And in that specimen, the ethanol was slightly higher at 0.28.
Thank you, doctor.
Slightly higher?
After your autopsy and observations of Mr. O'Keefe's body, inevitably, did you come to a conclusion about the manner and cause of Mr. O'Keefe's death? And I'll ask you first about the cause. To a reasonable degree of medical certainty, did you reach a conclusion about the cause of Mr. O'Keefe's death?
Yes, the cause of death was determined to be blunt impact injuries of head and hypothermia.
You mentioned two different things, blunt impact and hypothermia. Was
Correct.
there a primary cause of death in your opinion?
The blunt impact injuries of head.
Hypothermia, was that sufficient to be a primary cause of death in your opinion?
In the absence of head trauma, hypothermia is a cause of death, but I'm not able to make that determination in this case because we do have the blunt impact injuries of head.
So if I understand, you are not saying to a reasonable degree of medical certainty that hypothermia was the cause of death?
Not the primary. It contributed, but the primary cause of death was blunt impact injuries of head.
Did you learn what Mr. O'Keefe's body temperature was when he was brought to the hospital?
Yes, some of the medical records stated that his body temperature was 80.1, I believe, degrees Fahrenheit.
And what is a normal body temperature?
98.6.
Regarding the blunt force injuries as the cause of death to Mr. O'Keefe, at some point when you were conducting your autopsy, or even at the end when you drew your conclusions, were you able to reach a conclusion as to the manner of Mr. O'Keefe's death to a reasonable degree of medical certainty?
No, I was not.
After you complete your findings, including the manner of death and the cause of death, even if undetermined, are you required by statute, by law, to file a report or a document?
Yes,
And what is that document?
it's the death certificate.
Did you do so in this case?
Yes,
When you file a death certificate, do you include your ultimate conclusions regarding cause and manner of death?
yes. There is a death certificate that is issued immediately after the autopsy. The death certificate is a document that is necessary for the family in order to make funeral arrangements and proceed with their plans. So a death certificate is always issued at the end of the autopsy. If the cause and manner of death are known at that point, they are stated on the death certificate. If they are not, or if we need to do additional studies, then both the cause and the manner are listed as pending. And that death certificate is sufficient for the family to make arrangements. Later, as we get more information As we get more results from our studies back, we issue an amended death certificate. So that amended death certificate will have a cause and a manner. The amended death certificate, in this case, stated that the cause was blunt impact injuries of head and hypothermia, and the manner was undetermined.
May I approach, Your Honor?
Yes.
Doctor, I'm handing you a document. Do you recognize that document?
Yes.
And what is it?
This is the final or amended death certificate for Mr. O'Keefe, stating that the cause of death is blunt impact injuries of head and hypothermia, and that the manner of death could not be determined.
Do you recognize that document is accurate?
Yes.
All right, move this into evidence, please.
No objection, Your Honor.
Now, she didn't provide any of the medical basis for the hypothermia finding. It's just kind of there out of nowhere. She hasn't described anything other than just the temperature in the hospital.
After issuing the death certificate and after the 90 days passed, have you done any further study or investigation on this case, doctor?
No.
Thank you. I have no further questions.
Let's go. Deep sigh. Okay, he's not your enemy. You've already given him everything he needs.
May I, Your Honor?
Yes.
We have not had the pleasure of meeting, so good morning, Dr. Scordi-Bello.
Good morning.
With regard to cause of death as opposed to manner of death, is it correct that a forensic pathologist is tasked with determining that cause of death that includes contributing factors, injuries, and circumstances regarding the medical legal death investigation? Is that a fair statement?
Yes.
And I'm using the term medical legal. Is that a term that you're familiar with?
Yes.
And is it correct that medical legal means, particularly for medical examiners, that there's a medical aspect to the investigation that you perform, and there's also a legal aspect or a law enforcement aspect to it? Is that correct?
Correct.
And that's a little different than what physicians usually do, right? Because isn't it the ordinary course that it's mostly just medical, but medical examiners by statute and law need to have both of those prongs taken into consideration? Do I have that right?
Yes.
So in other words, the forensic pathologist, which you've indicated you are, is tasked with determining the cause of death, which answers the question as to why, in more layman's terms, why did the individual's body stop functioning at a particular time, correct?
Yes.
So more broadly, the cause of death is generally defined as the disease or the injury that resulted in the death of a person.
Correct.
So let's now, if we could please, move to the manner of death. And I'd like to summarize, I know you covered it on direct, but I want to put it in a slightly different context, and hopefully I'll get it right. So medical examiners, as you've stated, are also tasked with, if they can, determining the manner of death or the circumstances under which the death occurred, correct?
Correct.
So manner can and does involve the circumstances under which the death occurred.
Yes.
And that causes one to go the medical examiner to go beyond just medical analysis. You take into consideration other factors, which we'll get to. Is that correct?
Yes.
So you talked about, and I'm just going to go through them quickly, but if you could just check me on this, the 5 main categories of manner of death. So you talked about natural causes, correct?
Yes.
You talked about accident.
Correct.
You talked about suicide. You talked about homicide. And then the last category, undetermined. Do I have that correct?
Yes, you do.
So what I'd like to do is to focus on the undetermined category. And my understanding is, doctor, that that's where you landed, that's where you concluded with regard to manner of death of Mr. O'Keefe, correct?
Correct.
So undetermined is a term that is used and that you use. And does that mean that when the information pointing to one manner is not more compelling than other reasonable possibilities, or the death investigation lacks sufficient information to opine on a manner of death, at the time of death, the certificate is signed? Is that generally correct?
Yes.
So as we've talked about, I'm just trying to follow or just develop some logic and see if this is in agreement with you, that as a medical examiner, you're specifically tasked with conducting that medical legal investigation. And what we've just talked about is a bit of the method of analysis that you go through for that, correct?
I conduct the autopsy and I request information information from the investigative body that is out there investigating the other aspect of the case, not the body itself.
Yes. So is it correct that there's 4 general components to a forensic pathologist death investigation? Is scene investigation one of the components?
It depends on the jurisdiction where you practice. Scene investigation is part of forensic pathology in certain jurisdictions, and it is the responsibility of the district attorney and law enforcement in other jurisdictions. In the state of Massachusetts, we are responsible for the autopsy, and the DA's office and law enforcement are responsible for the scene investigation.
Excellent. So scene investigation in the state of Massachusetts is not within your domain in the office of the medical examiner. That is the domain of the district attorney and law enforcement, correct?
Correct.
How about another aspect, forensic autopsy and laboratory testing? That's within your domain, correct?
Correct.
And how about police reports and witness statements?
That is not under my jurisdiction. That is under the district attorney's office and the police.
Do you consider information, nonetheless, from police reports and witness statements in your analysis?
Yes.
And do you also consider, even though it's not within your jurisdiction in Massachusetts, do you also consider information about scene investigation?
Yes.
So it's correct then that you consider, whether it's within your jurisdiction or not, you consider scene investigation and police reports and medical statements, correct?
Yes.
And then forensic autopsy and laboratory testing is right within your jurisdiction, and therefore, of course, you consider that. And then lastly, medical history and hospital records, is it therefore, am I correct that that's something within your jurisdiction and that you consider in performing your forensic pathologist death investigation?
Yes.
So now let's move on to the application of those principles. So in order to conduct a proper medical legal investigation, the medical examiner has to have certain qualities, if you will. Is one of them being well-grounded in general medical knowledge?
Yes.
Is another appropriate training and experience in forensic pathology?
Yes.
In other words, you wouldn't want a specialist, for example, in cardiology without anything more to be conducting a death investigation. Is that correct?
I would not want them to be conducting an autopsy, correct?
Right. Would you want a neurologist to conduct a death investigation?
Personally, or are you asking me that? No, I don't think every physician has their specialty and their training, and forensic pathologists are trained to perform autopsies, and cardiac surgeons are trained to perform cardiac surgery.
Would you want a neurosurgeon to be conducting a death investigation?
To be performing an autopsy? No.
So you wouldn't want a neurosurgeon to perform an autopsy?
No.
Because you don't believe they're qualified to do so, correct?
I don't believe they've had the appropriate training to perform an autopsy.
Going back into the many qualities of a medical examiner and attributes, they also have to have the ability to form opinions based upon all the available information using the scientific method along with sound reasoning. Is that a fair statement?
Yes.
And you're familiar with the term scientific method?
Yes.
And is it fair to say that the scientific method generally is sort of a systematic pursuit of knowledge that involves recognition and definition of a problem? Is that fair?
Yes.
Is it also involve the collection of data through observation and experimentation where appropriate?
Correct.
Does the scientific method also include the analysis of data?
Yes.
Does the scientific method also include the formulation, evaluation, and testing of hypotheses?
Yes.
And does it also, where possible, include the selection of a final hypothesis after considering other hypotheses?
Correct.
So what we've just discussed is a fair explication, a fair explanation of the scientific method.
Correct.
And the scientific method is part of the autopsy and forensic pathology analysis, correct?
Correct.
Now, applying one concept, that medical legal concept we talked about, just holding for a moment, if you could, the medical and going to the legal, if you will, law enforcement that you said in Massachusetts is not under your jurisdiction, but nonetheless, you consider information arising from it.
Yes.
Are you familiar with a person named Michael Proctor? Is that name familiar to you?
Yes, it is.
And at one time, Michael Proctor was a trooper, correct?
Correct.
And so did former Trooper Proctor inform you of the working law enforcement theory at the time of the investigation of this matter, namely his working theory, a collision of a motor vehicle with a pedestrian? Did he inform you of that?
He informed our office of that, yes.
He informed your office. And is it fair to say that he informed your office or provided that information to your office in or about February of 2022?
That information, part of that information was provided to our office at the time of the autopsy. One of the pieces of information that had come in, and there were multiple sources calling into our office, providing information, was that this was a possible person struck by a motor vehicle.
And the time of the autopsy, if I have it correctly, was that around the end of January of 2022?
The autopsy was January 31st.
Your Honor, if I could, with your permission, please publish a photograph which Your Honor has and the parties have stipulated, or that's in evidence. And this is the one. May I approach, Your Honor?
Yes.
May I show that to the witness?
Okay.
I would love it if he did it.
All right,
We got the
so we will
exogenous
mark this as
blast
the next
yesterday.
exhibit. There's no objections to Brennan?
No objection.
Okay, so we'll mark it first and then you can display it.
Thank you, Your Honor.
Exhibit 163.
I love how he uses big words to get to know the witnesses, introduce himself.
Yeah, Your Honor.
Yes.
Thank you. Dr. Scordi-Bello, if I could hand that to you, please. You could take a look at it, and when you've had a fair opportunity to look at it, you can just look back up, and I'll proceed at that time.
Yes, I recognize the picture. Well, I've never seen this picture before, but I know what it's depicting.
Thank you. What is depicted in that picture?
It's a picture of two individuals standing in a morgue setting, which looks very similar to our morgue at the Cape Cod office.
Very good. If you could just hold that for a moment, and with the court's permission, could I publish that for the jury?
Okay.
Thank you. Mr. Wolf? And if you could please zoom in on the two individuals in that picture. Dr. Scordi-Bello, do you recognize any of the individuals in that picture?
To be perfectly honest, no, I don't.
Looks like Connor
With
Keefe.
regard to the person on the right, do you recognize that person?
No, I don't.
And you said you recognized the setting, correct?
Yes,
And you,
Proctor
if
and
I heard you
Keefe.
correctly, you said this is the Cape Cod facility?
it appears to be
Right.
correct.
So you testified earlier, if I recall correctly, that the autopsy was performed at the Cape Cod facility of the Office of the Chief Medical Examiner.
Yes, it was.
And you're normally in, as I recall, the Westfield, in an office that covers Western Massachusetts, it's Westfield.
Correct.
But you were at the Cape Cod facility, as I understand it, because there was a staff shortage and you had to travel down to Cape Cod for this. Is this correct?
Correct.
So you were at your normal home base sort of facility. This is a facility that you went to for this autopsy, correct?
For this autopsy and multiple others, yes.
Yes. And you were covering a staff shortage, and that was the reason you went to Cape Cod, correct?
Correct.
And what's depicted in this picture are two individuals. For two individuals to be present, is there a protocol that they had to follow to be present for that, like a sign-in or an authorization?
Yes, there is a sign-in sheet that individuals have to put their name and their shield number and before they can come into the autopsy room.
So they have to put a shield number down, correct? You mentioned the shield number.
Yes,
And does that therefore mean that even though you don't know who they are, that they are with law enforcement? Are you able to determine that?
correct. I believe they were with law enforcement.
So those two individuals were with law enforcement, but you don't know who they are.
I don't know who they are specifically and what their actual position was.
But they were with law enforcement.
I believe, if my memory serves me right, there was a person from crime scene investigation and someone from state police.
Thank
But I'm working on a 2+ year memory.
Fair, that's fair, that's fair. I'm not going to ask you more questions to probe the memory. We can take that down. And yeah, we are finished with that. If you could hand that to thank you. Now, we were speaking about former Trooper Proctor. Do you recall former Trooper Proctor sending you a copy of scene photographs and wanting to schedule a phone call with you so that he could explain the status of his investigation? Do you recall that?
Yes,
And that occurred approximately in March of 2022?
yes, approximately.
Right, and the method of communication of that was that by email, to the best of your recollection?
I requested that our medical legal investigator, we have our own investigators at the office that are responsible for obtaining medical records and sometimes being the liaison between us and law enforcement to get reports. I requested that she contact whoever was in charge of the investigation and set up a meeting, a phone call. So since it had already been a few weeks since the autopsy, I wanted to make sure that if there was any additional information that could be provided to me, I could take it into account because I had 90 days to issue a report and a death certificate on this case.
Now, you've mentioned the 90 days on direct, you just mentioned it now. Is the 90 days a hard and fast rule, or is it just something you aspire to as a matter of good practices?
It's not a hard and fast rule. It's something that as an office we try to achieve. Again, the reason being that there are family members, next of kin that are waiting for these reports and these death certificates for various reasons. So is it possible to go over the 90 days? Absolutely, if necessary. But we do try to finish our part in those 90 days.
So it's possible to go past the 90 days, but there would, given the considerations you just articulated, there'd have to be a pretty good reason why you'd want to do that, right?
Correct.
In this situation, you concluded that you had sufficient information on the medical side and the legal side to come to the conclusions that you needed to come to. Is that fair?
Well, I had sufficient information on the medical side because I did the autopsy and I had those findings. I did not have sufficient information that pointed to one manner of death over another manner of death. And therefore, I stated that the manner of death was undetermined.
Exactly. So the manner of death is undetermined. And I want to, if I could with you, pursue that a little bit in a moment. But when you came toward the end of that 90-day period, you had information from the law enforcement side on their theory of what had happened, correct?
Correct.
Yes.
I'll let that one stand.
You had performed all of the medical investigation and analysis that you needed to perform, is that correct?
Yes.
There wasn't something more that you wanted to do on the medical side. You had mentioned, to be fair, you had Dr. Stonebridge involved as well. You had what you needed on that side, correct?
Yes.
And you therefore concluded on the manner of death that there was a not more compelling or more likely than other reasonable possibilities. Is that fair?
Yes.
So in furtherance of that, on April 14th of 2022, you issued a death certificate, correct?
Yes.
And please feel free to check your report of any dates or any other particular as I go through.
Okay. I issued my final report on April 14th, correct. And I would assume that the death certificate was on or around that same day.
Thank you. Now, to back up a little bit with regard to the autopsy, as you stated, it was conducted, I just want to do a little bit of a timeline, on January 31st of 2022, correct?
Yes.
And we discussed that the body of Mr. O'Keefe was presented to the Cape Cod location, correct?
Yes.
And you also discussed that you brought Dr. Stonebridge to work with you on this matter, correct?
She didn't physically come to the office. The way Dr. Stonebridge was involved is at the time of autopsy when the brain was removed. Having seen that there were injuries, I saved the brain in a special solution, and then the brain was transported to our facility in Boston. That's where Dr. Stonebridge examines the specimens. And after examining the brain, she issued a report.
Who asked Dr. Stonebridge to become involved in the matter?
I did.
And Dr. Stonebridge is triple board certified, correct?
Correct.
Play her up.
She's a forensic pathologist, correct?
Yes.
That means she's achieved board certification in forensic pathology like you?
Do you know that?
I do.
Oh, love it.
Yes, she's board certified in forensic pathology.
And she is board certified in general pathology, correct?
Yes.
And she's board certified in neuropathology, correct?
Correct.
Can you briefly describe to the jury what neuropathology is?
Neuropathology is a subset or specific additional training in forensic pathology where the person spends a considerable amount of time, usually 1 to 2 years, examining brains and learning all about the diseases of the brain as well as trauma to the brain.
Now, you asked her to be involved, as you indicated earlier, correct?
Yes.
And you determined that she should be involved because there was a brain injury, correct?
There was trauma to the brain, correct?
Trauma to the brain. Is it a fair characterization that Dr. Stonebridge is sort of the brains of the brain area of autopsy? Is that fair?
I'm going to sustain the objection. Let's move on.
So with regard to Dr. Stonebridge, would you agree that she's really uniquely qualified in some ways? Or how would you describe her qualifications, Dr. Stonebridge?
Sustained.
With regard to Dr. Stonebridge, what did she do?
I'm going to see you at sidebar on this, please.
So what? Now it's a problem to go into what she wouldn't have personal knowledge of? It's her basis of her opinion. And why she held that opinion, why she relies on this doctor. But this is what happens when you don't have people state the basis for your objection, then he's just going to continue to try to fix it. Because we don't know if your problem is foundational. We don't know if your problem is formal. We don't know if your problem is something more fundamental. When it came to Maureen Hartnett, getting around to eliciting that question, well, I was told about the circumstances in the solo cups. No issue with it. But Scordi-Bello, what is she not? Is she not supposed to know what what Stonebridge did, even though she's relying on it? Relying on it to make part of her decisions. Don't we love Alessi's ability to turn the expert into his own witness? We just love that. Absolutely not. Of course, you would not have a neurosurgeon do an autopsy. They're not qualified to do that. They have not been appropriately trained. Just the reaction was so authentic. Like, what a strange thing you're proposing. Indeed. Indeed it is. And when you think about it, doesn't that seem ridiculous? Oh, that was communicated loud and clear. Does not think highly of that idea. This is, a few times now we've seen Alessi kind of introduce himself to the witness with his use of words. Can we agree on the term artifact? Would you describe this as exogenous glass? And now with Scordi-Bello, it's medico-legal. Let's talk about this big term, medico-legal. You and I, we're on the same page. We understand the parlance that we're using. We have common ground with these terms. Let's make sure everybody else knows, because we both understand. It's kind of signaling. It's a way of signaling to this expert, I understand what we're talking about. So don't be thinking you might come through and outsmart me, dazzle me with big words or whatever. I understand what we're talking about. You'll get down in the weeds on the technical issue with the experts, and that's just part of the prep. You know, he's educated himself about what he's asking about. And how does he educate himself? Does he do Google searches? No, he talks to the freaking experts. And I just love how he does it all with his kind of Alfred E. Newman appearance. Great. What? Me devastate you with a cross-examination? What? Me slice and dice you with your own words?
May I, Your Honor?
Yes.
Thank you. Dr. Scordi-Bello, have you, are you aware of an attorney name, or excuse me, a doctor named Alessi Wolf?
No, I'm not.
Now I'd like to move on to another category. Based on the information that was presented to you as part of your examination and analysis, is it correct that you presume that because Mr. O'Keefe's body was found in the snow and his body temperature was 80 degrees, that he died from hypothermia as one of the causes?
I reached that conclusion after performing the autopsy and after seeing some findings that were consistent with hypothermia, and then combined with the information that was provided to me about Mr. O'Keefe's body being found in the snow, I came to the conclusion that was one of the things that contributed.
Did you consider whether there may have been other reasons as to why his body reached that temperature of 80 degrees? Sort of applying the scientific method and seeing if there were other reasons?
Other than being out in the snow? No, I do not.
Like being dead?
Do you know whether there are other alternative reasons how his body could reach the temperature of 80 degrees?
People can become hypothermic for other reasons, such as sepsis. But in this particular case, I didn't have any reason to believe that that was part of the circumstances.
Have you heard of algor mortis?
You're familiar with the medical phrase differential diagnosis, correct?
Differential
Yes.
diagnosis first.
And a differential diagnosis is a term that's used by doctors to pursue other potential causes of a medical injury. Is that a fair general statement?
Yes.
So for example, if somebody is having difficulty breathing, a doctor may say, I think it's the heart is their primary hypothesis, but they may want to differentially diagnose this and look at the lungs. Is that an example of a differential diagnosis that let's look at the lungs to see if that may be the problem? Is that a good, fair example?
In the example you're giving, yes.
So applying that concept, and do you believe the concept of, well, applying that concept to this situation, did you perform a differential diagnosis as to the cause of the death and question whether there was hypothermia as any cause of the death of the decedent? Did you make that analysis?
I looked at the anatomic findings that I had at the time of autopsy, the information that was provided to me based on the circumstances and where the body was found. And I came to the conclusion that there were hypothermic changes in Mr. O'Keefe's body.
So you just used the phrase hypothermic changes. Did I hear that correctly?
Yes.
Can there be hypothermic changes without a cause of death being hypothermia?
Yes, of course.
So you can have signs in the body of hypothermia, but you can also conclude that a cause of death is not from hypothermia, correct?
If the person is deceased and I am examining the body and there are multiple things that I believe contribute to the death, then I tend to include all of them. Meaning that if this was a drug intoxication and the body also showed signs of hypothermia, I would include both of them on the death certificate because there is no scientific way of teasing out whether it was just one or the other or both. In this particular case, I had two processes that were going on. One was the head trauma, and the other one were these hypothermic changes. I put all that together, and again, included or took into account the investigative information of where the body was found, what the temperature was when the body was found, whether the person was still alive or not. And I came to the conclusion that the cause of death was blunt impact injuries of head. And I included the hypothermia because I saw during the autopsy that there were changes consistent with hypothermia.
So I want to break that down a little bit if I could with you. So you testified on direct, and I think you alluded to it here, that the primary cause of death, use that phraseology on direct, was blunt force injury. Is that correct?
Blunt impact injuries to the head, yes.
Blunt impact injuries to the head, and that's the primary cause, right?
Correct.
And then there's, and I'm not clear on what you referred to on direct as a secondary cause of death of hypothermia, but you used a little different phrase in some of your answers, and I want to make sure I got it right. Hypothermic considerations, can you repeat what it was?
I said have hypothermic changes.
Hypothermic changes, and we agree that you can have hypothermic changes without a conclusion of hypothermia, correct?
No, hypothermic changes are what I'm referring to are actual things that I can see in the organs that are consistent with hypothermia. They're anatomic findings. They're things I can see with my eyes.
So you can, I'm sorry, did you finish?
And those changes suggest and are consistent with someone being hypothermic.
As you sit here now, with regard to, you used the phraseology consistent with hypothermia, signs of hypothermia, that's what I want to pursue just a little bit with regard to further information. We got started on this by asking whether you used the concept of differential diagnosis and hypotheses to determine the cause and manner of death. And you said in one of your answers that you relied upon law enforcement information, correct? Is that
Yes.
part of it? It was, you brought that up. You're the one who said you relied upon that, correct?
Yes.
And you've brought that up on your direct testimony and earlier in the cross. Is that correct, that you relied upon the investigation of law enforcement? So,
Sustained.
so now what I'd like to do is to ask you whether, using the concepts of differential diagnosis scientific method, did you consider whether Mr. O'Keefe could have died somewhere other than where the body was found and been moved and placed in the snow? Did you consider that?
Objection.
Sustained.
May we approach, Your Honor?
Move along with this. We can approach in a bit.
Thank you. What, if any, alternative diagnoses did you apply to Mr. O'Keefe?
I don't understand your question.
What alternative scenarios did you look at, if any, for the cause or manner of death of Mr. O'Keefe?
I'll allow that question. What, if any?
At the time of the autopsy, I documented injuries and signs of hypothermia. I was provided with a set of circumstances. And at the end of the investigation, or at the end of, my timeline, I concluded on the cause, but I did not conclude, or I did not determine a manner.
And we know.
The manner would be the circumstances you are speaking about, whether I considered other causes or circumstances. That's not how it works. I don't come up with hypothetical scenarios on how those injuries occur. I try to state the injuries, describe the injuries, state the cause of death and why that person died. And then I use all kinds of other investigative information that is provided to me to determine if I have enough to make a determination on the manner.
Did anyone provide to you any alternatives as to the finding of the body of Mr. O'Keefe in the snow?
Personally, to me, no.
Did you ask for any alternatives to the nature and location of the injury or death of Mr. O'Keefe?
I asked for all the information that was available.
Understood, but my question is, did you ask for any alternatives to the information that was provided to you as regards the location of the injuries? Did anyone provide you any alternatives to where the injuries could have occurred?
No.
So
I'm going to let the answer stand. So the answer is no, so there's no evidence of that. So next question.
So you talked about the information you had at the time. What time is that?
The information at the time was a preliminary police report and verbal communications regarding the circumstances of how Mr. O'Keefe's body was found.
And when I asked about the time, I'm not calendar time. Was this January, February, March, April of 2022?
The preliminary police report was on the day of the autopsy, and then information, I don't remember exactly how long, but in the weeks following, information was, coming in.
Do you have the ability to amend a death certificate?
What?
Yes, I do.
And you can amend a certificate if you obtain further information with regard to the circumstances surrounding the death. Is that correct?
That's correct.
In your previous answers, you were talking about the information you had at the time. And I'm concluding that the latest that would be is April of 2022. Is that correct?
Correct.
Have you obtained or been provided with further information? In other words, information after April of 2022 regarding the cause or manner of death.
What do you mean, have I been provided? Has someone physically provided me with a report on different circumstances?
Well, what I'm just talking about is any other information that you have received or considered.
Anybody updated
in terms
you?
of the analysis with regard to the cause or manner of death.
Received in what way?
Here's what I'll do. I'll be a little more specific. What I want to do is to get at the head injury of the decedent, okay? Is it fair to say that the head injury, you called it a traumatic, state what you phrased that as, because I want to use your phraseology.
Blunt impact injuries of the head.
So blunt impact injuries of the head. Is it fair to say that that was a very severe injury?
It was a severe injury, correct?
And would Mr. O'Keefe had been rendered unconscious nearly instantaneously with death following shortly thereafter?
It's very possible, yes.
Is it more than possible? Is it probable that that's what would have occurred?
I can't tell you how quickly he would have been rendered unconscious, but at some point after that injury, yes, he would have been rendered unconscious.
Is it possible he could have been rendered unconscious immediately?
So she's answered it this way. I'm thinking another person for that. Let's move on from that, Mr. Alessi.
You made your own determination of the cause of death, correct?
Yes, that's my job.
Understood. And what I want to do is to pursue the basis of your determination. So you used the phrase brain impact injury.
Blunt impact.
A blunt impact injury. Have I got that correct?
Blunt impact injuries of head, yes.
Of head, right. And that's your conclusion, correct?
Yes.
Based upon your conclusion, did you make any determination as to whether the decedent would be able to carry out any purposeful movement after that injury?
Define purposeful movement.
Sure. I'm talking about the ability to perhaps manipulate their hands.
I don't know.
Did you make any determination as to whether they would be able to engage in any cognitive functions, meaning processing things and making decisions?
I did not make that determination, no.
Did you observe any pattern to the injuries to the head of the decedent?
A pattern? I observed that there were injuries to the back of the head as well as other internal injuries to the base of the skull, as well as the brain.
Your Honor, if we could please publish, I'm just going to check to make sure they're in. If we could, Your Honor, publish 160 that is in evidence. But before we do, Mr. Wolf, I would like to approach Your Honor and let you know in case there's anything further that needs to be done. Thank you.
Did you show it to Mr. Brennan?
It's already been agreed to as in evidence.
Okay.
It is in evidence.
Oh, it's in evidence?
Yeah, I just wanted to make sure if there was any statements that Your Honor wanted to make.
So why don't you come over here, because why don't you come over this side?
Oh, she's really not letting him use this witness to kind of vet and preview the other witnesses. Seems fair to me to be asking if she got, new information after the fact. You do, in fact, have the ability to change the manner, cause and manner of death determination. So, anybody brought any new information to you? We know this is a preview because we know that there are differences of opinion now. We have the Commonwealth's own expert saying, oh, this is a contre coup injury. We have the defense expert apparently saying not hypothermia. So maybe we just need a hypothetical. What would you do with that information? Not sure. Not sure why the judge is having such a problem here. Didn't she testify last time that the skull fracture was radiating, or did we get that from Stonebridge? I thought she said it was radiating from a point. I wish this were better illustrated because I'm trying to visualize in my head what she's describing when she's talking about, the base of your skull being the bowl at the bottom. But then she talked about the point of the laceration being on the occipital part of the skull. That's more like, back here, like right at the back. It's not on the bottom. So just, how do we reconcile these things? You're saying it appears that there's a connection between these. Seems logical that there's a connection between these, but visually from the description she's giving, I'm having a hard time seeing how that works. Anybody ask you if the ground caused an injury like that or could cause an injury like that? I'd like to revisit that concession she made during the first trial that these are not conventional motor vehicle collision, pedestrian collision injuries. Not what you normally see in that type of interaction. Feels like on this one, Mr. Alessi's gotten a little stuck in the weeds. It's hard to tell where he's going. And, some of that is Bev not letting him take it in the direction that he clearly wants to take it, which is to preview what is coming from the other experts. If it's posed as a hypothetical, I don't know why it would be a problem. Dr. Scordi-Bello, if you received information that A, B, C, D, E, X, Y, Z, whatever, would that change your interpretation of the cause or manner of death? Maybe. We're sort of halfway in between, like, I'm not sure if we're relying on the whole fact that she has to rely on law enforcement to tell her what the circumstances are. We've already established, law enforcement investigation of the circumstances was targeted. It was not following the evidence. It was confirming a specific theory versus does she have other medical evidence? Or how would that affect her? I just don't know.
May I, Your Honor?
Yes.
Thank you. With Your Honor's permission, I would like to publish Exhibit 160.
Yes.
Thank you. Dr. Scordi-Bello, if you could please draw your attention to what is depicted on both screens. Pick whatever screen is most convenient for you. And what I want to do is to go over what is depicted there, and I'd like to start with just some basics. What is that white rectangle that is on the photograph?
This,
Yes.
that's a ruler.
And what's the purpose of the ruler?
To show a scale. When I measure the injury, I use the ruler to document that.
And if you could please draw your further attention to what I will refer to, and you use your own term, but just to start it, the horizontal line that is appears to be a laceration. You know what I'm referring to?
This, yes, this is a laceration.
Right, so it's fair to say that that's a laceration.
Correct.
And just so we get all that's depicted on this, you referred to earlier up above that, the red area, and is that an abrasion?
Yes.
And do you also denote to the left, almost like a J-type item going vertically up? Yes, and going up. Do you see that?
Yeah, that I did not note that specifically. I just noted the whole injury as part of the abrasion.
That's my point. So you didn't make a separate note of what appears to be a J, and it might be easier to see it in the screen over there. It's your conclusion.
J,
is it more, is it easier to see there?
Yeah, I can see it.
Yeah, and so you didn't make a separate note as to what that was in your report, correct?
No, I did not.
Do you consider that an abrasion or something else?
I believe that's still an abrasion.
Do you conclude that that J is different in any manner from the abrasion that you've noted above the laceration?
I believe it could be part of the whole abrasion, or it could be something different.
Fair enough. Would a fall backwards on a flat frozen ground produce a circular and not a linear abrasion as depicted here on the back of an injured person's head?
Can you repeat the question?
Sure. Assume a fall backwards on a flat frozen ground. Would such a fall and impact present that type of pattern, or would it present a circular pattern, perhaps with something like a starfish in the middle?
I'll allow that. Can you answer that?
I can say that a fall backwards could very well produce that injury.
My question is more specific, and that is a fall backwards where the person impacts the back of their head on flat frozen ground. Would you expect that type of a laceration from that type of a fall? Not just a general fall backwards, but specifically a fall backwards where the back of the head hits flat frozen ground. Would you expect that?
I could, yes.
And under what circumstances could a laceration like that and an abrasion, all of it together, what circumstances could cause that type from a fall backwards on flat frozen ground?
Well, the laceration is due to the blunt impact, and so is the abrasion. The abrasion is friction. So depending on the type of surface, you mentioned flat frozen ground, it's quite possible to have an injury as the one depicted. There's nothing inconsistent with this injury and a fall on someone's on the back of the head with a blunt surface.
Is there, are you familiar with the phrase pattern recognition in medicine?
Yes,
And isn't pattern recognition something that requires training with regard to being able to recognize certain patterns and determining what could be causing that pattern?
yes,
And just merely recognizing whether there is a pattern takes certain specialty training, et cetera?
correct.
And isn't pattern recognition a principle that you apply in the medical examiner's office?
Yeah, we do.
And so example of pattern recognition could be a knife wound, correct?
Yes,
Could be a gunshot.
correct.
And there's certain patterns that you see on a decedent that can be consistent with those types of causes of injury, correct?
Correct.
You're going to try to get there again? She didn't give it to you. He's going to try again.
Assuming a fall backwards onto frozen ground and there being on a lawn with grass, would you expect to see any grass at all in the injury site?
It's possible to have grass.
Is it possible to have well, are you familiar with the height and weight of the decedent generally? And if you need to look at your notes, please do so.
Yes. Mr. O'Keefe was approximately 6'1" and 216 pounds.
So assuming a fall backwards and an impact ahead on, a ground with grass, a person who's 6'1", there is going to be significant acceleration forces that occur as they're going backwards. Is that correct?
That's fair to say, yes.
And therefore, the more acceleration forces, usually there's a correlation with the force of the impact.
Correct.
And in terms of force of impact and assuming grass on the ground,
Bigger they are, the harder they fall.
do you believe it's more probable than not that one would then see some grass on the head?
Sustained is deathful.
Given what you testified regarding the height of Mr. O'Keefe, and assuming what I just gave to you as a fall backwards and acceleration and forces, would you expect to see anything else on the back of his head?
You have to be more specific than that.
Right, I thank you. So would you expect to see, is it possible if that was the manner of the fall that there should be grass on the head? Is that possible?
Sustained.
She did already say, yes, it was possible.
Did you consider at all in your evaluation well, let me back up. Do you see any evidence of grass in this depiction?
No, I do not.
Did you recall ever seeing any evidence of grass when you were performing the autopsy?
I did not see evidence of grass.
Did you consider at all in performing your autopsy, whether or not grass should be present, given what was reported to you by law enforcement?
Sustained.
There's nothing wrong with that
Did you make any
question.
considerations at all regarding grass in regard to your autopsy report?
I did not see any grass. No, I did not make any determinations.
And was grass at all even a consideration in your analysis?
I had very limited information as to the exact nature of the surface at the time of autopsy.
So the answer is no to that
No.
question. Thank you. Did you have any information regarding the circumstances that you said you look at in trying to determine manner of death as to whether there were any stones or rocks around the scene?
That I did not have any information.
So meaning you didn't have any information, you saw no information that there were any stones or rocks by the scene, is that correct?
Sustained in that form.
What, if any, consideration did you make in your assessment of cause and manner of death with regard to stones or rocks?
I did not make any.
With regard to any other potential causes other than ground, did you consider any other possibilities that could cause the type of injuries that are depicted on the screen?
There's a number of possibilities that could cause the injury.
My question is, did you consider, not whether there are, but whether you considered them at the time you were performing the autopsy?
I'm always considering at the time of autopsy what could have caused a certain injury.
Did you put in your notes or your autopsy report any of those considerations? Are they documented?
No.
Now, in terms of differential diagnosis that we talked about, did you determine whether there were any other possible explanations for the injuries to the decedent other than what law enforcement presented to you?
I'll allow that.
Internally, I consider all kinds of other explanations. I have to look at the findings and the possible ways that those injuries could have been sustained and decide whether I have enough information and whether I am satisfied with the information that I have in order to conclude or determine a manner.
Did you make any notes at all about the considerations you were just speaking about, other considerations, any notes whatsoever in any document in your autopsy report?
Not in my autopsy report, no.
Did you make any other notes of those considerations in any document that you created for this case at all?
No, these are considerations that I've had and discussions I've had with colleagues in terms of evaluating these injuries and.
And I don't want you to go into what other people said, but I want you to finish your answer.
Right, no, I did not make physical notes of my considerations.
Your Honor, I'm going into a different category, so I just wanted to alert Your Honor to it.
All right. And
Lunch?
it will take more than 10, 15 minutes?
Oh, yes.
Okay.
Oh, yes.
We'll take the lunch and recess, so we'll see in about 45 minutes.
Rise to the jury.
45 minutes will be a little bit after 10:30 here. It'll be like 10:35, 10:40. We're here on the West Coast. Oh, yes, it'll take more than 10 to 15 minutes. Well, that's intriguing. So did she just completely contradict herself? She said, I'm always considering other possible ways that injuries were sustained. But he just asked her before that, did you look at alternative scenarios? alternative circumstances to explain what you're seeing. And she says, that's not how it works. I don't consider hypotheticals. I just state and describe the injuries. So I'm not sure if this is just a confusion about what exactly is being asked, but it sounds like that's a contradiction when he's asking her about the hypothermia and the reasons for the body being 80 degrees. And did you consider any other of those circumstances? She's like, that's not how it works. But when it comes to, how we get a laceration on the back of the head, she's like, well, I consider all kinds of explanations. So that seems a little bit inconsistent, but not entirely clear here. Well, I don't think he was expecting that answer about the injury to the back of the head, consistent with hitting the flat ground. I don't think he was expecting that. It seemed to catch him a little bit off guard. Let's just go ahead and back up to where we were when we came back from our break. So he brings in the scientific method. Love that. How do you not love that? Of course, it needs to be a scientific process. What scientific process? What is the scientific method grounded in? Say it all with me. Skepticism. You adopt a hypothesis and then you see if you can verify it or disprove it. And you obtain information that way. You don't make assumptions. Your skepticism until it is established. Oh, he's using that former Trooper Proctor title. That is so well deserved. Had that moment getting her to undermine the state's neurologist, the neurosurgeon who's going to come in and tell us about the injury. Like, what a ridiculous thing that such a person would do an autopsy. They don't have training to do that. Yes, we agree. Thank you for pointing that out. I'll go ahead and take the fan off because I'm pretty sure we're not coming back until after lunch at this point. The photo of the two people shown, she didn't recognize. It sure did look like Connor Keefe to the left and could easily be Trooper Proctor to the right, couldn't it? Couldn't it? So then she got the information from Proctor in March of 2022 about, roughly their theory, the scene photos and so forth. Based on her request for information about the investigation. She didn't have enough information at that point. So she had knowledge of the law enforcement theory, nevertheless reached undetermined manner of death. So could not find evidence more likely or not to confirm their theory versus another theory. I'm going to try not to slurp in the mic for you guys. But was there another theory? Like, she's so back and forth on, do you consider other theories or not? It's not particularly clear. We talked up Stonebridge, Renee Stonebridge. She's triple board certified. That is something that the witness, yes, I do in fact have personal knowledge of that. Brennan was trying to object to that, get that excluded. Oh no, she knows, and she is happy to sing the praises of Dr. Renee Stonebridge. But that did get cut off, I guess, at some point about what is neuropathology. She's not gonna let her. Bev is not gonna let Alessi get into previewing what a great witness Dr. Stonebridge is. Perhaps the Commonwealth isn't going to call her, and they're just going to call their own neurosurgeon. That's the issue. So we came back after that sidebar And all we got then seems whatever the objection was sustained. We came back to Azif Wolf, and she's not aware of Azif Wolf. That is the neurosurgeon for the Commonwealth. So then we got into this temperature of the 80 degrees in the snow. She concluded after the autopsy, because there were findings, did she consider other reasons for the body being 80 degrees? And the answer was no. Well, sepsis can produce hypothermia. I didn't understand what this was getting at. He then introduced this like differential diagnosis idea. Differential diagnosis is a rule out process, right? If you have like 6 possible explanations for a thing, then you go look for reasons to rule any of them out. At least that's kind of my understanding of how it is. And so once you rule out 5 of them, you're left with the one, and then that becomes your final diagnosis. I may be wrong about that, but that's just kind of my layperson understanding of it. Kind of went down on this like angle with the differential diagnosis to talk about the hypothermia. She says that she concluded there were hypothermic changes to his body. And then we got caught up a little bit on those can occur without the cause of death being hypothermia, but not without hypothermia itself. The primary cause of death was the blunt impact injuries to the head, but the secondary was hypothermia based on actual anatomic findings she can see with her eyes. And they're consistent with hypothermia. So it didn't really spell that out. And it wasn't clear where he was going with this. I thought he was going at, well, isn't a possible reason for somebody's temperature, a dead person's temperature being 80 degrees because they died before, time of death. The algor mortis is the natural cooling of the body after death. Isn't that an explanation for why a dead guy would be 80 degrees? It seems like it, but he didn't go there. So I don't know. I don't know if that's what the point was of that. And instead we just got into, did you consider whether John O'Keefe could have died somewhere other than where he was found? That was objected to. It was sustained. Mr. Alessi was annoyed. Can we approach? And she's like, in a bit you can, but for now you're going to move along. So she doesn't let him approach on that. She's not allowing them to ask these general, like, did you consider this? Were you aware of it? It's like a similar thing that she did with Yuri Buchanan, where we didn't get to ask him in front of the jury, are you aware of all of Michael Proctor's text messages with his friends? Because he's not, they did the voir dire to determine that he's not. And so I think this is kind of a similar thought process where she's like, well, absent any evidence that she considered that circumstance, let alone other circumstances, he doesn't get to answer it. He doesn't get to ask it. And I think that's consistent possibly with that little comment that she made about that's not an evidence. There's no evidence of that. And that was him asking the question if she had requested any alternative, theories, explanations, circumstances beyond finding John O'Keefe in the snow. She said no. There was the objection that kind of overrode the answer, but the answer was out. And Bev just says, so there's no evidence of that. Well, yes, there's no evidence that she considered that. Is that what that comment was about? Or is she saying there's no evidence of alternatives as far as hypothermia? It's very, very unclear. And it's not helped by the fact that they don't get to explain the objections and talk them out. So this is the point where she said, he's asking, did you consider other circumstances? Leading up to that determination, she's like, I don't, that's not how it works. I don't consider alternatives. I don't consider hypotheticals. Well, but then you're going to go on later and talk about how you're always thinking about alternatives. So this was all very confusing because it seems to be a mix of like, there's this cause of death secondary cause of death determination. There's the physiological changes she says she was able to see. There's the body temperature. And then there's the circumstances he was found outside in the snow at 6 a.m. I just don't feel like Mr. Alessi really was able to kind of clarify where in the intersection of those things is he directing his questions. And so for me, I found that confusing. It wasn't clear on where he was going with that. Asked if the blunt impact injury to the head would result in him being unconscious nearly instantaneously and with death following shortly thereafter. That sounds like he's reading from another report, probably his own expert's report. She says that's very possible, but she would not be able to say how quickly it would render him unconscious. And Bev now is at this point, continuing to tell him, you need to move on. You need another person to establish that. So I think what's happening here is that he is trying to confront, I guess, his own expert with Dr. Scordi-Bello. Like, Dr. Scordi-Bello, here's the findings my expert has. What do you think about that? Like, just generally speaking, that's kind of what he's trying to do. And so I think that's why Bev is sustaining it, because his expert isn't in evidence yet. We don't know. So she's not letting him like pre-vet his own expert's theory. I say this because I have to think that's why he went into the pattern of the head injuries and what sort of pattern you would expect from a fall flat onto a flat ground, and would it be different? And she's like, no, this is very consistent. Yes, she could expect that laceration. Depending on the surface, yes, it's consistent. I don't think that's the answer he was looking for or expected. This just goes to the risk of, if you don't know the answer, is that a question you want to ask? You might get in the habit maybe of assuming if it's obvious to another expert, it will be obvious to this one, but they argue with each other all the time. That's why there's a whole market for expert witnesses and stuff. People can have different opinions about things all the time. So it sounded like he thought it'd be really easy for Scordi-Bello to buy into this argument that he's making about just the structure of the injury itself and what that could tell you about the nature of how it was inflicted. But she did not agree. She did not see it that way. I don't think he was expecting that. I expect they have their own expert, to be able to testify to it. And that's why he brought it up in the first place. But so then he got into the pattern recognition. You need special training to do that. Possible that you would see grass in the injury site from a fall backward onto a frozen lawn, but would not go so far as to say, probable, just that she didn't see any grass and it was possible that there would be grass. Then the acceleration forces, increases the force of the impact. The bigger they are, the harder they fall. That's the principle he's getting at there. John is 6'1". He's a longer lever, so to speak, when he falls over and hits his head than somebody who is 5'6". Falls a longer distance, than that little short one. So more time it takes to fall, more acceleration, greater force of impact. And I think he's trying to use that to suggest, therefore there would be grass in this injury. His expert probably thinks that. But judge is not letting him get into whether she considered whether grass should be present. I don't know, hypotheticals. Sometimes she thinks about them, considers them. Sometimes she doesn't. Don't know what exactly the problem is here. She had no information about rocks or stones by the scene, and she's considering any number of possibilities. Now she's considering all kinds of possibilities about what could cause an injury. And she didn't document any specific alternative scenario that she considered in her report. Not the best performance we've had from Mr. Alessi so far. I think he is getting a little in the weeds somewhat. He's got an idea in his head about the relationship between things, but I think he's not maybe articulating it as well. It's just not clear. It's not clear where he's going with some of this stuff. And then I think some of those answers that he's relying on his own expert to ask her about, but she is not agreeing. So a little bit of, doing the Commonwealth's work for them. Okay, when my expert comes out and says this, they're already going to know, well, the Commonwealth's medical examiner, Dr. Scordi-Bello, she doesn't agree with that. So that might be a misfire in terms of the strategic decision making. It's always a gamble to ask that question you don't know the answer to. You can make an educated guess on it. And I think the more trial experience you have, the more likely you are to riff on things like that. But in this particular case, not looking like a gamble that paid off. Don't think he got the answer he was hoping for and expecting. All right, guys, I will take my quick break at this point. Go, you know the routine. Go check on all the animals and the trees and everything. It has been windy this morning. So once again, kind of a constant around here. It tends to really dry the trees out more than anything else. So probably going to need to give them a good water. But then I will be back. Looks like we got probably, 20, 25 minutes left. I should be back shortly. We'll see if we can get to some of your comments and questions before they get back into session. So thanks you guys for hanging tight, and I will be back shortly. Hey guys, we're back. Thanks for waiting patiently. Appreciate that so much. The trees, again, just very dry right now. Taking a long time to get everybody back fully saturated in the pot. Yes, we're all still recovering from the Brian Higgins texting. Before I turn to your comments and questions, there is something that several people brought to my attention. And I wanted to go ahead and bring up, see if you guys can see this. From Brandy Churchwell, great follow, great deep dive source of information on this case. So Trooper Connor Keefe said he went to the autopsy alone. That don't look like alone. Very interesting. We're going to listen to it because I didn't.
You attended the autopsy of
remember.
John O'Keefe on January 31st of 2022. And with regard to other members of your unit, you were the only one to attend that autopsy?
Yes.
That was done at the medical examiner's office?
The medical examiner's office in Sandwich, Massachusetts.
In Sandwich, Mass. And it was Dr. Irini
Only member of his
Scordi-Bello
unit
who performed the autopsy, correct?
Only member of his unit that was there. And the detectives unit at the Norfolk County District Attorney's Office, that is also Proctor, is it not? So I think she might have caught something there. They're still over at lunch, so just getting it ready to go back. Good catch. Very good catch. He was the only member of his unit present. If that was also Proctor in that photo, that would seem to be incorrect. He and Proctor were both part of the detective unit attached to the Norfolk County District Attorney's Office. We'll see. See if anything comes of that. Guys, let's look at some of your questions and comments while we're here. My Mini 67, the heroic hair. Andrea, I do believe you've solved the case. Thinking back to when I lived in rural Alpine France, I was reminded that tooth marks, gum material, and pig DNA would be death by wild boar. They have death by wild boar in like Texas, I think some parts of the Southwest. They have a wild pig problem here. We don't have wild pigs up here, so not something that I have personally had to run into. But oh yes, that was a great question during the first trial when that pig DNA hit. So was he mauled by a wild pig? Is that what we are to take from the Commonwealth's case? Did they provide any explanation of the pig DNA? No, of course they did not. Of course they didn't. They just pretended it didn't exist. Wasn't a thing. Any reason why pig DNA would be on a taillight? None that I can think of, and certainly none was offered. But yeah, that keratinized tissue, it just adds to it, doesn't it? No, it's not only in your gums. Like, yeah, okay, could be something else, but just go Google it. Go Google it. What's the first thing you get? Oh yeah, it's gum tissue. It's like the most common result. Alyssa Ramirez, this witness sent the swabs to California for the dog DNA testing. Yeah, Maureen Hartnett did. She took the swabs, but didn't do the testing herself. Same thing with the hair sample. They have the root of the hair is one sample, goes to their own DNA in-house. Then the shaft of the hair is a second sample. That was sent out for the mitochondrial DNA testing. She did not do any of that testing herself. K-Dub, I'm a bit behind, but the keratinized tissue, you are brilliant, Andrea. I don't know about that. I just saw it in my notes. I was like, I wonder what that is. Let's look at that. And lo and behold, hey, wow. Who knew? Who knew? Just happened to look back on Maureen Hartnett's testimony from last time because I was so excited about starting the day with an Alessi Cross. Like, what is the day going to bring? How was I to know that I'd get a second? And there's a lot more than 10 to 15 minutes when we get back after the lunch. So eager to see where this goes. Greg, anyone else notice the video started working a lot better after the SUV magically showed up? It was doing that, like when you had the old school analog TV, you know, with the antennas and you get a bad signal and it like feeds, you know, like feeds through the screen kind of. But then you jiggle it and it fixes it and it stabilizes it. That's what it reminded me of. Yeah, it did seem to stabilize a little bit after the SUV was in there, didn't it? Sabina D, when snow melts and the water runs down, it takes things with it. Even if the hair stuck there in the end, it may have been moved from a different place. Yeah, good point. Good point. Could have just, you know, been on the top. Been somewhere on the top of the car. Snow, water melts it. It tracks down. That might even be, you know, what got it to stick there. A little bit of water adhesion. Oh, I forget. I'm not so good at my my fluid mechanics, but there's some word for that. The principle of water. It's not the capillary action, but just you know, the water is attracted to other water. It's hydrophilic. Can't remember the exact word I'm looking for, but anyway. So if there's, you know, water on the hair, water on the car, and those water pieces touch, they're gonna, you know, be inclined to like stick together. I don't know. I really don't know. I don't have a very good explanation for this hair at all. And the bottom line is it's the Commonwealth's burden to explain the hair. How exactly, if you want me to put any weight on this. So we'll see if maybe the accident reconstructionist has something to say about that. TL Haddix, there's snow on the floor before Karen's vehicle is there. No snow on top of her car once it's on screen. Where'd the snow on the floor come from? I did not notice snow on the floor in that particular video. It is such poor quality. So I would have to take your word for it. The second view that we had of the Sally Port, the one where we see it pull in, but it's the mirrored view. I don't recall any snow on the floor on that one, but don't really see the same things in both the videos, do we? I mean, we don't see people getting in and out. Now, granted, it's the wrong side, but yeah, nobody going up near the passenger taillight. Not sure that we see the same things on both videos, so it's strange. More video issues. Law and Lumber leading a question that by its phrasing suggests the answer. Example, you'd agree Hank can't ask not leading questions, right? Indeed I would, Rob. Indeed I would. He has a real hard time asking open-ended questions. It's undoubtedly a lifetime habit from being a defense attorney. You're usually spending your life on cross-exam. Cross-exam, you get to ask leading questions, so it just becomes a habit. But the problem is then if you found yourself in a different pair of shoes with a different role to play, you're going to have to break that habit because you're not allowed to do that when you're directing your own witness. Rob and I have a little dispute. We've had a little dispute about the yes or no questions and the extent to which they can be characterized as leading. I am a purist. I am of the opinion that it's only leading if it suggests the answer. So just asking for yes or no is not leading because you can freely choose which answer is correct. But some courts, and I believe our Rob as well, may take a little bit of a different view on the yes or no, that it's like too directed, too restrictive when it comes to the witness being able to answer the question, and that makes it leading. I don't want to put words in his mouth, but yeah, we've had a little toe-to-toe over that one before. No grudges, none at all. None at all. We are on the same page about this one. No question. And Cat 100, HB, don't underestimate the seductive power of a decent vocabulary plus tense plural accuracy. I'm perplexed how Hank Brennan and others got through school. I don't think Hank is a dummy by any stretch of the imagination. I think he's very sharp. I think he's very sharp. But I think he is also, what I would describe as canny, wily like a fox, the kind of smart that you get from figuring out how to get out of a trap, not the kind of smart that how do I anticipate the trap, foresee the trap, avoid getting in the trap in the first place. But, this is a smart way to figure out your way out of it. I don't think he's a dummy at all.
Followed by pound.
Mr. Lowley, I might have some questions. But you'd be surprised at how low the bar is to be a practicing lawyer sometime. Greg, if I remember correctly, the proficiency test was kept out last trial. Could be why it didn't come up last time. I did have it in my notes. I think it did come up. They brought it out on direct because I think he knew it was coming. So I think Alessi or Lally took the sting out of it. He brought it out on direct. So he was able to explain, here's what the problem was. I didn't recognize that there was a root on the hair. And so then my supervisor sat down with me and we looked at a lot of hair and they showed me what to look for. And then I took another proficiency test and everything was fine. So I just think it's not particularly good evidence. Who cares? Like, if we were worried about, is this a hair or not a hair, then maybe it would be an issue, but it's not an issue here. And so it tends to look perhaps a little bit nitpicky. Jennifer Devine, she is my hero. She is a strong woman who takes no crap. You are going down real bad quick if you're going down bad real quick if you try. I think you're talking about Scordi-Bello. Scordi-Bello was not going to get pushed into making a determination of the manner of death that she didn't agree with. And so I have to respect that. I have to respect that. She is happy to explain her position. She doesn't seem to be shy about taking a position. She seems confused sometimes about some of the questions, but I can kind of understand that because they have been a little bit awkward. We got into that little bit of a morass with the hypothermia and the cause of death and the changes and what exactly are you asking? It's just not clear. Just not clear. But by and large, she does seem, pretty confident with herself and her skills and her ability to back them up in a court of law. So I do have to respect that. Willow's Angel, Andrea, you are by far the best channel to watch. You provide the best info commentary and you make me smile. Well, thank you so much. What a nice thing to say. Bring a smile to my face. Glad you enjoy your time here. We just, do our best to make it a little bit more familiar, more comfortable. Not something we have to, stress and get all anxious about watching a trial because we don't understand what's going on. No, nah. This is my universe, guys. I'm happy to share my experience of it with you and hopefully make y'all a little bit more comfortable with what you're watching. Mike, your coverage is amazing, Andrea. If a not guilty verdict is delivered, it would be great if you had Alessi on for an interview. Everybody is going to be seeking interviews from everybody. I do enjoy Mr. Alessi and his skill. I don't really do interviews on my channel. I never have, And 2 guests ever had that show we did with Daniele Bolelli on the Standing Bears Writ. And that wasn't really an interview. It was more of like a joint storytelling. And then Ian came on during Delphi when we had the ballistics, what passed for ballistics evidence there in Delphi, since Ian's the gun guy. So I wouldn't rule it out, but it would be a shift in speed. For sure. But I'm not going to say no. I'll think about it. Quick recap. We got through Maureen Hartnett, the lab analyst, and we are now on Dr. Scordi-Bello, the medical examiner. We are in Cross. Cause of death manner of death is undetermined. We're debating some of the details of the hypothermia and head injury and so forth. And that's pretty much where it's been left off.
Excuse me, please.
A pig foot dog treat would have pig DNA and keratinized tissue. Yeah, it could. Keratinized tissue in the like trotter part of the hoof. That could be it. Don't know if we know. Can't quite tell what we're waiting for. Yeah, pig's ear are probably a little bit more likely. Like those are very, very common dog treats. You can get pig's hooves. I don't know that I've ever fed those to my dog. I'll go get like a good raw bone sometimes. I like a good knuckle bone. If you can get like you know, the end of a leg bone or something like that, they can chew it open, eat all the marrow out of it. That's pretty common. Pig's ears, very common. Not sure pig's trotters are super common, but you can probably find them. Dr. Winston Squeakerson seems like the person who would know that you can get dried pig feet and pig snouts. Yeah, I believe you can. I believe you can.
Other water, I'm good. Thank you. Want to know the bathroom break.
Scores of session, please be seated.
Frozen chicken feet I've never done, but I'll do chicken necks. Chicken necks are a good
Alessi,
one.
whenever you're ready.
Thank you, Your Honor. Good afternoon, Dr. Scordi-Bello, and welcome back.
Thank you.
I want to move on to a slightly different aspect of the hypothermia discussion. So you've acknowledged previously that hypothermia is a very difficult diagnosis to make, correct?
Correct.
And you acknowledge that in your grand jury testimony in this proceeding, correct? Do you recall that?
I do.
And
Clean it
you
up. Where are we
indicated
going?
in that grand jury proceeding, generally that diagnosing hypothermia is based on contextual clues. Is that correct?
On autopsy findings and investigative information, yes.
Right. And the last part, investigative, and that's that legal part, sort of the law enforcement contribution. Is that correct that you're referring to?
Correct.
You diagnosed Mr. O'Keefe with hypothermia based upon certain medical data that you believe you observed in the gastric area and the pancreatic area. Is that correct?
Correct.
And just for, I think most people will get this, to just be clear, gastric is sort of synonymous with the stomach.
Stomach.
And then we know the pancreas is a separate organ. And in your autopsy, you observed for example, the lining of both the stomach and the pancreas. Is that correct?
I'm sorry, what was the word you used?
Let's start with the stomach. Did you observe the lining of the stomach as part of Mr. O'Keefe as part of the autopsy?
Yes, I observed some hemorrhages in the lining of the stomach.
We'll get to that, right? But I just want to talk about the organs and what aspects of the organs first, and then we'll get to that. And with regard to the pancreas, what aspect of the pancreas did you observe?
I examined both the external surface and the tissues around it, as well as the pancreas itself by making several cuts.
And there was also a histopathology report that was relevant to both the stomach and the pancreas, correct?
Correct.
Histopathology,
Spell it, Mr. Alessi.
histopathology. So that histopath information informed your hypothermia analysis, is that correct?
The histopathology was done to further confirm my finding or my determination of hypothermia.
So do I have it correct? And let's start with the pancreas. That you noted the pancreas was congested and diffusely hemorrhagic. Do I have that correct? And you feel free to look at your report, please.
Who else did, Allie? Guess who else won 5th grade spelling?
And I specifically, if it helps, I'm
Yes.
looking at the report of autopsy. It's not numbered pages, but it would be 4. And you see liver, gallbladder, and pancreas is 1. And then you go down a couple more and you see digestive system. That's what I'm focusing on.
Okay.
And the next page is the histopathology.
Yes.
All right. Are we sort of oriented in the same location?
Yes.
All right. So let's start with the pancreas. So if you look at the histopathology page, it says endocrine and exocrine pancreatic tissue with vascular congestion and patchy parenchymal, that's parenchymal hemorrhage, autolytic changes. Did I read that correctly?
Yes.
We're all losing the spelling bee in this
I want to
exam.
go at these one at a time, so I'm going to jump back to the previous page where you discussed the heading liver, gallbladder, and pancreas. Do you see that?
Yes.
And you see the last sentence says the pancreas is congested and diffusely hemorrhagic. You see that?
Yes.
So now what I'd like to do, and is that what you're rooting in, if you will, the analysis of hypothermia?
The determination of hypothermia was made, yes, based on these findings and the circumstances that was provided. Yes.
Right, and thank you. I'm going to get to the circumstances, but it's sort of the medical legal construct that we were talking about. I want to just start first with the medical, if that's okay with you.
Yes.
So then let's now move to the organ of the stomach, a synonym gastric in terms of your report. So let's go to, please, back to the histopathology section. And under that, under pancreas is stomach. And there's a bulleted one sentence that says gastric tissue with vascular congestion and focal mucosal hemorrhage. Did I read that correctly?
Yes.
And then let's go back, as we did with the pancreas, for the stomach, go back to the previous page in your report under the heading digestive system. And the second sentence states the gastric mucosa shows focal areas of linear hemorrhages. Did I read that correctly?
Yes.
So we've got hemorrhage discussion with the pancreas. We've got hemorrhage discussion with the stomach and the gastric area. Your diagnosis of hypothermia was not based just on gastric and pancreatic hemorrhaging alone, though, was it?
No.
And you did fairly refer to other circumstances just moments ago in your answer, correct?
Correct.
And we're going to get to that. So that means that your diagnosis of hypothermia was also informed by the information we discussed earlier that was provided to you by former Trooper Proctor in his investigation. Is that correct?
Correct.
And
Good.
one aspect of
Hang it on
that
Proctor.
information is that he was found, Mr. O'Keefe was found in the snow, correct?
Yes.
So let's go to the death notification report. Am I generally correct that you were, I'm sorry,
Rephrase it.
I will. Thank you, Your Honor. Do you recall the death notification report in this matter?
I do recall, the very initial first information that comes in. That's the death notification given to our intake staff.
Do you recall the contents of that death notification report?
Would you like me to summarize? I don't recall I don't have it in front of me, but I can tell you what the gist of it was.
Would it be helpful to you if I showed you a document that might refresh your recollection on what that, a document that may refresh
She
your
said
recollection?
sure. I
Thanks.
think you heard her.
I did. Thank you, Your Honor. May I approve?
I was trying to rush him through. Cut him off. She said yes.
Yeah, Aperture.
Yep,
Thank you.
show Mr. Brennan.
Yeah.
Yes.
Dr. Scordi-Bello, what I'd like to do, you can read anything you want, but I'm just going to reference to the section that says circumstances of death.
Yes.
What I'd like you to do is read it to yourself, not out loud, and then when you, just that section up to here. And once you're done, if you could kindly look up and let me know.
Okay.
Classic refreshing right there. Read it quietly to yourself, and when you're finished, look up and let me know. This is all refreshing. This is not impeachment. This is refreshing. Different technique. And this is to get her to say what is in the report that he wants her to say. And what does it say? I don't know. Maybe that he was hit with a glass, something like that. Fist fight. Something about the circumstances he wants us to know about.
Dr. Scordi-Bello, did that refresh your recollection with regard to the circumstances of death section of the death notification report?
Yes.
And you could please state now what your refreshed recollection is on that topic.
Yes. The initial intake death notification was made by a physician at the hospital. And it stated that we were dealing with a adult male that was found in a snowbank. There was note of having been at a party. There was some information as to the decedent was walking to a house. There was reference to some sort of altercation or dispute with
Sustain.
Strike.
Jurors, disregard that. Move on with this, Mr. Alessi. With this, but just move on.
Yeah, yes. In terms of the differential diagnosis concept that we were talking about before, based upon your refreshed recollection of circumstances of death as discussed in the death notification report, based upon that, did you consider whether Mr. O'Keefe could have been injured and died somewhere other than the front lawn of 34 Fairview?
I'm going to allow that.
Good. Foundation is in. Based on the
Initially,
information
no.
you had.
Let's go to significance, if any, of hemorrhaging of the two organs we were talking about, the pancreas and the stomach. Is it correct that the hemorrhaging of a pancreas can be caused by many different things?
Yes, it is.
And to be clear, you found evidence of hemorrhaging of the pancreas of Mr. O'Keefe in the autopsy, correct?
Correct.
And is it correct before the grand jury, you yourself were evaluating whether the injuries had been sustained in a different environment? Well, let me ask it this way. Do you recall what your testimony was in the grand jury about hemorrhaging of the pancreas and possibilities of injuries being sustained in different environments? Do you recall any testimony on that subject?
All right, I'll see you at 10.
So, I think he may be running into a little bit of an issue with the basis. He's trying to get into what she did and the basis for it. I don't know, guys. I'm just I can't follow whatever the thought process is here for why we're having sidebars and why he's not being allowed to ask these questions, because they seem perfectly reasonable. You get to ask the expert about their analysis and what they evaluate and what they didn't evaluate. Oh, are we going to lose NBC 10 again? Just going to sit and buffer for a little bit. Hopefully that doesn't freeze on us. With the death notification, told the jurors to disregard that, the circumstances of death. Why? Well, I guess because she thinks it's being offered for a hearsay purpose. Adult male found in the snowbank, been at a party, walking to a house. There was an altercation or a dispute. But it's not necessarily okay. I don't know what just happened. I think NBC lost their feed. So let me do what we had to do yesterday. Find the other stream, see if it's still on. Okay, it does seem to still be on the other stream, or on the other screen, so where we're at
Significance, here, if any, of hemorrhaging of the two organs we were talking about, the pancreas and the stomach.
We're talking about that. And I think they have just gone to sidebar. I think we are just waiting for sidebar right now. They're still chit-chatting about why ever Mr. Alessi is not being allowed to ask these questions. Okay, so I have a little bit of an idea. We will look at it maybe after we get closed with the court for the day. But I'll just read it out to you. It's Rule 703, Massachusetts Guide to Evidence. Bases of opinion, testimony by experts. And so it says the facts or data in the particular case upon which an expert witness bases an opinion or inference may be those perceived by or made known to the witness at or before the hearing. These include A, facts observed by the witness or otherwise in the witness's direct personal knowledge. B, evidence already in the record or that will be presented during the course of the proceedings, which facts may be assumed to be true in questions put to the witnesses. And C, facts or data not in evidence if the facts or data are independently admissible in evidence and are a permissible basis for an expert to consider in formulating an opinion. So here's why this matters. There's a little bit of a note. There's several notes often to these rules that explain, a little bit in further detail what it means, what the law, what law it's derived from and stuff. And so what the note is pointing out is that Massachusetts is different from the federal rule. In the federal rule, an expert can rely on anything that the experts say they can rely on. If it's something that you reasonably rely on in that field as an expert, you can rely on it in formulating an opinion. Massachusetts is different. Massachusetts law requires the facts or data underlying an opinion to be admissible, even if not actually admitted. So your opinion isn't supposed to be able to be based on hearsay. But the problem is it is. Like necessarily what she's doing based on how she's described this process of doing the medical legal investigation.
Yeah,
she's
Your
got to
Honor.
take hearsay from the cops.
At the grand jury, did you testify as follows? If the injuries had been sustained in a different environment where the temperature wasn't that low, then there might have been an alternative explanation for those gastric and pancreatic hemorrhages. Do you recall that?
Yes.
Hemorrhaging of the pancreas can also be caused by blunt force trauma, correct?
Correct.
Hemorrhaging of the pancreas can be caused by CPR, correct? Cardiopulmonary resuscitation.
It's possible.
Do you know what a Lucas machine is?
Yes.
And a Lucas machine is an automated CPR machine, correct?
Correct.
And it's a rather large device, correct? It gets strapped down to the chest of someone. So instead of someone having to exercise, etc., you put on a Lucas machine that goes over the chest and it automatically does the compressions, right?
Correct.
Lucas machines can cause hemorrhaging, correct?
Yes.
And in fact, wasn't a Lucas machine applied to Mr. O'Keefe?
I believe so.
And wasn't the Lucas machine applied from when the first responders came to the scene and he was in the ambulance continually and through when he was in the hospital?
I believe so, yeah.
So when a Lucas machine is used in resuscitation efforts, you'd actually expect to see some hemorrhaging, wouldn't you?
Where?
In the stomach, in the pancreas? Would you expect to see it there?
Not in the mucosa of the stomach and not as extensive in the pancreas.
Let's talk about and pick the pancreas first. So you would agree that from the use of a Lucas machine, you would expect some degree of hemorrhaging in the pancreas, correct?
Not always.
But it's certainly possible that a Lucas machine causes hemorrhaging of the pancreas, correct?
It's possible.
And now let's move to, and there was evidence of hemorrhaging in the pancreas of Mr. O'Keefe, correct?
Correct.
Now let's move to the stomach. Isn't it possible that a Lucas machine could cause hemorrhaging in the stomach?
Personally, I have not seen it in that context.
But do you rule that out?
I can't rule it out. I can only tell you my experience.
So your personal experience is you don't believe you've seen that, but you can't rule out that a Lucas machine causes hemorrhaging to the stomach. Is that correct?
I don't believe a Lucas machine causes hemorrhage to the mucosa of the stomach.
Right. I'm not yet at the mucosa of the stomach, which is a subset of the stomach, right? You're talking about the gastric rugae.
Talking about the inner lining of the stomach.
Inner lining, and another name for the inner lining of the stomach is the gastric rugae, R-U-G-A-E, correct?
Yes.
So I'm just talking about the stomach in general, not a subset of the stomach. Is it possible that a Lucas machine could cause hemorrhaging in the stomach?
Not in the stomach, around the stomach, in the soft tissues of the torso.
Okay. So you've said that you're aware that Mr. O'Keefe was hooked up to a Lucas machine, correct?
Yes.
And are you aware of the length of time that Mr. O'Keefe was hooked up to a Lucas machine?
No, I am not.
Do you know how many compressions per minute a Lucas machine causes?
I would have to say close to 60.
Would 100 compressions per minute be a reasonable amount of compressions for a Lucas machine to cause?
Sure.
So assume 37 minutes of a person hooked up to a Lucas machine, and assume 100 compressions per minute. That would result in 3,700 compressions for a Lucas machine, correct?
Correct.
Sounds like a lot.
Could 3,700 compressions from a Lucas machine explain hemorrhaging in the pancreas?
You could.
And that explanation could be why there's hemorrhaging in the pancreas as opposed to hypothermia causing hemorrhaging in the pancreas, correct?
Possible.
Did you consider that at all in your autopsy report, the effect of the Lucas machine? Is it written anywhere in your autopsy report?
I do consider changes due to cardiopulmonary resuscitation. The rib fractures that were observed were attributed to CPR. Usually we will see some amount of hemorrhage in the soft tissues, but in this context, with the gastric findings, the pancreatic findings, and the information that he was found in the snow with a body temperature of 80 degrees, my opinion was that those hemorrhages, along with the gastric hemorrhages and his body temperature, were consistent with hypothermia.
My question was, does your report state anywhere the words Lucas machine?
No.
And you agree that a Lucas machine could cause hemorrhaging to the pancreas?
It can cause hemorrhage in a lot of tissues.
But including the pancreas?
Including the pancreas.
If you see hemorrhaging of the pancreas,
We'll talk about this,
and
Ashley.
you believe
I'm going to star it.
that hemorrhaging is a contributor to hypothermic deaths, wouldn't you also expect to see Wisniewski ulcers?
I did note gastric hemorrhages.
So the court reporter needs to have a spelling of that. Doctor, can you give us the spelling of that?
Would you like to give it?
If you'd like me to, I'd prefer
Go
to do
ahead.
it. Thank you. Wisnewski.
She didn't know how to spell it. She just
So-
went ahead and let him do it.
Can you just tell the jurors what Wisniewski spots or Wisniewski ulcers are?
Wisniewski spots are small hemorrhages, small areas of bleeding in the mucosa of the stomach that are thought to be associated with hypothermia, among other things. They're believed to be either a reaction to stress due to the hypothermia or some form of what we call reperfusion injury.
Is it correct that if someone is believed to die, at least in part, from hypothermia, that in 90% of the cases of death from hypothermia, you would find Wisniewski's ulcers?
I do not know the exact number.
Is it that you're not recalling what the percentage is for the percent of cases for death of hypothermia that you would expect to find Wisniewski's ulcers?
I don't.
Do you recall?
Hold on.
Okay.
Move on. The objection sustained. So
Okay.
you're asking it. Yes, go
Okay.
ahead.
Thank you.
He's trying to refresh her, see if she's able to be refreshed.
There were no Wisniewski's ulcers present in Mr. O'Keefe. Is that correct?
I believe there were.
Can you point anywhere in your autopsy report where the word Wisniewski appears?
I did not call them Wisniewski spots. I called them gastric hemorrhages.
Right, so you didn't use the term Wisniewski and you didn't use the term ulcer, correct? In your report at all?
No, I used gastric hemorrhages under the title of hypothermia.
Do you believe that all hemorrhages in the pancreas are Wisniewski ulcers?
No, it's the stomach.
You mean the stomach?
I want to start with the pancreas.
Wisniewski ulcers are, the term is used to describe the gastric hemorrhages.
Right, so I wanted to clarify that. So now I want to move to the stomach.
Okay.
Do you believe all hemorrhages in the stomach are Wisniewski ulcers?
Not all of them.
Therefore, there can be Wisniewski ulcers and not be hemorrhaging, correct? Just by logic?
And not be hemorrhaging?
Correct. You can have a Wisniewski ulcer but not have hemorrhaging.
You could, but ulceration would manifest in what we call hemorrhage, the actual appearance of it.
What I'd like to do now is, Mr. Wolf, what has been in evidence, what I'd like to do is to, with your Honor's permission, publish some depictions of first the gastric mucosa, and then start with that, Your Honor, publish that.
All right. So this is the one that we have not introduced into evidence openly, but it's sidebar, right?
What I'd like to do is I'll start out with the one that is in evidence, which is the gastric mucosa.
Okay.
Start with that.
What number?
I don't know. He gave her a big stack of things. Brennan did. Big stack of photos and said these are autopsy photos, right?
Your Honor,
Okay, so that was the one I was referring to that we did at sidebar, not in open court. Okay.
Yes.
It's for identification. It's N for identification.
Well, it's all
And I'd
about
like to,
identification.
move into evidence at this time.
All right. All I'll say about this, jurors, is that this may be considered graphic. You satisfied with that, Mr. Alessi?
I'm satisfied with that, Your Honor.
Okay, Mr. Brennan, you satisfied with that?
Yes, Your Honor.
Okay.
Exhibit 164.
May I, Your Honor?
Yes.
This is graphic, huh?
Dr. Scordi-Bello, I'm handing you
We're not going to show it to us.
Exhibit 164 in evidence, and I'm going to also, with the court's permission, have it published on the screen. So whatever one is best for you to look at the screen, please feel free to look at either one. Mr. Wolk, if you could publish 164.
I mean, you can kind of see it where she's holding it and where he held it.
Dr. Scordi-Bello, do you recognize 164 as the, well, you describe what 164 is.
This is a picture of the stomach of Mr. O'Keefe after it was removed and opened and the contents were removed. And what you're looking at, this pink red surface, is the mucosa. That's the lining of the stomach. And you had used the word rouillé before. These are the folds. The stomach has a lot of folds. And what you can see here are small areas that are redder than everything else. That's hemorrhage, that's blood. And these are the gastric hemorrhages that I described.
Right, so those are what you just showed. There's darker areas, there's just a few of them. That is what you refer to as hemorrhages, correct?
Wisniewski's was correct.
Well, you didn't use Wisniewski's in your report, correct? You referred to them as hemorrhages.
Correct.
Okay, so what I'd like to do now is to, if I may approach, Your Honor?
Yes.
For the chalk.
He's going to time of death, guys. He's challenging hypothermia. How long has John been outside?
Scordi-Bello, the chalk that's marked for identification.
That's why I
and
think
let's
this
see what she
matters.
answers before we use it for more questions, okay?
Yes. May I hand it to you?
Yes.
Dr. Scordi-Bello, could you
That's
please
why it matters.
take what's identified as Exhibit N and see if you can identify what that depicts?
Yes, this is a picture of a stomach, again, the mucosa with hemorrhage.
Oh, for the siren. They're going to the time. How long was John outside? That's why I think this
Your Honor, can we
matters.
take a break?
Yes.
Jurors.
Yes.
Rise to the jury.
Yes, we're taking a break for the jury.
Right this way, please.
Oh, is the juror grossed out, getting right that way? Ugh, I hope not.
I'll see counsel at sidebar, please.
It could be. Guys, that's why I think this matters. That's why I think that's what I think they're getting to. They're getting to John doesn't have hypothermia because he wasn't out there long enough. That's not part of what killed him. If he's got hypothermia, it suggests he's been out there for a while. But if he didn't have hypothermia and he didn't have frostbite, more likely he wasn't out there that whole time. And then the alternate explanation for why is his body 80 degrees? Because he died. Because he died and the body cools after you die. It's part of the natural process. That's where I think he's going with it. And that's why it matters. And that's why he really wants to make this point about undermining the hypothermia diagnosis. Because that suggests a extended period of time out in the cold. And so if he can undermine that, maybe John was only put in the cold more recently. More consistent with the defense theory. We have, I'm going to switch back Give me a second here. I'm going to switch back to the NBC 10 just because I didn't like that sound on court TV. It was like crackling and kind of gross and unpleasant. So NBC 10 is back up now. Hopefully it won't crash again. Of course, we're just waiting for the sidebar. So, staring at the fan. Nothing exciting there. But yeah, guys, that's why I think he's hammering on it. That's why I think he's hammering on it. It's going to the length of time that John was out in the cold. I bet he starts getting into frostbite. What do you want to bet he starts getting into frostbite? Because we got that preview too in the opening that the defense expert is going to say no frostbite. Under circumstances where we would expect him to have frostbite if he had, been knocked to the ground and laid there for 6 hours overnight in a blizzard. Well, not quite a blizzard yet. Cat's track of snow, but very cold wind chill. We certainly got all that established, and at least some snow. Couple few inches of snow. So he's attacking the hypothermia, and then I think he's going to move on to the frostbite. Well, we'll have to see, but that was the hint. So I kind of have a little bit of mixed feelings about this. Because this is not like a freebie, no cost angle of challenge to the Commonwealth's case and their interpretation of John's condition. And in part, that's because these injuries, she's saying these hemorrhages could be caused by blunt force trauma. And blunt force trauma is what you're dealing with a car, right? Yeah, cars cause big blunt force trauma. Cars can cause major internal injury, major internal bleeding. That's how Princess Diana died, right? Literally tore her aorta, the force of the collision. And then she, bled internally. So I that's risky. It's risky to say, oh no, it wasn't hypothermia. It was blunt impact, or it could have been blunt impact. Well, now you're holding the door open. Maybe it could have been a car accident. So they are going to need to tie that up, I think, and rule that out. Make it clear to me, why wouldn't we infer that then? He doesn't have any bruising on the outside of his body. He doesn't have any kind of injury to the outside of his body that, would seem to correspond with that. But is that always going to happen? Are you going to see that in all circumstances? I don't know. That's why these are the medical professionals. So I have mixed feelings about this. It seems like not a zero risk strategy to be suggesting, could be blunt force is the reason why his stomach had these hemorrhages. I know there's a plan. I'm quite confident in that. But it is risky. I sure hope this plays out the way that they have kind of gambled on it playing out. While we're waiting, guys, I'll go back to what I was talking about before, and I'm going to pull this up again real quick just so you can see what I am looking at. This is the Rule 73, basis of opinion testimony by experts. This is what I was talking about, why I think the problem is. So this is the rule itself that we read, and then I was reading here in the notes. Massachusetts law requires the facts or data underlying an opinion to be independently admissible, even if not actually admitted. So the problem here that Mr. Alessi is having is that a lot of what Scordi-Bello's manner of death determination is based on is inadmissible evidence. It's based on the hearsay that she got reported to her from Proctor and who knows who else, the reports that she read about the circumstances. Here's how he was found. Here's what was being said. Here's this and that. So that's not independently admissible necessarily. And so like it's her opinion under the Massachusetts rule, it seems like it shouldn't be allowed. Seems like the problem is, to the extent her opinion is based on hearsay, it shouldn't be allowed as an opinion. But it is. So it's in. But then when Mr. Alessi tries to go in and address the bases of it, this is being held against him. Like, no, you can't ask that question because it's based on hearsay. That's why I think she's saying you can't get into the death notification with the circumstances of death, that it was dealing with an adult male found in a snowbank. He'd been at a party. He was walking to a house. There may have been some kind of altercation or dispute. That's all hearsay. And in that particular case, it's like a couple levels of hearsay. So it's not supposed to be part of the basis for her decision, but it seems like it was, but he's not being allowed to ask her questions about it. That's why this is quite messy. So I don't know. This might be the defense a little bit between a rock and a hard place, because you want Scordi-Bello's opinion in. You don't want to object to it and say, oh, it's you can't come in under Rule 703 because the bases aren't admissible. You want the jury hearing that the manner of death was undetermined. That was her opinion. That the evidence was no more likely for one manner than for another. So maybe that's the situation. They want it in so they can't challenge it, but now being challenged it, they can't really challenge the basis for it because the basis isn't admissible, and they don't get to explore that really. That's really the only sense I can make out of what is happening here. It's just this kind of bizarre dilemma that they're on the horns of this dilemma. Do we challenge her opinion, and then it's kept out, and then the jury doesn't hear the undetermined? No way, we're not doing that. But it's technically not supposed to be an admissible opinion. Funny how if Mr. Brennan maybe could have, he didn't want the undetermined coming in. Maybe he could have argued 703. I don't know, but he didn't. He didn't. But that's what seems to be the problem. It has to be independently admissible, but much of her information was not. It was information that she learned as hearsay from other sources. Seems to be a little bit of an issue with this rule, and some discordance between the existence of this rule and the practice of the medical examiner's office. I'm not quite sure how those things get reconciled based on what she's told him. Based on what she's told us about how she makes her determination, like, yeah, she's relying on stuff the rule seems to say you shouldn't be able to rely on. So I think that's why we're having such difficulty here when it comes to examining what was the basis of your decision. Did you like how she just booted that spell it back to Alessi? Booted it right. He offered to let her. The judge put it on her. Judge, you doing the witness dirty here. You're gonna make her pull out the spelling off the top of her head. A Wisniewski's ulcer. This is not a one of the simpler Latin or Greek. Where the letters always sound the same. So you can kind of phonetically work it out. Wisniewski's, I have no idea if there's like a CZ in there somewhere, you know? I'm pretty sure there's not, but just depends, doesn't it? Just depends. I don't think she knew how to spell it. I think that's why. I think that's why she went ahead and volunteered Mr. Alessi to go ahead and spell it. He's got notes. You know, it's probably there in his notes, just to be sure. But he allowed her to save that face. He allowed her to save that face. He could have said, no, I'm sorry. The judge wanted you to do it, so please go ahead. No, he let her save the face. You don't need to do that. You don't need to embarrass her about something small like that. But boy, Judge doing her dirty. Put that spotlight right on her. Spell it. Look, just because we're over here in chat talking about the 5th grade spelling bee does not mean we ever had to spell Wisniewski's ulcer. Okay, that was not on anybody's 5th grade spelling bee. So let's just keep our expectations reasonable here, shall we? Well, hey, while we're waiting, see what other things y'all have had to say. Lisa, why is Bev giving instructions now? This was back during when they started showing the photographs, and she gave that cautionary instruction. Guys, these are going to be potentially graphic, and you're not to have your verdict be influenced by any kind of sympathy or pity for John O'Keefe. Just, pay attention to them for medical purposes. It's a cautionary instruction. She's giving it because it's coming into evidence. And so if people are looking at it and they haven't seen stuff like this before, they're not accustomed to this type of evidence, it might be shocking to them. It might be disturbing. It might have an emotional impact on them. They might find it hard to deal with. And so it's just a caution to not allow your emotions to run the show as far as your processing of this information, what you do with it, and what you take away from it. You need to keep it clinical. So that's why she's doing it. She's done it a couple times now where she volunteers the cautionary instruction to the jury. In general, I don't necessarily have a problem with that. Most of these are form instructions that are in the Massachusetts form instructions. So not really that unpredictable. Texas Sister 2, if they did all that medical intervention, he must have been alive when the ambulance arrived. No, the testimony was his heart was stopped. He was very cold, no signs of life. But because of the circumstances, they considered it to potentially be a viable resuscitation. And there was that testimony that you're not dead unless you're warm and dead. So they were going to warm him and attempt to resuscitate him. And only if he was warm and they could not resuscitate him would they then make the determination that he was dead. So no, he didn't have to be alive when the ambulance arrived, but we've gone all the way through direct. We've heard nothing about the time of death. We didn't in the first trial. There's no effort, I think, to try to identify, hey, is it possible he could have died 5 minutes before the ambulance got there? Is it possible he could have died 6 hours before the ambulance got there? How would we know? What sorts of things would we look for? It really hasn't been fleshed out at all in either trial. Cyarnus, 2 Alessi cross-examinations. It must be Christmas, or it's my birthday. It's my birthday. 2 Alessi crosses. This one is probably his most challenging one so far. Do you guys think so? She's not giving him anything she doesn't want to give him. He's having to work, to get his point in, and she has been able to blunt. She's been able to blunt a few of his points. Okay, just because she didn't call them Wisniewski's ulcers in her report doesn't mean that isn't what she meant. No, she doesn't agree that the Lucas machine would cause hemorrhages to the mucosa of the stomach. He had to just kind of back away from that. Okay, that's it. She is formidable. Andrea McBurnett, do you think Alessi will address on cross Proctor's text message calling her a whack job? See you next Tuesday, or just a whack job? I guess it was Karen was the whack job. See you next Tuesday, because Scordi-Bello labeled his death as undetermined. I don't think so. I don't know that we know that she's aware of it. The jury has already seen it, right? Because of the because of the cross-examination of Buchanan. Back here.
Yes.
So no, without some indication that she knew about that text message or that it had anything to do with her work, I don't think it comes up with her.
Dr. Scordi-Bello, you have in front of you, which has been marked for identification as MN, and you were discussing that. Do you recognize that document since you sort of started over to the Aperture? You recognize that?
I recognize what it is, yes.
And what is it?
It is a picture of a stomach, of the mucosa of a stomach with multiple hemorrhages.
And does that exhibit fairly and accurately depict a stomach with what you have referred to as multiple ulcers?
Yes.
Your Honor, I offer that into evidence.
I object to Anthony as a child.
I'll, you know what, if I can use it as a public, a chalk
Yes, you
publication.
can.
Yeah, that's what I'll do, Your Honor. Thank you, Mr. President.
So you can have it displayed.
Thank you. And
So
again,
this is
I'll leave this hard copy with
going to be a chalk,
and we'll use
but not as substantive
So it's not in
evidence,
evidence.
It is not.
I guess.
It's marked for identification.
Yes, marked for identification, and we are with it.
So it's demonstrative only. Help her explain her findings
Mr.
in her
Wolf?
testimony.
Dr. Scordi-Bello, is that the depiction that you were just describing at your witness stand?
Yes.
And could you please, with the laser pointer, state what you see in this depiction?
So this is a stomach. This is the mucosa and the folds of the stomach. They're not very folded in this particular picture, but you can see these distinct areas that are that have a darker coloration. That's blood. These are hemorrhages.
And to be clear, this is not the stomach of Mr. O'Keefe. This is a medical reference depiction to sort of generic or some other depiction other than Mr. O'Keefe's stomach, correct?
Correct.
If we could, with Your Honor's permission, Mr. Wolk, put side by side this chalk with what is in evidence as the actual gastric mucosa of Mr. O'Keefe.
The objection sustained.
Could we, with Your Honor's permission, publish simply Mr. O'Keefe's
Yes.
gastric mucosa?
Yes.
She's not going to let him put it side by side, I guess, because it's not in evidence.
Isn't it correct, Dr. Scordi-Bello, that there are much less dark spots in this depiction of the gastric mucosa than there were in the chalk that we just displayed? In other words, that green depiction of what I'll just refer to as a generic stomach. Is that correct?
That is correct.
So you can take that down, Mr. Wolf.
So,
isn't it correct that for hypothermia in the presence of Wisniewski's ulcers or spots, that you have to have a predominance of the stomach covered by the spots for them to be Wisniewski ulcers?
I think there's different levels and different grades.
In hypothermia, particularly death from hypothermia, wouldn't you expect to see a predominance of those ulcers, meaning they take up most of the stomach lining? Isn't that what you would expect to see?
Not always. I have seen that. I have also seen cases with much fewer spots, as you refer to them.
But isn't the majority of the cases that you have seen where someone has actually died from hypothermia, that the ulcers predominate, take up greater than 50% of the stomach.
Yes.
And what percentage of the, and I'm trying to avoid putting it up again. So what percentage of the gastric mucosa of Mr. O'Keefe would you estimate is taken up by the ulcers that you have identified?
I would say somewhere between 10, 15%.
Just 10 and 15%. Thank you. Now, if we could
Repeated it back.
look to the issue of continuing with hypothermia. Let's go to frostbite.
Frostbite, there it is. We saw it
Do
coming.
you note any evidence of frostbite on the deceased, Mr. O'Keefe?
No, I did not.
Do you know what the weather conditions were in Canton, New York on the early mornings? I'm sorry, I keep saying Canton,
New York.
My apologies. Do you know the weather conditions in Canton, Massachusetts, starting at midnight on January 29th, 2022, going through 6 a.m. on January 29th, 2022?
It was very cold. There was a blizzard coming.
They called it a nor'easter, right?
Correct.
And when you say very cold, in addition to very cold, do you recall whether there were gusty winds?
I believe so.
And do you understand that when there's a very cold temperature in Fahrenheit and you add gusty winds, that is called, when you apply the two together, that's called wind chill, right?
Correct.
And with wind chill, doesn't the phenomenon of wind chill mean that the wind combined with the temperature brings the actual temperature down, and in addition to bringing it down, temperature in a wind chill calculation, it also has a physical effect on the body, correct? Wind chill. Doesn't wind chill also cause greater effects than if there was no wind?
Correct.
So in medical terms, the wind synergizes with the temperature and exacerbates the effect on a human.
It exacerbates.
And with a wind chill, isn't it correct that you would have a greater chance of frostbite than if there was no wind chill effect at all?
Yes.
So you saw no signs of frostbite on Mr. O'Keefe, correct?
At the time of my examination and at the time of autopsy, no, I did not.
Did you see frostbite at any other time with regard to Mr. O'Keefe?
I only examined him at the time of autopsy.
So at the only time you examined him, which is at the time of autopsy, you had zero signs of frostbite, correct?
Correct.
So,
Dr. Scordi-Bello, now that you have gone through this part of your examination here today, would you like to amend in any way your opinions as to whether hypothermia was any cause of the death of Mr. O'Keefe?
No, I don't. I still believe that there were hypothermic signs.
Hypothermic signs, correct?
Yes.
I'd like to move to another topic area, please. You did not include in your autopsy in any fashion any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident, did you?
No, I did not.
In fact, There were no injuries consistent with a motor vehicle impact on Mr. O'Keefe, correct?
Objection.
Sustain.
Did you evaluate it all in your autopsy? Whether Mr. O'Keefe had any injuries consistent with a motor vehicle accident?
Objection.
I'll allow that.
Yes, I did examine his lower extremities. That is protocol in any case of suspected impact with a motor vehicle. So I did examine his legs and I did not see any evidence of an impact site.
And can you elaborate to the jury what you mean by no evidence of an impact site?
Objection.
I'm going to sustain that objection.
What?
What do you mean in your answer, no evidence of impact injuries?
Objection.
I'll allow that.
Okay, it was narrative, calling for a narrative.
What I look for is some sort of bruise, either on the outside of the leg or bleeding on the inside after the skin is reflected in the soft tissues, or any fracture of the bones of the legs. I did not observe those things.
That was going to be my question. You did not observe any of those things, correct?
Correct.
Why do you look for that? I wonder if you could ask that, or if she would take issue with it.
I'd like to turn to, please, the face of the decedent in your analysis that you discussed on direct examination of that area of the decedent. You talked about ecchymosis, you recall that?
Yes.
In medical literature, there's a synonym for ecchymosis that's sometimes referred to as raccoonized. Is that correct?
Raccoon eyes.
Ecchymosis doesn't cause a laceration to an eyelid, does it?
No.
Ecchymosis does not cause a laceration to a nose, does it?
There was an abrasion on the nose, but no, the answer is no.
Correct. So ecchymosis doesn't cause a laceration to the nose. Correct?
Correct.
Did your report at all evaluate whether there was any significance of the laceration to the eyelid that you spoke about in your direct testimony?
What do you mean?
Other than just noting that there was a laceration to the eyelid, did your report at all evaluate the potential significance, if any, of that laceration to the eyelid?
I noted it and photographed it, and it was part of the totality of the blunt impact injuries that I noted on both the face and the head.
Do you believe that the laceration to the eyelid could be caused by a blunt impact injury?
A laceration, by definition, is a blunt impact injury.
Do you believe the eyelid laceration was caused by a blunt impact injury from falling backwards and hitting one's head?
Not from falling backwards and hitting one's head, but that area at some point came in contact with a blunt object or surface.
Okay, if I could follow up.
Walked her
on that,
into it.
So you agree that if a person falls and hits the back of their head, that they cannot sustain an eyelid injury, is that correct?
Correct.
All right. And if somebody falls backward and hits their head, they can't sustain from that impact to the back of the head a laceration to the nose, correct?
Correct.
An abrasion to the nose, but yes.
So if we could.
Some other
Mr.
blunt
Wolf,
impact.
And with your
Some
honor's
other blunt
permission,
impact?
publish which is already in evidence, which are depictions. Let's start out with, please, the laceration to the right eyelid. And Dr. Scordi-Bello, is this the laceration to the right eyelid that we've been talking about of Mr. O'Keefe?
Yes, it is. Yes, it is.
And that injury could not be caused by a fall backwards and one hitting their head, correct?
No.
I'm sorry, we'll just need, and then I'm going to repeat the question.
Wait out the sirens. Another
Can
little
you
siren
state
break.
your answer again? Let me read. That injury to the right eyelid, that laceration, could not be caused by someone falling backwards and hitting their head, correct?
Correct.
Bear with me one moment, Your Honor. May I approach, Your Honor?
Yes. Show Mr. Brennan.
Mr. Jackson came up and whispered something at him.
Assume that that picture was in evidence.
Oh, it's not in evidence.
Dr. Scordi-Bello, you see what's in front of you. Can we mark this?
So, Mr. Brennan, are you objecting to that coming into evidence? Okay, so let's just put it in evidence.
Exhibit 165.
Thank you.
There you are.
Yes.
Thank you. Dr. Scordi-Bello, I place before you what is in evidence now is 165, and Your Honor, may I have Mr. Wolk publish
Yes.
165? Thank you, Mr. Wolk. So, Dr. Scordi-Bello, that laceration to the right eyelid could not be caused by a fall backwards where someone hits the back of the head, correct?
Correct.
So that injury, you've called, what do you label that
Blunt
category? Traumatic, did you use that phraseology?
Blunt impact.
Blunt impact. So that's a blunt, in your opinion, that's a blunt impact injury, correct?
Correct.
So is it correct that that injury had to occur in some manner other than falling backwards and hitting one's head?
Yes.
And is that injury consistent or inconsistent with a punch?
I'll allow it.
Mm-hmm. Allow it.
Could be consistent.
If we could, Mr. Woke, have the laceration to the nose.
It's an abrasion to the nose. She's going to keep correcting him. It's going to irritate her.
I'm sorry, hold off on a moment.
Abrasion is a friction injury. Laceration is a blunt force injury.
Your Honor, Mr.
She has to
Brennan
allow
has
that because it's so
agreed to
critical to the
this.
Okay,
defense.
so like we can mark it.
That is the alternative theory. Beat up and dumped. She doesn't let him ask that question. There's going to be an issue.
Yeah, Your Honor.
Yes.
Thank you. Dr. Scordi-Bello, I have put before you what is in evidence is 166, and Your Honor may, Mr. Wolf, publish.
Yes.
Thank you. Dr. Scordi-Bello, does that exhibit fairly and accurately depict the laceration to the nose of Mr. O'Keefe?
Yeah, it's an abrasion. I described it as an abrasion, as a scrape.
I knew that was coming.
So you would classify that as a scrape?
Yes.
That scrape could not be caused by someone falling backwards and hitting the back of their head, could it?
Not by a single event, no.
You can take that
Could
down,
it be caused
Mr.
by a
Wolf.
punch? Yes, it can. Friction, skin on skin. Friction can cause abrasions.
On your direct testimony, you talked about injuries to the right arm of Mr. O'Keefe. Do you recall that?
Yes, I do.
And is it correct that you, in your autopsy report, did not determine the cause of those wounds to Mr. O'Keefe's right arm?
Anyone mentioned a dog
That's
to you?
With
Vincent?
your Honor's permission, I would like to,
Hypothetically, you ever consider a dog?
Mr. Brennan.
Your Honor, Mr. Brennan has agreed to stipulate into evidence these two photographs. May I please have them marked as next evidence?
Exhibits 167 and 168.
Thank you.
I'm going to do the same thing, if I may, Dr. Scordi-Bello. I'm going to leave these with you, but I'm also going to, with the court's permission, have them published.
Okay.
Whatever one best allow you to answer the question. Your Honor, may I have Mr. Wolf publish those two? Thank you. With regard to what is on the screen, am I correct that you noted these injuries to, and these wounds to Mr. O'Keefe in your autopsy report?
Yes.
And am I correct that you noted that there was a pattern to those wounds?
Correct.
And although you noted there was a pattern to the wounds, you were not able to determine the cause of those pattern wounds. Is that correct?
That's correct.
Are those injuries consistent with a dog bite?
Based on our answer to the last question, ask something else.
I'm sorry, couldn't hear you.
Ask another question, sustain.
Ask another question.
Can you identify any cause of those injuries that would be consistent with what is depicted on the screen? Objection.
So can you answer that, Doctor?
I cannot.
You can take that down, Mr. Wolf. Thank you. Do you recall discussing
Sustained to
at all on your
dog
direct
bite.
examination? Well, let me ask it this way. Did you evaluate at all in your autopsy a gray hoodie sweatshirt of Mr. O'Keefe?
No, I did not.
So were you aware that there was clothing associated with Mr. O'Keefe when he came as part of the autopsy?
He did not have any clothing that came to us. The clothing was removed at the hospital and was packaged and I believe submitted as evidence.
So the clothing of Mr. O'Keefe, a t-shirt or a hoodie, didn't make its way to you?
No?
You were unable to reach a determination as to the manner of death of Mr. O'Keefe, correct?
That is correct.
So you have doubts about the manner of death of Mr. O'Keefe, and you consider those doubts reasonable?
Sustained. Sustained.
You were not able to reach a determination as to the manner of death of Mr. O'Keefe, correct?
Correct.
And manner of death, as you've testified, includes the circumstances surrounding death in addition to the medical analysis that you performed. Okay.
I'm sustaining it, asked and answered.
Okay, you're done.
Thank you for answering my questions, Dr. Scordi-Bello.
You're welcome.
All right, thank you, Mr. Alessi, Mr. Brennan.
How are you going to redirect that? Desperately keeping out what you don't want the jury to hear.
Doctor, how many autopsies have you performed in your professional career?
At this point, more than 1,200.
When the person is brought to you, are they usually clothed?
It depends on the circumstances. If a person comes directly from their residence, they may or may not be clothed. If the person comes from a hospital where they went first for treatment, many times the person is unclothed. They may be wearing a hospital gown, but in most cases, that clothing has already been removed.
If that clothing has already been processed, is it common that it would be brought to you for inspection?
Objection, Your Honor.
Sustained is to the point.
Is clothing that is not accompanying the person's body commonly brought to you for observation?
Objection, Your Honor.
So let's move on. Or ask it.
You were asked questions
We don't know what the objection is, so
about
don't know if the
your
problem is scope.
opinions relative
Or what?
to spots in the organs of Mr. O'Keefe. And you were asked about part of your statement in the grand jury. When you provide statements, is it important to have the statement in context to understand it?
Yes.
Is it important to have a complete statement rather than just part of a statement?
Yes.
And when you were asked the question that counsel asked you, do you remember that grand jury testimony you gave?
I remember it was a long time ago.
Okay.
But I do remember most of it.
Do you remember when he read part of your answer? It was in response to a grand juror's question.
Yes.
And he read part to you, right? I understand your question. And my answer is that I don't know, but given the environment, so if the injuries had been sustained in a different environment where the temperature wasn't that low, then there might have been an alternative explanation for those gastric and pancreatic hemorrhages. Do you remember that?
Objection, Your Honor.
The doctor can answer that.
Do you remember Attorney Alessi read you that part of your statement?
Yes.
Do you remember that you had more to that statement that was left off when he confronted you with it?
I'm sure there's more to this.
To complete your statement, you said, but in the whole context, I believe that those are signs of hypothermia and not caused. Do you remember that completion to your statement?
Objection, Your Honor.
Sustained, you can show her the statement.
Okay. I can approach.
It's improper impeachment and
Part of the grand jury testimony.
it's a prior consistent statement, but he didn't impeach her, so it shouldn't be coming in.
So I'll strike that. Have the witness look at it and go.
You asked about your entire answer or just part of it?
Objection, Your Honor.
Sustained.
Did you read the rest of the answer that you weren't given when it was read to you?
Objection, Your Honor.
So this is phrased as refreshing recollection, so follow it appropriately.
Do you now remember there was more to your answer?
Yes.
Could you share with us the rest of your answer?
Without reading
Objection,
it.
Your Honor.
Without reading it. Turn the paper over, please.
She's getting annoyed with Brennan
Ask
now.
the appropriate questions to Brennan.
Do you remember the part that was left out?
Objection, Your Honor.
Sustained.
Does it refresh your memory to the rest of your statement to the grand jury?
I'm sorry, what was your question?
After looking at this, does it refresh your memory to the rest of your statement you made to the grand jury?
Yes.
And could you share the rest of your statement with the jury, please?
Rest.
The rest of the statement was that I have to take those findings in the context which was presented to me. So in the case of
This isn't even helpful.
this particular case, those hemorrhages, in the context of a body found in the snow, I believe they were due to hypothermia.
Is your answer more complete in context?
Objection, Your Honor.
Sustained.
You were shown a photograph of two individuals that were in the room at the time of autopsy. Do you remember that photograph?
Yes, I do.
And you were asked about certain names.
Correct.
You said that there would be a log identifying names.
It would be a log, yes.
A log. Do you remember exactly who logged in to that autopsy?
No, I don't remember their names.
May I approach?
Show Mr. Alessi.
It's part of the end of the report. It's in there. Take a look at the report. You have it.
Your Honor, if we need Sidebar to explain, we just need a moment to take a look.
I can move on and we'll come back to it, Your Honor.
Thank you, Mr. Brennan.
You mentioned that Mr. O'Keefe's body temperature was a little under 81 degrees when he was brought to the hospital.
Yes, that's what the hospital records stated.
And again, a normal body temperature is?
98 degrees.
So there was, is it fair to say there was over an 18-degree drop in his body temperature?
Correct.
You shared with us that you generally understood it was a blizzard and cold outside. Do you have any experience on how rapidly a body temperature will drop outside?
The body temperature?
Yes.
Objection, Your Honor. Scope.
No, it's within the scope. Let's see if she's got the basis.
The rate that the body loses heat depends on a number of factors. Depends on conditions, weather conditions. It depends on the original temperature of the body, and the higher the gradient between the body temperature and the environmental temperature, the faster the drop will occur.
You were asked if there's any signs of frostbite. There was no type of freezer burns or anything on Mr. O'Keefe's body, was there?
Objection, Your Honor.
Freezer burns?
Was there any type of burns on his body that would suggest that he was put in some type of machine or environment where there was cooling, mechanical cooling?
What?
Objection, Your Honor.
Sustained. Sustained.
Put in
Move
a
on,
fridge?
Mr. Brennan.
Why are you bringing up
You
if
were
he was
shown
put in
a
a
photograph,
fridge?
a chalk that had spots on them. Do you know where that photograph came from?
I do not.
Do you know who that was from, what person that was from?
No, I do not know the context of that picture.
Do you have any information on the circumstances which led to that condition?
I do not.
Do you have any information about what caused the condition that you saw on that chalk?
I have seen similar pictures in textbooks depicting gastric hemorrhages or Wisniewski spots.
You were asked about your role as a medical examiner, and there were a number of questions about your assessment from a legal perspective.
Yes.
You mentioned that you had information from a police report. How many police reports were you given?
There was a preliminary police report, I believe, the day of the autopsy, and communications with law enforcement in the days and weeks following.
May I approach?
Yes.
Showing you a document. Do you recognize that document?
Yes.
What is it?
This is a police report on this particular case.
Is that a police report from your file?
Yes.
And that police report, is that the police report that you considered?
Amongst other
You gonna try to
information,
get
yes.
this into evidence?
How many lines is that police report?
11.
What's the date and time of that police report?
This was initiated on January 29th. It says at 1941.
I have this marked for identification, all right?
Okay.
And in the, what's another document?
Let us mark it.
Oh, sorry, let me have that back.
Yeah.
Q for identification.
Thank you. May I approach her on?
Yes.
Second document, is that another document in your file?
Yes.
And is that another report that you considered?
Yes.
How many lines is that report?
5.
I'd move to have this marked for identification, please.
Okay.
Thank you.
Exhibit RR for identification.
May I approach again?
Yes.
I'm gonna go back to the questions I asked you about logging in and refreshing your memory.
Mhm.
I'm gonna hand you the document. I'm not gonna actually read it aloud, I'm just gonna ask you to look at it. Does it refresh your memory on people who attended the autopsy?
Yes.
And who were they?
I believe one person was Mr. Keefe and the other one was Mr. Corner.
Who? Mr. Coroner?
Are you part of the criminal investigation team?
No, I am not.
Did you go to the scene and evaluate any evidence?
No, I did not.
Did you do any of your own detective work or investigation in this case?
No, I did not.
So when you were asked questions about your role as the medical examiner in your medical evaluation of Mr. O'Keefe's body, you were also asked whether you considered any part of the legal aspect. Do you remember those questions?
Yes.
You were never, well, let me ask you. You submitted the death certificate on April 14th?
Correct.
I want to talk about some of the things that you may or may not have known about or considered at the time you wrote your death certificate or filed your death certificate. Were you informed or were you aware that before you filed your death certificate, there was information in the investigation that police spoke to a first responder by the name of Timothy Nuttall, who reported that the defendant,
I'm going to
Objection.
that the defendant
What?
said, I hit him, I hit him, I hit him. Were you aware of
Oh,
I became aware of it at some point.
that during your 90-day
that
window?
is some bullshit.
I believe so.
Were you aware that there was another first responder by the name of McLaughlin
That is some bullshit.
who provided information that the
None of
defendant
this is
said,
allowed
I hit him,
under
I hit him, I hit
703.
him, I hit him?
Yes.
Were you aware of statements made by the defendant, to Miss McCabe, that she said, may have I hit him? Did I hit him?
Objection, may we approach, please, briefly?
Okay.
Yeah, this is some bullshit. This is some absolute bullshit. This is exactly why she was previously sustaining stuff for him, as far as we can tell, since none of this actually gets to be stated in open court, because he's asking about bases of her opinion that are not independently, admissible. They're hearsay. Let me find some examples from his. The circumstances of death. The initial information that came in. Where the hell do you think that came from? Where do you think that came from? So they can go in, the Commonwealth can go in and be like, oh, I took into account the fact that Katie McLaughlin told somebody that Karen said something. Okay, multiple level hearsay. But the information the doctor had can't come in. This is not good, not cool.
So jurors, I want to let you know that like other evidence that was let in previously, this is not coming in for the truth of what's in the statements. It's coming in so that as it goes to Dr. Scordi-Bello's knowledge and state of mind at the time of her report.
Oh, good
Thank you.
Lord.
At the time of your death certificate that you filed, were you informed that a Jennifer McCabe had reported that the defendant said, did I hit him or could I have hit him multiple times?
Objection, Your Honor.
I'm going to allow it.
I don't believe I knew about Miss McCabe.
Did you learn that Ms. McCabe reported later that the defendant, while speaking to first responders, reported that she had hit him? Did you know that?
I was aware of that information later on.
Were you aware of
After
the
her report?
investigation regarding alcohol consumption?
Yes,
Were you aware that the police or Massachusetts State Police spoke to other witnesses about their observations that night?
about their,
Observations?
yes,
Were you aware of an interview by Trooper Buchanan with firefighter Daniel Whitley on February 7, 2022?
I don't remember.
Not at the time of her report.
Were you aware that Mr. Whitley told the police that the defendant
Objection.
had expressed that
Said
she had
no,
gotten
she's
into an
not
argument
aware.
with the defendant that night?
That was part of the information I was given, yes.
Were you aware of a report from first responder Anthony Flamate about statements made by the defendant to him?
I don't recall that particular first responder, no.
Were you aware of statements provided by Kerry Roberts to the police that the defendant had called her, citing Kerry, John is dead,
Yeah, I was given that information,
and the questions of did I hit him? Were you aware of that?
yes.
Were you aware of information that troopers had an opportunity to go and speak to the defendant?
Yes,
Were you aware of the statements that she made to the troopers?
not in detail.
Because she didn't say anything bad.
Were you aware that when they spoke to her on January 29th, she
She
informed
just said no.
that she had a
Object.
broken taillight on her vehicle but did not know how it happened?
Objection, Your Honor.
I'll allow that.
She said she
Yes,
doesn't
I was
know.
provided with that information.
Were you provided the information that she had never observed John enter the residence?
I believe that was part of the original information, yes.
Were you aware that she informed relative to the broken right taillight, she didn't know how it happened?
Yes, I was.
Were you aware that members of the Massachusetts State
Ridiculous.
Police obtained John O'Keefe's phone and did a forensic data analysis on it?
I was not aware of that until much, much later.
After you filed your report?
Correct.
Were you aware of location data that was obtained from John O'Keefe's phone before you filed the death certificate?
No, I was not.
Were you aware of healthcare data on John O'Keefe's phone before you filed the death certificate?
No, I was not.
Were you aware of battery temperature data on Mr. O'Keefe's iPhone before you filed your death certificate?
No, I was not.
Were you aware of voice messages left on John O'Keefe's phone from the defendant before you filed your death certificate?
No, I was not.
Were you aware of text messages between the defendant and John O'Keefe before you filed your death certificate?
No.
Were you aware of statements from the defendant to various media outlets before you filed your death certificate?
No, I was
No.
not.
That's not even a good faith question.
Did anybody ever come to you after you filed your death certificate and ask you to change it?
No.
Did anybody ever provide you any of this additional information you weren't aware of at the time, ask you to evaluate it, and then reconsider your finding?
No.
You were asked some questions about impact injuries. In your experience, are most pedestrian collisions where there's injuries to the lower legs, either frontal or rear impacts?
Objection, Your Honor.
I'll allow that because I'll allow that.
Most pedestrian fatalities that we see are with impact with the front of the vehicle.
When you gave the perspective that you looked for impact injuries, was that with consideration of your experience that most collisions are frontal impact injuries?
Most collisions involve frontal impact, yes.
How about cases where you've had an opportunity to observe people who sustained injuries from being clipped? Not hit, but just being clipped. Is your opinion any different in your experience?
Objection, Your Honor.
Sustained in that form.
Okay. How about a side swipe injury? Is that different relative to your expectations to lower extremity injuries?
Objection, Your Honor.
Sustained.
A bruise on the knee, is that consistent with a side swipe impact?
Not that one.
Did you do any type of biomechanical analysis of any alleged collision in this case?
No, I did not.
Were you asked to?
I'm not qualified to do that.
And so when you talk about injuries from a collision, are you in part speculating about what could happen to somebody?
Objection, Your Honor.
Sustained in that form.
Are you giving a direct opinion in this case about how the injuries were caused?
Objection, Your Honor.
Sustained.
You were asked questions about a nose laceration,
Yes.
Abrasion.
and you offered that was not consistent with falling backwards on the head alone.
Correct.
You were asked if that was consistent with a punch.
No, she wasn't
Correct.
about the nose.
Objection, Your Honor.
That's not the testimony. That's your
Correct.
objection.
That is, Your Honor. There's not a question.
Did you provide an opinion that it could be consistent with a punch?
No.
I did provide that opinion.
Could it be consistent with broken glass?
It's possible.
Could it be consistent with sharp shards from broken plastic?
Possible.
Could it be consistent with first aid?
I'm sorry, what was
Could
it?
it be consistent with first aid treatment?
Anything is possible.
Anything is possible is what you get now.
Do you have any firsthand knowledge of how the laceration on
But
the
not
nose happened?
anything is
I do
possible,
not
is
have
it?
firsthand knowledge.
Did you
Not anything is
know
possible, is it?
at the time you filed your death certificate that there was plastic pieces of taillight found near Mr. O'Keefe's body around 5:45 p.m. on January 29, 2022?
I do believe some of that information was communicated to us, yes.
Thank you.
Mr.
All right, Mr.
Alessi,
Alessi.
and in spite of all that, you couldn't confirm law enforcement's theory,
Thank you, Your
could
Honor.
you?
Dr. Scordi-Bello, Attorney Brennan just asked you questions about alcohol consumption. You had the opportunity to evaluate the medical records of Mr. O'Keefe, correct?
Correct.
And you had, in terms of the medical records, information with regard to the medications that Mr. O'Keefe had taken, is that correct?
I believe I reviewed those records at some point prior to issuing my report, yes.
Do you recall the list of medications that were in the medical records that Mr. O'Keefe was on?
I do not recall.
If I were to show you a document, might that refresh your recollection as to the list of medications?
I'm going to allow it. Is in connection with alcohol too, you said, right?
Correct, Your
Go right
Honor.
ahead.
Is it antabuse?
Yeah, Coach, you know.
Yes.
Dr. May I?
Yes.
Dr. Scordi-Bello, may I stand by the witness here?
Yes.
Thank you. Dr. Scordi-Bello, I am providing you with a document. Up at the top it says John O'Keefe, and I would like to draw your attention to medications. And to expedite it, I am going to focus on the fourth item on that list. Can you state what that medication is?
The fourth item is omeprazole.
Does that refresh your recollection as to one of the medications Mr. O'Keefe was on?
Yes,
And that medication is,
it's an antacid.
right, and so omeprazole is the trade name of omeprazole Pepsid?
I believe so.
And Pepsid is a
Pepsid.
proton pump inhibitor?
Correct.
And a proton pump inhibitor stops the proton pump in the stomach from releasing acid, correct?
Yes.
And we're going to come back to that in just a moment, but do you also recall testifying at the grand jury with regard to alcohol consumption and potential alcohol consumption of Mr. O'Keefe?
I do remember testifying, yes.
And do you recall what your testimony was with regard to alcohol consumption and small ulcers in the stomach potentially associated with alcohol consumption?
Alcohol consumption, I don't recall my exact words at grand jury, but alcohol consumption can lead to gastric ulcers.
And alcohol consumption can lead to gastric ulcers. And what medications
Pepsid?
can treat gastric ulcers?
Well, they don't treat them, they prevent them, but that would be a proton pump inhibitor such as omeprazole.
Right. So, isn't it correct, therefore, that the ulcers that are observed in the stomach of Mr. O'Keefe that we talked about, the gastric mucosa, could have come from ulceration due to alcohol consumption,
It's possible.
as opposed to hypothermia, correct?
Correct.
Attorney Brennan asked you questions moments ago, and actually several of them, of which included the words, did I hit him, could I hit him? Do you recall those questions?
I do.
And isn't it correct that you had that information before you issued your final findings in this matter in April of 2022?
Yes, I did.
So, even though you had all that information,
Yep.
you still were unable to conclude the manner of death of Mr. Stevens, correct?
Correct.
Thank you, Dr. Scordi-Bello.
Yep. All right. He's my spirit
Doctor, you
animal.
are all set.
Thank
Thank
you,
you,
Your Honor.
Mr.
Maureen
Alessi is my
Counsel at
spirit animal.
Sidebar.
What did I say as soon as he stood up? Even though you had all of that, you still couldn't find that the Commonwealth's theory was more likely than not. They're going to have a scheduling talk because they're going to be done for the day. I love it. Ulcers can be caused by alcohol consumption. And by the way, even in spite of all that quote unquote information that was provided to you, still couldn't determine manner of death. What a bullshit ruling. What an absolute bullshit ruling. He can go into all of these hearsay bases and Mr. Alessi can't ask similar questions about what she considered and what she didn't consider. That's pretty one-sided, isn't it? They get to know her basis if it supports the Commonwealth's theory, but can't be asked about anything having to do with the defense theory. Except for that one single question consistent with a punch, that laceration over the eye. Yeah. Yeah, she let that one through. You better let that one through. She did not allow the dog bites. Guys, bad ruling, bad ruling. She said based on the prior answer. The prior answer, he asked about the right arm injuries and that she was not able to determine the cause of those injuries. She doesn't know the cause. So then he asked if they're consistent with a dog bite. She said, no, based on that prior injury, I'm sustaining it. She's treating it as asked and answered. It's a different question. It can be consistent with it and not be the cause. If she couldn't determine the cause, it's like the manner of death. She can't say this is more likely than this other thing, but there could be lots of things that would be consistent with it, and she can't identify the cause because it could be any of them. It's a different question.
All right, so that is it for today. I'm told that we are on schedule. So with that, I'm going to let you go a few minutes early. So please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know, and be very careful with your social media. So we'll see you tomorrow morning.
Rest of the jury.
Still got the sound on, so waiting to see. Are they going to come back and chit-chat about something? Really giving him every advantage, Hank, isn't she? And when he asks objectionable question after question after question, does he get the frustration, the side, the get over here to sidebar so I can correct you?
Be seated.
All right, so Mr. Alessi, I'll hear you. I'll hear you, Mr. Alessi.
Thank you, Your Honor. The topic I would like to raise with Your Honor is the timing and nature and significance of the information that the defense has received from the firm Aperture. And Your Honor may recall there are two individuals on the witness list that we understand are to testify in this matter. First is Dr. Judson Welcher, and the second is Shannon Burgess.
And are they testifying in reverse order, though, than what you said?
My understanding is, Your Honor, yes. That
Okay.
My understanding, Mr. Brennan has the best information, is that it's proposed that Mr. Burgess testifies first and Dr. Welcher testifies thereafter.
Okay.
So the Commonwealth has established in reports right up until May, not established, they had stated in the reports of Aperture, particularly the slide presentation of Dr. Welcher, a trigger called 1162.2 that they had associated in the report of Dr. Welcher with a specific time. And that specific time that they have associated with that trigger is 12/31/38 to 12/31/43. And we have been assuming
5 seconds.
that information, and this is from best memory, but I believe it's slide 137 or so, where this statement is in the slide. And so we have proceeded with our defense. We have proceeded with the work that has been assigned to ARCA
And now,
based upon
guess what?
that
New
time
theory.
period. On May 8th, not too long ago, Your Honor, we received an amended report of Shannon Burgess that pushes that time period. I'm just going to get it. So, although it was dated May 8th, we received it actually on May 11th. And in that report, Mr. Burgess states that he is making an amendment, and he is now stating that that infotainment trigger of 1162.2 is further back in time, and it is past 12/31/43.
Do you have the time?
I'm going to get the exact time, Your Honor. It is 12/32/16. And Your Honor may recall that the seconds, literally seconds matter in the analysis of many factors. I won't go into them other than to say, I went through and developed testimony with regard to the cross-examination of Mr. Whiffen. He had a timeline. He talked about much human volitional conduct. Suffice it to say that that information is literally by seconds determinative in some ways of various analyses. So we basically commissioned, if you will, ARCA to be looking at matters based upon the infotainment trigger 1162.2 of 12/31/38 to 12/31/43. As of May 11th, we received information that has changed that. Now, Your Honor, that is a Rule 14 violation.
Yes.
Among other issues, but I wanted to start there. It's a Rule 14 violation. It's obviously, as I stated, an amendment of a report of a significant matter. And also, with regard to the defense's ability to provide a defense, we have to be able to evaluate that information in terms of our entire defense. And it's just not limited to ARCA, it's our entire defense. The other data point I want to get to, so the effect it's had, we still haven't even been able to evaluate entirely that. And I believe, Your Honor, based upon the information that I have, that this may have been a calculated matter by the Commonwealth, but even assuming it's not calculated, the effect is pronounced. So what I want to do, Your Honor, is to look at what the reason Mr. Burgess has given, which leads me to be very concerned about a calculation and a strategy calculation here. Mr. Burgess states in his own words that the reason why he is changed, that time is being align the trigger with Mr. Whiffin's analysis. And Mr. Whiffin's analysis is based upon the
Lock button.
extraction data from Mr. O'Keefe's phone. And I believe it's undisputed that the extraction from Mr. O'Keefe's phone occurred years ago. And the data from that has been extant, it's been available years ago. So to me, Your Honor, that basis can't be a proper basis at particularly this stage where we are approaching the end of the trial, just literally days before the testimony of Aperture. And we are in a very, very almost impossible, challenging situation. So, Your Honor, there are obviously, Your Honor knows the situation here. Our first request is that the May 8th report that we received on May 11th be not allowed, that it be not considered at all. As Your Honor knows, I don't like to use hyperbolic words, but the word has been used for us, against us, ambush, ambush, ambush. If there's ever an example of an ambush, this is it. And so, Your Honor, our request is that Your Honor find a Rule 14 violation, that Your Honor have the remedy be that the violation remedy be that this is not allowed, and that the Commonwealth proceed with its the information of Aperture that has been extant before the May 8th date of the report. Thank you.
All right. Do you have another option if that's not something that we do, right? Because the Commonwealth moved to exclude ACCA or have them go by their old report, right?
Right. And Your Honor, I'm going to answer your question, but with just a quick point that this is really much different than ARCA because two reasons. We are the defense, and ARCA is a rebuttal to the prosecution's case. That is much different than a prosecution changing its theory of the case at this time.
I understand that. I'm just asking if you have another option.
It's not what I am saying that I am proffering. I think the only remedy here is exclusion in a Rule 14 violation.
And you're not waiving that?
Oh, I'm not waiving that.
No, I'm not asking you to.
Your Honor.
Okay, a continuance for how long?
I could have a better answer perhaps to that question tomorrow. I haven't, given what's been going on, I haven't even had a chance to talk to ARCA.
All right, so tomorrow morning, let me know that. All right,
In Your Honor, I will do that, of course. And I will also say, without getting into an elaboration of it, we have to look at all the witnesses that we called. I'll give you an example. Mr. Whiffin. I had my whole cross-examination, not whole, but a significant part of my cross-examination of Mr. Whiffin based upon going through human volitional conduct off that phone that was after that 1162 trigger. And a lot of our defense in theory is based upon that's been in existence now for several months. And again, I go to the bottom line that the proffered reason in Mr. Burgess's report is to align with the data on Mr. O'Keefe's phone, and then that's been around for a long time. So that's my answer to Your Honor's question.
all right, thank you. Mr. Brennan.
Your Honor, this disclosure is not a Rule 14 violation. The Commonwealth, just like the defense is entitled, continues to work on their case and study their case as time goes on. This issue, the relevance of this issue has been clear throughout the case, including my opening statement. And the issue is that clocks are different. There is a clock in a Lexus that runs on a different time than that of an iPhone. And if you recall in my opening statement, I talked about the fact that there are variances between those clocks. So instead of a moment that coincides happening at the precise second, sometimes there's a variance of time between the two. So the Lexus clock could be at a variance with an iPhone, but the event still could happen at the same time, given the clocks have different times. The defense provided a report by a person by the name of Mr. DeSorga, a noted expert witness who they've listed as a witness they may potentially call. Mr. DeSorga wrote a report, and in the report, he suggested, based on his analysis, that Mr. O'Keefe's phone always ran late. That means if the text stream data, the black box data from the car, has a event at 12:32:38, 12:31:38, and Mr. O'Keefe's last movements were 12:32:16, last user interaction 12:32:09, there is a variance between those times. We asked our expert to review their expert's report to see if he was accurate that the variance means that these times would never align. And that's what he did. He studied the data, he studied the waves, he studied the Lexus black box relative to the time. Doesn't change anything, doesn't change the data whatsoever, just adds to the time. What he learned from his opinion is that Mr. DeSorga was wrong. He used information from different phones, not recognizing the items that these timelines came from, and that his time estimates are wrong. So then he looked at the time of the event of the ignition on and off, and he compared that to the Waze data. And when he did, he found that he could identify what the actual differential was. Instead of guessing that it was within the 30-second window, it was somewhere around 21 to 25 seconds. And that 7 minutes before the collision, Mr. O'Keefe's phone was 21 to 29 seconds ahead, which means you subtract that time, which puts it in the same variance that we've been arguing from the beginning, that the collision occurred at the same moment when Mr. O'Keefe last had user interaction, and that reconciles with the data. It does not change the text stream data or the black box information on the car whatsoever. It does not change ARCA's analysis whatsoever. We received this report on May 8th. I was surprised to receive it. I welcomed it. We turned it over on May 8th. There was no delay. It's been a week now the defense has had this information. And so this is not an attempt to align anything. While it may reconcile or identify that variance more closely, it doesn't change any data whatsoever. And so this is not a Rule 14 violation. The effort was in response to disclosures that we believe were wrong by the defense expert, and it is clarified and it is favorable for us. And so we should be able to use it.
Did you intend to use it in your case in chief, or only if this witness disorder? I don't remember reading that name, so I don't know how to pronounce it.
Case in chief. On my case in chief, because we now have this available data. As I said, this wasn't ambush, isn't something that we sat on. It was in response. Fortunately, we received their expert
No,
report,
you didn't sit on
which
it.
caused us to focus more closely.
It's a theory of the accident you've come up with
rather than having an open
3.5 years later in the middle of trial.
Should not be precluded from favorable information that has been provoked by a report by the defense.
Okay.
Provoked.
Yes.
I'll do it quickly.
Okay.
Attorney Brennan has provided a lot of information, and he has accurately provided information, but he's got the time completely wrong and the significance respectfully completely wrong. I'm going to hit his 4 categories quickly. He said he referenced Mr. DeSorbo, who is a defense witness. Two points about Mr. DeSorbo. First, Mr. DeSorbo provided his expert report within this reciprocal discovery deadline.
Okay.
And he provided that report months ago.
Okay.
So if, as I heard Attorney Brennan, he's saying the reason why we're getting something on May 8th is because Mr. Burgess supposedly is responding to that. That was months ago.
Okay.
The more apt point is, or an even more apt point is, Mr. DeSorbo was responding to the information of Aperture. It wasn't like Mr. DeSorbo was coming up. He was rebutting as defendants do. So, and it's Mr. DeSogra, D-I-S-O-G-R-A. Again, D-I-S-O-G-R-A. So that's an important point with regard to Mr. DeSogra. Now I want to go to Attorney Brennan's comment about clocks are different. I agree with Attorney Brennan on that. The shortcoming for Attorney Brennan's argument, however, is that the clocks are different concept has been in existence in this case for over 6 months. I can give you by memory Mr. Whiffin's report of December of 2024, where his report went into the different clocks and what their significance was. So that is almost 6 months ago, at least 5 months ago, the issue of different clocks has been in existence in this case. So therefore, the issue of different clocks dates back to then. But even more fatal for the Commonwealth's argument is that Mr. Burgess himself issued his report and talked about the difference in clocks. He already knew it. He already had it.
Did he testify to that last time? Did he testify?
Aperture was not part of
It wasn't part of the first trial,
Right, I
dumbass.
thought Burgess was, no?
No, neither.
Okay.
No one from Aperture was.
Yeah, I knew
Your Honor.
Aperture was, and I thought he may have been something. The name just sounded.
Neither
yeah,
Burgess nor Welcher were part of the first trial, but they were retained. Aperture was retained, I believe, in October of 2024.
Okay.
And at best for the Commonwealth, Aperture had, and Mr. Burgess and Dr. Welcher had Mr. Whiffin's report that talked about the clock differences. So the clock differences cannot be, as the Commonwealth is proffering, some sort of new information that caused Aperture to provide a new report. This variance that Attorney Brennan talked about, it's called the clock drift. A more layperson's term is a variance of time. Mr. Burgess, in his original report months ago, has a whole section on clock drift. That's not a new concept for him. He's just changing the drift.
Okay, so what I'd like to do, because I want to address the other issue and I don't want to keep people here too long, can you wrap it up, Mr. Alessi, or is that?
In 60 seconds.
Okay.
Thank you, Your Honor. Your Honor, the last point I wanted to make, and I think I heard Attorney Brennan correctly, is he said he was surprised that he got this report dated May 8th. That's what I heard. So if the Commonwealth is surprised that they got it, that should mean, to me, Your Honor, be an outstanding fetching reason to not allow it, because they're surprised to get it. And I can lastly say this, Your Honor, there's nobody that's more surprised to getting this than the defendant when we got it on May 11th.
Okay, thank you. The other issue about calling your expert on rebuttal, Mr. Brennan, based on the late disclosure of the ARCA materials. What's your argument on that?
I won't iterate the entire past, but Your Honor has found discovery violations. Your Honor has found that I want to phrase this properly, efforts of the defense were improper. And inevitably, we've now received an extraordinary amount of discovery on the most important issue in this case, well beyond the discovery deadlines, without any excuse. And the court, understandably, has overruled government's objection and has stated that it is going to allow the defense to proffer two expert witnesses in a very complicated field, in an issue that is the heart of this case. If you're going to allow them to testify, despite the fact that we have not had adequate time to review and to prepare and to address it. The Commonwealth has the burden of proof. The Commonwealth has an obligation to prove its case beyond a reasonable doubt. And this isn't simply late disclosure of some evidence. This is a massive amount of evidence of the most critical issue. And so we provided this information to Dr. Wexler. As you know, he was away. We did not get a report until maybe May 7th. We did not have a chance to look at it until May 9th. An extraordinary amount of work, effort, and expense has gone into preparing our case for the jury. He is still in the process of reviewing the materials. There are entirely new subject areas within this information, well beyond the simple 4 opinions that they gave at the beginning. There are studies, there are demonstrations, there are experiments. This requires not only review, but an analysis, testing, vetting, and then preparing testimony to address the claims made by the defense experts. Not to get into a battle of disparagement, but our expert has found extraordinary issues in his first reviews of material. And some of those concerns lead him to need, in his opinion, to actually conduct his own tests to demonstrate the failures of these ARPA witnesses. That's going to take time. You've heard from the ARPA witnesses themselves. With the amount of data they received, they estimated they needed 5 weeks. And they were given 5 weeks despite all the discovery deadline violations. They were given 5 weeks. We did not get the report until May 7th. And so we believe we are entitled to have our expert review all the materials.
So by the deadline, you got it?
None of that is going to happen anytime soon because he still has not finished reviewing all the materials. There's many, many gigabytes. He's in a difficult schedule. He is away tomorrow, Saturday.
Well, she didn't care about ARCA's schedule, did she?
At the end of the weekend. There is no way he's going to be able to testify anytime soon and have all of this validation and vetting and testing.
So what is it exactly you're proposing?
So what we would like to do is have him testify about what he has prepared, that he's had adequate time to prepare. If either of these ARPA witnesses testify and they introduce new opinions, new testing, new demonstrations, he should be able to continue reviewing the materials, actively engage his own testing now, so by the time the defense case is over, he will be prepared to come back and address the new issues, not the older issues or regurgitate his testimony, but to address any new issues that were provided in violation of discovery orders. And so that he can then
Not in violation of the discovery order. They get to respond to your case.
No other way of this expert fairly being provided, presented to the jury. The unfair prejudice cannot be cured in any other way. We ask that he be able to continue his review, offer rebuttal opinions on anything that is new and not to encroach on anything that's been previously provided.
Can Burgess testify after Welcher?
No, because Dr. Welcher relies on Shannon Burgess's information material. It will make no sense. I thought about it. It makes no sense to the jury, his presentation, unless Shannon Burgess has an opportunity to provide background information.
Right. Mr. Alessi, I'll hear you on this.
Thank you, Your Honor.
So they met the deadline, therefore they should be sanctioned?
And I understand that it's very well understand the time of the day, so I'm going to do this hopefully efficiently. When we're talking about ARPA and the information of ARPA, it's very important analytically to put them in their 2 proper buckets. The first bucket is the information and opinions of ARPA that have been in existence since February of 2024.
Yeah, let's focus on the beyond. Let's focus on.
Okay, good, because my pithy conclusion is there should be no prejudice on that.
And I don't think the Commonwealth's even suggesting that. So
we're focusing just on the quote, new information bucket. Your Honor, it's very important to understand that what ARCA is doing is in response to the testing of Aperture. ARCA did not come up with new approaches. We, again, to state the obvious, are the defense. We get to rebut what the prosecution has put forward. And so what ARCA has done with the new information, new testing, is simply to rebut what Aperture has done. So I do not understand the length of time or the lift, if you will, that's being proffered for Aperture. Now with regard to the time period, Your Honor has already determined what the appropriate approach is for the new information from ARCA. When Dr. Rentschler was on the stand, or Dr. What you said, when can you get me the information? And they said, I think it was May 6th or May 7th, whatever, and they met the deadline. They did it. We proceeded along with the trial with that information. We complied with that request to continually try to claim that there should be ongoing remedies of something that's already been decided. I do not understand.
So I did leave open. I did leave it open to address.
You did leave open the time, but Your Honor didn't leave open that you were going to continue to address this matter as if the defense is making perpetual violations. There was a determination made, and then the question was the remedy. So I'm just addressing the Commonwealth, positing that somehow there's continuing violations. My final 2 points. What Mr. Brennan is seeking is improper. What it's seeking is the most extraordinary situation, which is have Aperture come before the jury, testify to certain things, have ARCA have to come on, and then have Aperture come back and essentially have almost a rebuttal to a rebuttal as of right. I do not understand that process. I do not understand that proposal. It inverts the order of proof. It prejudices the defendant because it almost ipso facto gives a double rebuttal, surrebuttal to the defense. I believe, Your Honor, the final point is if Your Honor is inclined to give Aperture more time, and I haven't even heard a deadline yet for Dr. Welcher. It's still open. What I would recommend, Your Honor, is that we follow the proper order of proof. We determine when Aperture can conclude its review of the ARCA work, and that there be a reflection that keeps the order, namely that the prosecution comes in with Aperture, Dr. Welcher, and Mr. Burgess, and then the defense, as part of its case in chief, puts on ARCA, and we make the determination as to what happens there. Otherwise, what we're happening is here, it's almost a self-serving matter where the Commonwealth is getting to put on certain witnesses here from our witnesses and then have an automatic rebuttal. And Your Honor, I just think that's improper and prejudicial. There's another, and importantly, it's a burden shifting to the defense.
All right, so I have a question for you, Mr. Alessi. Are you still thinking that if the defense puts on a defense that will take roughly a week and a half for that to take place?
That is our best estimate still, Your Honor.
And not holding you to this because obviously you have no burden. If ARCA is part of that defense, when in that week and a half time frame would that be?
We haven't made a final decision, Your Honor, but we're pretty close that it would be toward the end.
Okay. All right. I needed all this information now, so I appreciate it. All right. Thank you.
Thank you. Nothing.
Goodbye.
Well, that got our blood pressure all up for the afternoon, didn't it? Didn't that? Oh, let's calm that down together a little bit, shall we? It's so aggravating. The double standard, isn't it? Isn't it aggravating? See it just so in your face like that? Well, let's back up. We'll go ahead and just recap. Let's back up to when we came back from lunch. We can go back over what we saw, and then we'll touch on this argument and the issues with this argument. So we came back from lunch after the hypothermia struggles, for lack of a better way to put it. Challenges with not sure where we're going with the hypothermia. Came back after lunch, and now we're on track. We're going to dive in specifically to what are the changes that you relied on, and can those be caused by other factors? Pancreas, she's far more receptive to multiple causes for that. The gastric mucosa, not so much. Brings up this one example of the Lucas machine, the machine that does the automatic CPR. It's horrifying watching this machine, guys. That's what I remember about the George Floyd video, and they had him in the back of the ambulance and they hook him on that machine. I find the whole thing a little bit stomach turning. Anyway, she's far more resistant to that as being a potential cause of mucosa hemorrhages. She said more about the soft tissue and stuff like that. Right around in this area is when Alessi was trying to get into the information that she had at the time, the circumstances that led her to conclude this was hypothermic, right? What information did she rely on? The hospital physician said they were dealing with an adult male. He was found in a snowbank. He'd been at a party, was walking to a house, possible altercation dispute, and that was disregarded. So if it's the basis, going to hypothermia from the doctor, elicited by the defense, we don't get to hear it. But if it's hearsay from the police reports elicited for the prosecution, we do. Double standard in full evidence this afternoon. So then got into that grand jury testimony where she said if the injuries had been sustained in an environment where the temperature wasn't so low, then perhaps it would be, something different, not the hypothermia. So that was interesting, right? That's assuming the circumstances. Circumstances would apparently play a pretty significant role in the determination of whether hypothermia contributed to the death or not. But what does she know about the circumstances? Well, we don't get to get into the doctor stuff, but at least, from the police, she gets to rely on what the police tell her. And haven't we already established there are some pretty significant problems with what the police are telling her? Little problems with their information, their reliability, and so forth. So then we got real specific about these Wisniewski ulcers that I don't think she knew how to spell. She booted that back. Judge Bev tried to get her to spell it. She booted that right back to Mr. Alessi. No, please, you go right ahead. And of course he did. I bet he didn't just win the 5th grade spelling bee. I'll bet he won that pharmacy school spelling bee as well. So small hemorrhages. He's got studies. He's got studies. I don't know if it's in his expert's report or if this is just something he independently looked up and knew, but that in 90% of cases of hypothermia, you would find the Wisniewski ulcers. She believes that that's what was present in John's stomach, but she didn't call them that. She just called them gastric hemorrhages. And not all hemorrhages are Wisniewski ulcers, and you can also have Wisniewski ulcers that are not hemorrhaging. So that distinction was brought up. So then the jury gets to see stomach mucosa, John's, and then the chalk, the one that's like from a textbook or something, seemed to maybe have a little bit of an effect on a juror. There was a pause and a rapid recess, and right this way kind of comment from the from the bailiff. And so then we got into like how much ulceration should there be if this is hypothermia is the cause of death. And the implication from Mr. Alessi that I think this is going to be a foreshadowing from the defense expert is that you would expect to see most of the stomach covered in ulcers. And in most cases, it's more than 50% of the stomach. She did agree with that, but she said she's seen it be less. But in most cases, it's more than 50% of the stomach that is ulcerated. But in John's stomach, she estimated only maybe 10 to 15% ulcerated. So it would be a minority of cases, even by her own testimony. No evidence of frostbite. Oh, I knew we were going to get into that. I knew we were. No evidence of frostbite, gusting winds, greater chance of frostbite than if no wind. We got that great new word. We love ourselves some Alessi vocabulary, don't we? The wind synergizes with the temperature and it exacerbates the effects of the cold. It synergizes. Oh. So when he's happy with where this is going and he's made his point. So you saw no signs of frostbite. Nope, she didn't. No signs of frostbite. No signs of frostbite. He invited her to amend her opinion regarding the hypothermia, but she did not take him up on the invitation. Nope, she stands by her evaluation that it was hypothermic. And then finally, we got to the the injuries being consistent with a motor vehicle collision. So first question, John O'Keefe had no injuries consistent with a motor vehicle collision, and that was objected to and sustained. She testified to that in the first trial. No idea what the problem is with this question. Consistent with? Let's go back to our rule 703. It can be things that the expert can rely on, can be evidence already in the record or that will be presented during the course of the proceedings, which facts may be assumed to be true in questions put to the witness. So you can give them hypotheticals as long as they're hypotheticals that are going to come into evidence another way. Hello, Arca. Hello, Arca is going to testify not consistent with motor vehicle pedestrian injuries. Dr. Rentschler. That was squarely within his wheelhouse. So they should be allowed to present it to her as a hypothetical. Hypothetically, does this explanation comport with the injury? I don't know why that question's not allowed. It doesn't make any sense to me. I don't know why they don't get to ask that. That's the Commonwealth's theory. You get to ask questions about whether the Commonwealth's theory is consistent with the fucking evidence. Like, what planet are we even on? Baffling. So then we got into the specifics about what she evaluated. Well, she evaluated the lower extremities, like they do in any suspected motor vehicle accident collision, and that's the protocol. And there was no evidence of an impact site on John. So they asked, what do you look for? You look for a bruise, bleeding, or a fracture of bones of the legs. And she did not deserve any of those. Might have followed up possibly on why do you do that? But it's, again, if you don't know the answer, you got to be very careful about the questions you ask. Already seen that a little bit with Scordi-Bello earlier in the cross. So if you don't know the answer, you don't necessarily ask it. But the reason why is because of the bumper. The bumper is made to be the point where the car hits whatever the car is going to hit. It's part of how the car is engineered to have the bumper in the impact zone and all that stuff. So where's the bumper? It's, somewhere in the legs usually. I mean, even a pretty big, like lifted vehicle, it's down, If there's a bumper that's like above waist high, it's a really, really like monster truck. Okay. Massive wheels, super lifted. It's on the legs. That's why, because it's the bumper that hits you. But he didn't ask. So then we turn to the face. Brought up the ecchymosis, the raccoon eyes, but there hasn't been any testimony from her about the significance of that. This was an issue from the first trial. Are these black eyes, or is this bleeding that is caused as a result of the brain injury? We'll probably hear about this with some of the other medical experts. But that is a question. The cause of John's eyes being swollen the way that they are. All that we dealt with it here was just to point out, well, that in and of itself doesn't cause a laceration to an eye or to the nose. The significance of the laceration to the eyelid is that it was part of a totality of blunt impact injuries noted on the face and head. It is by definition a blunt impact injury, a laceration is. But it would not be caused by falling backward or hitting your head. So to the extent it's caused by a blunt impact injury, wouldn't it have to be a different impact? Can't be the same impact as just that single impact of falling down and hitting your head. And she said that area would have to come into contact with a blunt object. Oh, you don't say. You don't say a blunt object like, for example, a fist. They got the photo of the eyelid into evidence. Of course, we didn't see that. It could be consistent with a punch. Yeah, no shit. Of course it could. Anybody that has watched boxing, MMA, combat sports, of course, that photo that injuries over the eye, lacerations over the eye, very consistent with a punch. Happens a lot. And then the right arm injuries. Okay, the right arm injuries, she could not determine a cause. But noted a pattern. Is it consistent with a dog bite? Objection sustained. What the actual fuck? Based on the previous answer? The previous answer does not foreclose her answering this one. The injuries can be consistent with a dog bite and also not caused by a dog bite. The injuries could be consistent with any number of things, and you may not be able to identify the cause. It is not the same damn question. Not asking, not allowing them to ask if it's consistent with a dog bite. They don't get to test the defense theory with this witness. That is crystal clear. All they get to do is undermine the Commonwealth's theory. They don't get to posit their own to her. And that's not the law. I don't know why on earth she's making that ruling in that way. She didn't evaluate the hoodie, could not ultimately determine the manner of death. So you had reasonable doubts about that. Objection sustained. He did that. He did that previously with who? Whiffen? Was it Whiffen? I think it was Whiffen. Acknowledged his reasonable doubts about his conclusions. Sustained. Jury doesn't get to hear that. And then he tried to close by essentially repeating, stuff that we already knew. So that was sustained as asked and answered. It doesn't matter. The bottom line is you're unable to determine the manner of death. That's what you're closing on. So then we get this redirect. Okay, we get this redirect where she's performed more than 1,200 autopsies. Sometimes they're closed, sometimes they're not clothed. We got into this whole back and forth about the grand jury testimony, and that's being objected to because it's improperly commenting on the question that Mr. Alessi asked is not in evidence. His question is not in evidence. So he's making all these comments about, well, that was misleading, that was cut off, it's out of context, whatever. Left out, you left out part of it. No, I don't think it was left out. You just want there to be more. So procedurally, this was very, very messy because he's treating it like he is rehabilitating an impeachment with a prior consistent statement. Her prior grand jury testimony is hearsay. It's hearsay. So normally, not admissible. Normally not admissible. But the defense was able to bring it up because it was, inconsistent, at least somewhat, with her trial testimony. So he's trying to, I guess, bring it back to being consistent with her trial testimony, which is, but in the whole context, I believe that those are caused by hypothermic injuries. This was the grand jury testimony about if the injuries had been sustained in a different environment where the temperature was not low, maybe not hypothermic. But in this whole context, given this context, meaning then when he goes through and she lets him get all this hearsay stuff in, that is her basis for her opinion, that the defense wasn't allowed to ask about the basis of her opinion. But the police reports, different reports, the statements, all the pieces. This is Hank's little mini closing, right? Because this is his case. Remember, this is his case. The medical examiner says, I don't know. So what are you going to hammer on? Oh, but Katie McLaughlin said, and Jen McCabe said. That's the case. So this was his closing. Some of it completely improper. Aware of statements she made to media outlets, that's not proper at all. The judge at this point has already given the cautionary instruction that this is going to her state of mind at the time she wrote her report. When did she write her report? In April of 2022. Pray tell, Mr. Brennan, what's your good faith basis for any statements that Karen made to the media before April of 2022? What's your offer of proof on that? Because I'm pretty sure there weren't any. Pretty sure there weren't any. So this is just him trying to preview his closing with all the little bits and pieces and giving away the game that this is what the case is based on. I hit him. That's the case. He didn't have freezer burn, and there's no evidence that he was put into a mechanical cooling. Hank is literally asking her about, did they put him in a freezer? What? I don't even know where that comes from. I don't even know where that comes from. He'd been asking about the rate of losing heat, and she said, the body temperature, how fast will it drop? And she says, well, it depends on a number of factors. It depends on the temperatures outside. It depends on the original temperature of the body. And if there's a higher gradient between the temperatures, like there's a larger differential between the temperatures, then cooling will occur faster. So makes sense. You're 98 degrees outside. It's 20 degrees. You're going to cool faster than by the time you reach 60 degrees. Your rate of cooling will slow. And somehow from there we get into freezer burn. This is slimy. This is trying to create the defense for them. This is trying to suggest to the jury that this is what the defense is. The defense, have they ever once suggested anybody put John O'Keefe in a freezer at any point in time? If they did, I definitely missed it. I don't think I've even seen any of the most enthusiastic sleuths of this case suggest that perhaps John O'Keefe was put in a freezer. I don't even know what that was about. Sustained, yes, sustained. Then that long laundry list we got. Nuttall's statement, Katie's statement, Jen McCabe's statement, other witnesses' observations, the Whitley interview. Several times, she's like, no, I'm not aware of that. And then he asks her about the content anyway. And there's no objection. There should be, because she asked it based on the answer to the previous question, Judge. You remember that? Remember how you didn't let the defense ask the question because based on the previous answer? When she says she's not aware of the Whitley interview, then that means you don't get to ask her questions about what's in the Whitley interview. But they did. And then suddenly she remembered it. You know, at some point she received that information. Flamati, same thing. Didn't remember him, but they're going to bring it up anyway. Carrie Roberts' statements. Troopers spoke with her. The fact that they spoke to her. Didn't know about the taillight being broken. Never saw John go inside. Only learned much later that they had his phone and analyzed it. Wasn't aware of location data. Wasn't aware of health data. Wasn't aware of battery temp data. You have no good faith basis to ask these things if you don't have a reason to think she ever saw them. And you know perfectly well you didn't give her the extraction report before April of 2022. But he can get away with being highly improper. There's no lecturing of him or calling him to sidebar or correcting him in front of the jury, is there? Statements of the defense to media outlets. Again, what's your basis for there being anything as of April of 2022? Nobody asked her to change the finding or provide additional info or reconsider the finding. That's, again, probably after April, which is why they didn't revisit that on Recross with the text communications, the Proctor and DeChico talking about, the whack job. And I could have sold her on whatever already, having that whole argument. Tried to turn her into an accident reconstructionist. Are most pedestrian collisions usually frontal or rear impacts? She's going to be allowed to testify. Usually the impact is to the front of the vehicle. What about clipped? Sustained. What about a side swipe? Sustained. Is a bruise to a knee consistent with a side swipe? Is it consistent with? I don't know. That sounds like a hypothetical. Sounds like a hypothetical. Not clear why she's allowed to entertain this hypothetical being consistent. Because we weren't letting the defense do that. Could be consistent. The lacerations could be possible broken glass, sharp shards of broken plastic. Could be first aid. Anything is possible. Well, fucking no, it isn't, Dr. Scordi-Bello. And you know damn well not anything is possible. Because you've already testified, for example, not possible that falling back and hitting his head on the ground caused a laceration to his eyelid. So no, in fact, not everything is possible. You yourself stated a laceration is by definition a blunt force injury. So how are we turning that into now being cut with glass? Is cut with glass now a blunt force? Is that now a blunt force? Pretty sure it's not. Pretty sure it's not. Maybe there is some definition of blunt force I'm not aware of that would include a cut like that. Knew that there were plastic pieces found near John O'Keefe's body beginning at 5:45 that night. I would have objected to that question. They weren't found near his body. You don't know where the fuck his body was. His body's over in the hospital. sitting in a cooler when they found the taillight. You found the taillight where you think John's body was later on down the road, and actually apparently according to CERT, it's over in the street. It's not near his body at all. His body's over by the flagpole. So near his body by CERT at 5:45, I would have objected, but you know, who knows if I would have even gotten a chance to be able to articulate that. So then we got recross, and we got into, this was clever. This was clever on Alessi because I think he actually forgot this. I think he actually forgot this during his initial cross, but he found a way to work it in through the guise of the questions about alcohol. John was taking Pepsid, and she had acknowledged that alcohol consumption in the grand jury testimony can lead to gastric ulcers. And what do? You take a proton pump inhibitor. Oh no, that doesn't treat them, it just prevents them. And there was a comment, I forget who it was, but I had to pull it up in the chat. I think it was Alyssa Ramirez with the great comment. Yes, just because you have skin cancer, don't put your sunscreen on. Don't do that. It only prevents sunscreen. It only prevents it only prevents skin cancer. So you wouldn't want to do that. It's silly. Of course, you take things like Pepsid and Prilosec and the acid inhibitors and stuff like that when you have a gastric ulcer. And acknowledge, yes, it's possible that the ulcers in his stomach came from alcohol consumption and not from hypothermia. And even in spite of all that information, even everything that Mr. Brennan just went through, all the statements and the this and the that, you couldn't corroborate it, could you? You still couldn't determine what the manner of death was. No, she could not. That was strong finish. I enjoyed that. So then we get to the motion, the argument on the motion. Haven't seen the motions. I don't know if they're in writing. I assume that they probably are. Perhaps I'm going to be tagged and stuff coming out. I don't know. I don't know if it's public yet, but maybe at some point. So Aperture, as of 1 week ago, as of last Thursday, changed their theory once again, 3.5 years down the road. Yet again, we have a different theory of exactly how this accident happened, how it went down. Changing the time of the trigger event. It had previously been 12/31/43. Now they're saying it's 12/32/16. And that's kind of significant, isn't it? Because it takes us past the point of that lock button. Let me just get myself on that very important. Oh, except I don't think that's on the old spreadsheet. It's not, because that's new information. Time of the lock button came from Ian Whiffin's testimony. It's in my notes somewhere. Not going to have it right at hand. But that's a pretty significant change. And as he points out, we're, midway through trial here, probably more than midway through trial at this point, because we are reaching the end of the Commonwealth case. They have developed their theory and conducted their cross-examination in reliance on this being the Commonwealth theory. This is precisely why we have discovery deadlines, so that things don't change at the last minute and then you end up in an ambush type of situation. So the reliance, I mean, he's got a very good case, I think, on the reliance here, because yes, he did very specifically cross-examine Ian Whiffin on that specific point. The timing of the lock button being hit after the trigger event is supposed to have taken place. So yeah, that definitely does matter. They've relied on it, but now out of nowhere, after Ian Whiffin has testified, we get this new report to reconcile Aperture's theory with Ian Whiffin's account. So is it a Rule 14 violation? Yes, it absolutely should be. If this is not found to be a Rule 14 violation, to dump a new opinion of an expert on the other side when you're, probably days away from resting your case, then you definitely don't have the right to be accusing anybody else of conducting an ambush. You definitely don't have the right to sit up there and be like, ARCA responding is an ambush. But we're gonna change the opinion, the substance of the opinion. We're gonna change it. No, that's why you have discovery deadlines. Now, let's be real. Let's be real. In courtrooms all over America, does that matter for anything? Often it does not. You'll have a brand new witness show up the day of trial, well past the time for discovery. What will the judge do? You're over here, Your Honor. This is ambush. I have no idea who this person is, what they're going to say. Never heard of this before. Can't investigate them. What will the judge say? They'll say, go interview them in the hallway during a break. That's your remedy. That's your remedy. So they pull this shit all the time. All the time. And this is exactly the kind of problem it causes, and the courts routinely don't care. Routinely don't care. As long as it helps the prosecutor, routinely don't care. So yes, they have to be able to evaluate new information in the context of their entire defense, and they have already committed to their defense because we're nearly done with the prosecution's case. So yeah, they've been establishing their defense through cross-examination. The reason given, they needed to align the trigger event with Whiffin's analysis, which is based on the extractions from John O'Keefe's phone, which took place years ago. So then judge wants to know, well, what other remedy is there? Really? Really? The remedy is that they not be allowed to use it, that you exclude information that is not timely produced. You exclude it. That is the normal and foreseeable remedy, but she wants to know what else is there. The only other remedy that there ever is for late disclosure is a continuance. We have a jury sworn. We have a trial underway. How do you think that's going to work? Oh, I have a guess. After we listen to Hank Brennan whine about how Aperture can't possibly respond to ARCA because they're so busy. Now, remember, ARCA was given, of course, almost no time to respond and met their deadline. But after complaining all that, how he doesn't have any time to respond to ARCA, what do you think's going to happen? Oh, your experts can have five days. You think she'd give him? I don't think she'd give him 5 days. 2 days, 3 days. There's no viable continuance here. If they need to do full review, they need to do testing, et cetera, et cetera. No, you're not continuing anything. I mean, you're talking about putting a stay on the trial. Jurors don't come in for how long? Like, this is not realistic. Continuance is a very viable remedy when you haven't yet started the trial. When the prosecutor walks in the door on the first day of trial and says, oh, by the way, here's these new reports, dumps a stack of stuff on your desk, and it's bullshit. It's bullshit because it's a violation of the rule. It's a violation of the deadline. It implicates your client's right to a speedy trial. For them to walk in and dump new information on you that you can't possibly be prepared to meet. But they'll routinely say the remedy is a continuance. Go ahead and get up to speed. Why? Because you don't have a jury yet, so it doesn't matter. You have a jury? I don't know how you think a continuance is even remotely viable in this. But that's what she wants. Tomorrow morning, let her know. how long of a continuance ARCA would need to be able to, respond to this. How much time would the defense need to be able to evaluate and respond to it? They're in the middle of trial, if you hadn't noticed. Their days are a little busy. They got some other stuff going on. So ultimately, the defense argument, this is them sandbagging. None of this is new information. They've been aware of this. They've been aware of this for an extended time. Nevertheless, Hank's going to say, nope, it's not a Rule 14 violation. We're entitled to keep working on the case and study the case. Yeah, you are, but you're required to produce your information in a timely fashion. And so that's why there are deadlines. That's why there are deadlines. Not a Rule 14 violation for him, but a definite rule violation for ARCA. It turns your stomach, doesn't it? It's like so obnoxious. So he explains, well, it's because the defense expert wrote that John's phone always ran late and the black box is at this time, and there's a variance between the times. So we asked them to look at the clocks and the differential and figure out the differential. And I was surprised to get this report, but I turned it over. Plans to use it in his case in chief. Provoked by a report by the defense from Disogra. No. So now Mr. Alessi is back on fire. We provided Disogra months ago, responding to Aperture. Everybody knows that the clocks being different have been an issue. He says for over 6 months. It goes back to the last trial. The issue with the Waze clock and the display clock, that came up in the last trial. That was something Mr. Green had identified, probably back in one of his first reports. So then, as of December of 24, Whiffen is writing a report about the different clocks. Burgess himself, one of the Aperture witnesses, issued a report on the clocks. So Aperture has been on the case since October. They got Whiffen's report in December. And so this is not anything new, according to Mr. Alessi. I think he seems to have a pretty good basis for that argument. Burgess's original report has a whole section on clock drift. Now he's just changing what it is. No ruling on any of this, of course. No ruling. Bev's gonna go think about it, maybe sleep on it. Hopefully she's not too tired to do something about it and share it with us. Shout out to those of you from the first trial. Remember when Bev was a little too tired to take care of the outstanding issues that needed to be addressed. So then we came back to ARCA because ARCA apparently met the deadline and produced their report by May 7th when she said they should. Hank wants a remedy. They brought up entirely new subject areas that are beyond the 4 original things that they discussed. Well, yes, because they're rebutting. Yes, of course. So our expert found extraordinary issues in his review of what they did, and that's going to take time. And he's really busy. He can't do it anytime soon. Nobody cared if ARCA was busy. You think ARCA was just sitting around drinking Mai Tais on the beach, waiting for Judge Cannoni to assign them a deadline to get their work done? It's just unbelievable. But our guy's busy, so he can't get right to it. That sounds like a your guy problem, because you guys waited this long. You're in the middle of trial. Yeah, you do have the burden of proof. That's why maybe you should have thought about how you're going to meet it before you're in week 4 of your case in chief. Maybe you should have worked that out a little bit earlier. Not like you didn't have Whiffen's report. Not like you couldn't have put the pieces together and figured out for yourself, oh shit, these timelines don't align. Better reconcile that. No, you waited for the defense to bring it up and point out that there's a problem. Point out with Ian Whiffen in the cross-examination that there's a problem. Then you went and reconciled it. But that's what happened. So he wants to basically just be able to put Aperture back on as Sir Rebuttal. Sir Rebuttal is not allowed in Massachusetts with experts. So Alessi is not pleased with this at all. ARCA's new opinions are solely in response to Aperture. They did not do anything novel. All they have done is rebut. They met the deadline. And so now Bev jumps in. Well, but I left it open to address. Left it open to address. You set a fucking timeline and you let them do all this work and you let the defense incur all this cost. So if you're saying now you left it open, whether they're going to be able to testify to this or whatever, that's definitely not clear. Definitely not clear. Let them go down and do all this work and incur all this expense and get it done. Drop everything, rush, get it done by May 7th. Oh, and then by the way, it might be an issue. It might not be okay. How arbitrary is that? And Alessi is pointing out, they're treating it like it's continuing, like the defense is just continuing to violate the rules of discovery. No. They took issue with ARCA being the FBI witness. You can only get what you can get from TUI. When they have it, they turned it over. You've known since the first trial what the TUI stuff was. And then what they did after that is in response to you, the Commonwealth, and your work, and what Mr. Welcher produced. So just a mess. This procedural posture is just absolutely a mess. This is being treated as a candy store for sanctions. A blank check to just go in and interfere with the defense case, the defense theory, the defense preparation based on what exactly? Repeated and continuous violations. Yeah, okay, but what exactly were they? Which act? Which act was the violation? Remind me? Oh yeah, it wasn't. The only act that's been identified here as a violation was the duty of candor thing. I don't like what you said in the memo. You said you never paid them, but you had paid them. We're talking in a different context, but nevertheless, that's the only real specific violation I remember being found. I have found repeated and continual violations of discovery. When? When and what? Willful? If it's willful, it's not based on the TUI stuff because that's not in their control. But it's just being treated like a blank check. This nebulous, there have been violations. Now apparently a blank check to do whatever the Commonwealth wants. So he wants Aperture to be able to testify as a rebuttal witness. Alessi doesn't like that. Is he going to like it? Is she going to allow that to happen? Yeah, probably. I think she probably will. If he needs it that bad, guys, he really needs it. If he needs her rebuttal that bad, ARCA is very, very damaging. But I guess we'll see when we get there. Oh, not a fun end to the day, is it? Gosh, it's so aggravating. It's very, very irritating to have to deal with the bias. You know, the hypocrisy. It's just unbelievable. Very frustrating, isn't it? Welcome to the world of defense. Welcome to the world of defense. And, you know, it's uphill battle. A lot of the time, very Sisyphean. Does it feel a little Sisyphean to you guys right now? Is that a good word? Alessi. I know Alessi. I know Mr. Alessi would appreciate. He would appreciate that. It's a Sisyphean hurdle that we're facing. Trying to get just fair, even-handed treatment. Same standards applied to both sides. Reasonable shot at being able to present your defense. Watch that rock roll down to the bottom of the hill multiple times today, didn't we? That's the life, guys. Well, we have a number of questions in the queue I am going to go ahead and get to. But before I do, please allow me a brief pause. I'm going to refill my tea here so I don't slurp badly into the mic, and also don't get massively dehydrated trying to talk my way through your chats. I do want to give everybody fair consideration and discussion and so forth. So I just want to make sure we don't turn me into a mummy by doing that. So please just give me a couple seconds and I will be back in a moment. All right, guys, we're back. Thanks for giving me a little extra minute there. My kettle turned itself off. So I use the electric kettle thing. I call it the electric kettle because nobody in the US uses those. It's like totally a British thing and like a Japanese thing. But I love it. It's genius. In the US, like people use the teapot on the stove, which is, you know, fine too, but the electric kettle is pretty awesome, but it had accidentally turned itself off. So it took me a minute to get my took my water back up to temperature. No harm, no foul, though. God, what was that music that was going on? I don't know. Felt kind of happy hour-ish. I don't know. Let's get to some of your comments and questions, guys. Lisa, you don't do peripheral IVs in traumas. This is dealing with the hand, the potential IV to the hand. Yeah, I don't know. I wouldn't know. This is something that the medical folks are going to know. These are the types of questions that I think troubled juror Ronnie. And according to him, those other folks on the first jury that had some type of medical background, that a lot of this stuff just doesn't quite add up. So, yeah, I don't know what those about. Lisa, those punctures were not IV, bet. Well, I believe they were not IV from the hospital. I do wonder what they were, though. What were they? That's what makes me wonder. Could this be some amateur who doesn't really know what they're doing, trying to like stick a hydration bag in him or something? I mean, I don't know. I'm just trying to think of like if I didn't know what I was doing and I was trying to stick a UV or stick an IV into my hand, into my vein, so that I could, you know, hook up a saline bag or something. I'd be like, I just feel like it would look different. I would be gouging it kind of different. I don't know. No idea what they were. It's bizarre, isn't it? It's a little bit bizarre. It's a little bit bizarre. You know, I did have, I remember a thought at one point, but I don't know how the size adds up, but you guys seen the taser wounds? The taser shoots out the prongs, and the prongs have like little, I mean, they're almost like hooks, you know, so that they can connect, and you got to have both of them make good contact if you're going to get a shock through it. It just crossed my mind. Maybe, I don't know, something I'll maybe look at. Patius, the ask your mom joke earned this super chat. I laughed out loud. Well, then you're gonna like it here. I do love nothing more than a well-timed and appropriate your mom. Didn't even get the best one off today. I mean, gosh, they got real into that depth of penetration. There were some golden opportunities there. But I appreciate your support, and you know, we try to keep them. You know, you can't dilute your mom. Gotta keep it at the highest levels for it to be classic humor we all love. Z, Nurse Kim, Nurse Sarah Levinson maybe attempted IV. Oh, that's an interesting thought. I forgot that she was a nurse. Isn't one of the other ones a nurse too? I could have sworn somebody else in this house was a nurse. Nicole, Julie, somebody. Yeah, I just don't remember now off the top of my head. Maybe. I don't know. I kind of vaguely remember too. I mean, I don't know. I'm not in healthcare. Haven't even really been to the hospital that many times. The one time I remember having an IV in the back of my hand was when I went in and got my tonsils out. And so I was under general anesthesia for that. I think that might be the only time now. Might be the only time I've been under general anesthesia. Anyway, it seems to me from my memory, and it could very well be my memory, but it seems like the needle's larger. It's like a larger gauge. But I could be way off with that. I have no idea. Just I don't like needles at all anyway. I mean, I'll tolerate them. I probably nobody likes them, but really don't like them. So probably black some of that out. And in my mind, it's like, blown up into some horrifying, massive thing that it isn't really. But I just remember, in the back of your hand, like, oh, it kind of grosses me out. Grosses me out even to just think about it. Audrey Sova, good CPR is 70% effective of normal blood flow. Interesting. I mean, it is a fairly violent process. I've done the CPR training, done the first aid, get the card and all that. And it's some work. It's some work. You're supposed to get it, so deep and fast, just like your mom likes it. Can be a real challenge. 70% of normal blood flow, that is pretty impressive. 333 Damon, sorry, AB, but I'm reaching saturation with the incompetence and BS of this live version of the trial. I'll watch it later. I can skip the most egregious parts. I understand you may want to skip today altogether. If you're watching your blood pressure, you might want to skip today altogether. It is very aggravating, isn't it? It's very aggravating. It's just very unfair. And so when you go into this expecting the process to be fair and just, it can be kind of shocking to realize, no, this is what we get. We get this instead. Z, justice for OJ and FKR standouts all over Massachusetts, including Dedham, every week. So trial restriction is redundant. Trial 1 jurors have dropped off coffee in support. Oh, that's awesome to hear that more of the jurors have come out and supported the protesters. So, I mean, they can't control the weekend. They can't control everywhere. It's not like the jurors are nowhere but their homes in the courthouse. It's part of the issue with is this under inclusive? Like, this doesn't prevent speech intended to influence the jurors or whatever. The jurors aren't sequestered. They're going about their daily lives. And so on Saturday, they go to the grocery store and see somebody wearing a free Karen Reed t-shirt. Now they're aware. If they weren't already, which seems awfully hard to believe. But yeah, it seems like it's going to already be out there, like a little over the top to just try so hard to keep it under wraps. Like, people think what they think about this case, and they're entitled to do that. So you not liking it isn't going to make it go away. A cool breeze, Agent Piggins. Oh, that's a little bit mean. But he does have a little bit of a swelling to him, doesn't he? A little bit of I don't know if it's edema or fluid retention or what, but he has very, very round. Very round. A lot of different things going on, seeing a lot of not real healthy bellies on a lot of these guys, but also hearing about a lot of drinking. And that could be not real good for you either. TB85, couldn't the pig DNA be from saliva, dog chews, etc.? I think that is the leading theory, that it's from a dog chew. I mean, yes, it absolutely makes sense. What's the other explanation? I remember, I think in the first trial, if I remember right, Lally was asking about things like, like hamburgers, stuff like that. Human food, yes, human. I mean, hamburgers are usually beef, but humans do also eat pork. But how are you saying a human bit up John's arm? Like, what's the theory here for how this pig DNA would be like something that John ate? I don't know. There's no like stain on the sweater, like a greasy stain. If I'm like eating a pork chop with my bare hand, like all Homer Simpson, like, I don't know, eating the pork chop and then I go and like wipe my hand on my sleeve. Yeah, it'd probably be some pig DNA, but there's probably also going to be a bunch of grease. So I don't know what the Commonwealth's explanation ever was. I don't think they really ever had one. Dog treats seems highly logical. Java Cat, Andrea, thank you for being a voice of reason in this trial. I love your coverage of this trial and Richard Allen's case. Well, thanks so much for being here with us. I just call things like I see them, and not everybody sees stuff the same way, and that's okay. And sometimes we disagree about stuff, and that's cool too. But I mean, it's all I can really do, right? It's my perspective. It is what it is. It's what commentary is about. So I appreciate that you consider that to be the voice of reason. And I hope you think that even if we don't always agree on every detail, not just making stuff up for, clicks and giggles. Bell M. Andrea, what's your opinion on no salt spots on the inside portion of the tail light? They are everywhere else that was exposed to the elements. Thanks. I think it's a good point. I think it's a good one for Mr. Alessi to have brought up. Got to that in this first part of crossing, the second part of crossing Maureen Hartnett today. Like very first thing he gets to. He didn't compare it to the photos of the car, but they're in. You can see the SUV. There's salt all over the back of that thing. And why? Because that's what happens. You're in this wet environment. Your wheels are churning up. The other cars are churning up stuff. There's like a mist. There's like a mist of grime, road grime, when you're driving in snowy conditions like this. So it's all over the back of her truck and stuff too. Yeah, I don't know why it would land everywhere, but not inside the exposed taillight. If the taillight's supposed to have been exposed since since like midnight the night before, other than the time I guess it was sitting in the garage, it was outside in John O'Keefe's driveway the whole time. Took all those drives, sat outside her parents' house, that massive amount of snow that they had. Don't know how we end up with no salt, no residue like we see on all the rest of the car. Glitter Beauties, Google, dogs have keratinized tissue, a tough fibrous protein that forms the outer layer of their skin, hair, and nails. It says it can form on their pads as well, so it could have been from Chloe. Yeah, so keratinized tissue is going to be anything that has, high amount of keratin in it. So keratin is in fingernails. What else? I mean, yeah, so the dog, it's going to be in the claws. But yeah, the one that stood out to me when I first Googled it, gum tissue. Apparently a lot of keratin in your gum tissue. I mean, who knew? I had no idea. I guess keratin's going to be in your hair too, probably. Yeah, definitely could be from Chloe, but it doesn't look like that's going to be a rabbit hole that anybody goes down in this trial. Annie Painter, sorry to be off topic, but I want to see if anyone picked up on the fact during Higgins's testimony when describing the Jeep, he started to say it was gris and stopped himself. You're the best. That would have to be from the first trial, right? And I don't recall that. I haven't gone back and watched Higgins's testimony from the first trial. So I'll take your word for it. I don't know, man. I'm not sure what to think. about all this stuff. I don't know about the significance of the mystery Jeep. Why does it need to be there? And it clearly doesn't work because of the testimony of Ryan Nagel. Like, was that the whole point? Did they try to put it there to suggest that Ryan Nagel was not honest, not truthful? I don't know. I'm very perplexed by it. Clearly, the man who drove to the Canton Police Department drove a white Jeep with a plow on it. So was it his car? I don't know. He said it was. I don't know what all this means. It's just a very bizarre set of circumstances that there's a reason for the inaccuracy about it, but I just don't know what that is. I really don't know what that is. I don't know if it's because they're trying to get him off the property earlier, help him out with the alibi. He wasn't even there when John got there. He left shortly after the SUV showed up. I mean, I don't know. Plain Whisperer, what would happen if mid-trial someone came forward with confession, such as BH confessing to fight accidental death? Well, it would be Brady material. The Commonwealth would need to immediately turn that over to the defense. Doesn't mean they have to dismiss the case because they don't have to believe it. They don't have to believe it, but they have to turn it over to the defense, and then the defense gets to use it, however they want. And ultimately, it's up to the jury to decide. Jury doesn't have to believe a confession. Jury doesn't have to believe a retraction. They don't have to believe any of that stuff. It's just an option that is available to them. So only thing that really would have to happen is it would have to be disclosed, and then the rest is up to the parties. Levin 2 Limes. I am wondering if the hand bruise with punctures are from attempted IV access by EMS while CPR was being performed. Sounds like from the medical folks in the chat that would not happen. They would not be attempting this peripheral IV under those types of circumstances. Yeah, I wondered the same thing. That does seem to make sense. Possible explanation, but just not totally sure about that. So guys, just gonna bring this up. Wait, I gotta find a good one. I'm having a hard time finding one that isn't like a naked person. Might be a little too far apart. Because those were very, very close together. I'm looking for photos of injuries, taser injuries. Because that's my kind of other thought. Is that possible? Is this like a puncture from the prong of a taser attaching? But those tend to look more like burns. Now that I'm kind of looking at those, so yeah, not sure that's going to be an explanation either. I don't know, guys. This is a little bit of a mystery. The back of the hand. I'm not sure that I know the answer to this one, or that we're even going to get an answer to this one. Steve F. The porcine Ms. McLaughlin claimed consciousness of guilt in trial 1 when Karen sought legal counsel. Shake my head now. Word is she's the a-hole whisperer. Yeah, she could be. And it was. And she got praised for that freaking argument. Praised on the quality of your argument. It's fucking embarrassing and un-American that anybody would raise the argument that Karen Reed calling an attorney, seeking legal counsel before the police come and talk to you in your house is somehow consciousness of guilt. You don't get to do that. You don't get to do that. And I didn't like it when the defense did it with Brian Higgins either. I don't like that implication, because every single person should have a lawyer with you if you're ever considering talking to the police. It should not even be a question. That should be a thing that's as routine as calling your mom on Mother's Day. Just pick up the phone, The police are coming to your house to talk to you. Just the most normal thing ever that you would have a lawyer present. Yeah, I could see it being her. It did sound female, you know. I mean, it's hard to say when it's a whisper. Like, how do you even say? I don't know. It's hard to put into words sometimes why you get the impression you do. It did sound like a female. But it didn't sound like it was coming from Judge Cannoni, so I could see it being her. I could see it being this lawyer. Track worker, multiple fractures from grass. Sure, okay. You think the jury's buying it? You think they maybe checked out at that point? Multiple fractures to the base, the bowl part of your skull, and that massive laceration, that 1 inch gash on the back from smacking your head on the lawn, on the frozen lawn. You think they're buying that? I'm skeptical. James Casatelli, Dr. ISB is the only Commonwealth witness to sound reasonably intelligent so far. I think she sounds reasonably intelligent. I thought Jessica Hyde is clearly very smart. Thinks she's the smartest person in the room. Got a little shook, a little rattled by Mr. Alessi being able to hang and threw her off her game a little bit. She had to lean into that snarky, excessively polite that just comes off as being very condescending. So she sounded condescending, but I thought she still sounded quite smart. I mean, but a little too much, lingo, a little razzle dazzle with words that she doesn't explain and concepts she doesn't explain, and doing it all at 90 miles an hour and so forth. But I agree about Scordi-Bello. I think she seems intelligent too. She's been able to explain all of her answers. She sticks to her guns when she thinks she's right, even if she's not necessarily saying what you want her to say. She's the Commonwealth's witness. Like that, she says anything that supports the defense's case is kind of a small miracle. And so I do. I got to respect somebody who is confident in what they think and willing to stand by it. So it may not hold up. We'll have to see what the defense brings. But I liked Scordi-Bello the first trial, and I like her this trial too. Denmark Radar. If the defense does not cross-exam, can the Commonwealth ask more? No. Once they're done, once they have concluded their questioning, if there's no cross, redirect is just to address what's brought up on cross. So if there's no cross, there's nothing to redirect. So no, you'd be done with your questions at that point. Katia Kane, Alessi's got that Columbo thing going on sneaky smart. Is it sneaky? I feel like he's pretty overt with it. Coming at me with the exogenous glass. Oof, my goodness. Gotta check our colors a little bit here. I think he's very overtly smart. No playing dumb. I could see a little in the appearance, the understated, the curly hair. Doesn't look like a scary guy, but that brain is very intimidating. Moira Carey, Trooper Keefe testified he was the sole member of his unit in attendance. Indeed, he did. And what did she say? What did she say when he showed her the log? What did she say? Let me find it. 2 individuals in the photo. There would be a log. Doesn't remember their names. That was on Redirect. Oh, and then they looked at the document to refresh who attended, and she said Connor Keefe and Mr. Sounded like she said coroner to me, but I heard people say Connor. I hear it like so. So who is this? Who is this other person? Because we haven't heard anything about a deputy or a trooper with a name that sounds anything like this so far. We've heard about O'Hara. We've heard about Tully. We've heard about Fanning. We've heard about Buchanan, Proctor, Dunn, Keefe, Koskowski, DeChico. Did we hear about anybody that sounds remotely like a Mr. Connor? Did they use a fake name? Did they do a fake log? That bald head in there sure does look like Proctor. Sure could be Proctor. Just going by the bald head in the photo. Wasn't clear to me who she was saying that was. I wasn't sure. Is she saying this is the coroner? I don't know. He did testify he was the sole member of his unit in attendance. So if that is the case, I would think that would mean can't be Proctor in that room, or that statement is not accurate. But did he define his unit? He probably did. He probably did. A few days ago now. See if I can find it real quick, because he was at the very beginning. Yep, he's at the Norfolk County District Attorney's Office, the detectives unit. That's Proctor's assignment as well. So if Proctor's there, it seems like that would be false. Law and Order. Who are the multiple sources calling into ATOPS? Yeah. Yeah. Everyone wants to know who are multiple sources calling in with information about any of this? Jen and Carrie, perhaps? They the multiple sources? Jennifer Divine, Andrea, you totally live in the same pod as these two P's. LOL. Look, I do. I feel like I understand Mr. Alessi on a very deep professional level. He does what I aspire to do. You know, when you do it really well. Just again, from a technique standpoint, it's really hard to criticize what he comes up with. He's not perfect. Nobody's perfect. Sometimes you're off. You lose track of your question. Your mind is over here. You use the wrong word. You call it the wrong thing. I do that all the time. I do that. I've probably done that like 20 times just on the stream today. I'm trying to speak. I'm trying to check my notes. I'm trying to watch the the proceeding. I use the wrong word. Like I do that stuff all the time. It's everybody's human. But his ability to prep his cross-examination, okay, which is where it's won. You win it in prep. And that's very impressive to me, just because, big part of winning anything is just showing up and putting in the work. It's one of the reasons I love boxing so much, guys. I've said this many, many times. The reason I like boxing so much, it is the most honest thing I think I've ever done in my entire life. There is no hiding from anything in the ring. If you didn't put in the work, it's going to show. If you don't have the skill, it's going to show. You haven't been doing your running, gas tank getting a little weak. Ugh, guilty. It's going to show. It's the most honest sport I have ever had a chance to participate in. So you can see you got to put in the work. I can see, his fruit from putting in the work. He is prepped. He knows what he's working with. He knows where it is. He's already planned it out. He knows what points he's making, and that's what makes him effective. He doesn't have to wander around in cross-examination trying to figure out what point is he even making. He knows. He might have a little bit of difficulty getting there. He might have to meander a little bit to get there. But he's got it all. He's got it all sorted out. So I enjoy me some Alessi for sure. Jen's nefarious 507 call to Coco. I just love this name. Emmy said she was working on this in Cape Cod, didn't she? Was that where Kevin Albert and Proctor were coming back from the night they were drinking after working on a case? Why, indeed it was. They went out to work a cold case out on the Cape. I don't think it was within this time frame, though. I forget exactly when it was, but I want to say, I think it might have even been in 2023. But I think it was quite some time after this. Couldn't say with 100% certainty, though. Couldn't say it wasn't, but yes, it was out on the Cape. Coincidentally, where we understand Auntie Bev's beach house to be as well. Sweet Lorraine, since there was a bunch of glass on the bumper, did Jen McCabe and Carrie see it when looking at the taillight? Well, not that they've ever mentioned. Not that they've ever mentioned. Nothing about seeing any glass on the bumper. Hard to get a sense of scale from those photographs that we saw. The glass should be in evidence, right? At some point, is somebody going to show us the glass? I would hope somebody will show us the glass, but maybe not. Glass is sharp. I guess maybe you don't want to be handling it in court. But at least one of those pieces looked fairly big. It looked like maybe an inch long, inch by half an inch, Not really that hard to see. Guess it just depends on how much snow is all over your bumper. But when her car has been parked in the garage all night, there shouldn't be really any snow on her bumper. Shouldn't be hard to see that. So no, nobody mentioned anything about that. Alessi's fantabulous lexicon. When Alessi is doing cross, I hear Jaws cello music in my head, slowly picking up tempo, knowing that Jaws is coming, but not when the bite will occur. Yeah, there is that anticipation, isn't there? A sense of the setup. And I loved that. So. Oh, he got to where he wanted to be. That was like the bite right there. It's like the breach of the fish. So happy he's got to do a little backflip. Yeah. He's a predator, man. You gotta watch it. Audrey Sova, the physiologic response to brain herniation and vasodilatory effect of significant alcohol would accelerate heat loss. Love this chat, guys. The things that it makes sense to me that yes, alcohol consumption it makes your blood vessels. I thought it made them constrict. Does it make them dilate? I don't know. It makes your extremities colder. I'm kind of aware of that. Might have to look a little bit more into this. I don't know what the response. I mean, I'm thinking shock, right? A serious injury, you would go into physiological shock. And we kind of talked about that a little bit in week 1, like the difference between when we're sort of colloquially talking about shock and hara, there's just the psychological, oh, I was in shock, is a different thing from like medical physiological shock, where it's a process that's happening. And a big part of the function of that is to prioritize blood flow, oxygen supply, and so forth to critical organs. And so your extremities not valuable at this point. You can not not feed anything to the fingers. We need everything on the heart and lungs right now, for example. So I could see that, shock having something to do with body temperature. But I'm interested in this, in the alcohol contribution as well. It makes sense intuitively, but I don't really have a clear picture of the mechanism of that. So might be worth following up on a little bit. Thank you for that. Bree sides, since people are concerned about HB crossing certain defense witnesses, Brian Albert, Brian Higgins, etc., is Hank Brennan's cross limited to defense's direct because he could have called them himself? Defense gets a lot of latitude in cross now, but will Hank Brennan get the same courtesy? That's a great question, and it is $1 million question. They're not in the same position when it comes to, do I get to go beyond the scope of the direct examination, because I'd be able to call this guy back when we get to my case anyway. So do we want to go through that formality of I cross him now, and then we wait until we get to my case, and then I recall him to ask questions about a different topic, like Judge Gull required the parties to do, very strict about limiting cross-examination to what was brought up on the scope of direct? Or do we recognize that that's not very efficient for everybody? It's certainly not very courteous to the witness to make them have to come back and forth. Just get it done, because you're going to be able to do it anyway. It's a much more lackadaisical approach, which is fine, but it also, again, it's a different context, like you're pointing out. The prosecution crossing a defense expert is not in the position of, well, I would have to wait to call him. No, you could have called him before. I mean, certainly with these people that are all on they're jointly on each party's witness list. I mean, I can definitely see an argument that if he didn't, he shouldn't be allowed to treat it as if it's direct. Everything else being equal, if he was allowed to call this witness after the defense called the witness, it would be rebuttal, and so it would still be limited to cross. It would be limited on what was raised during that, the defense's direct, and then your cross of them. So, yeah, I don't know about that. I don't know. My suspicion is that, Bev will be happy to apply the same rules to both sides when it benefits the Commonwealth, even if it doesn't necessarily make sense to do that, rather than put restrictions on their questioning based on the fact that they could have conducted their own case differently and chose not to. But this is a great question. It's a great insight. I don't think there's a clear answer to it. It's a big, it depends. So what do we expect Judge to do? Judge Bev, I expect her to bend over backwards to give the Commonwealth what they want. Young Black economist, at Forensic Fuhrer, at Jeff Burkhart, not an exaggeration. I go to all chats and like everyone, but this chat is run the closest to a chatter paradise, the best and the smartest. Well, that's what I like to hear. That's what we're aiming for. That's what we're aiming for. We like to have us a good, smart, clever, fun chat. That's our goal. So that's the vibe you like. Stick around. Stick around. We're going to do our best to keep on delivering that. Stacy Labruno, can Alessi ask if the laceration on the back of the head could happen if falling on concrete or hitting a barbell or some other solid object? Well, as we've seen, apparently with Judge Cannoni, the defense does not get to ask about hypotheticals or whether the injury is consistent with other mechanisms by which it could occur. Only the Commonwealth gets to do that. So my suspicion is that she'd be like, well, there's no evidence of a fall on concrete, no evidence of hitting a barbell, no evidence of hitting another solid object. So there wouldn't be a basis for it. So they wouldn't be allowed to ask that because we're only allowed to question about the Commonwealth's theory. That's all that's been presented to her. Doesn't make any sense to me. Doesn't seem logical. Doesn't seem fair. Of course, they should be able to ask about other mechanisms. And then if the Commonwealth has a problem with that, they can point out on redirect or point out in their argument. No evidence that he ever fell on a barbell, is there? Great, we're done. But the jury can infer things. I always hate that there's no evidence. Because it's just very rarely the case. Like most of the time when you hear somebody saying, oh, there's no evidence, there's actually a lot of evidence. It just may not be direct evidence. It may be circumstantial. You may have to make an inferential leap to reach that conclusion based on evidence that very much does exist. So falling on concrete, is there concrete around in this house outside the walkway? Yes, there is. Is that a possible way that the jury could interpret what happened that night? Maybe he was walking towards the house and slipped on the pathway and cracked his skull. And then, one way or another ended up out by the flagpole. Is that possible? Seems possible. Could the injury cause that? I don't know, because we won't get to ask the medical examiner. It seems like she has a very stringent standard for, whether there is a basis to ask about a hypothetical question or not, but she's not including circumstantial inference. Because you can infer a lot of things. We got steps, John taking steps. We got location data that tends to show towards the direction of the house. We've got Nagel and Maxon saying he wasn't in the car when they showed up, and they didn't see him walking. He was already, somewhere else. So, you can draw inferences from that, but no, I don't think she would allow them to do that. They should, yes, but I don't think she would allow them to do that. Did he have grass stains on his hands from the bracing to the impact, or dirt, or any signs other, and pants? His hoodie have them because he would have slid. I was thinking about this because I remember Sergeant Buchanan. I remember Yuri saying, well, it wasn't dragged because that would be linear. Isn't any grass stain going to be linear? I mean, isn't that kind of characterize a grass stain? It's because you hit it and it's that friction thing. You slide on it, and the grass is soft and it's green, and the chlorophyll stains your pants. And because you're sliding, that's what causes the stain. You don't get a grass stain if you just sit down. It's the force and the movement. So like they're all going to be linear. Every grass stain is going to be linear. Like, I don't know how you would tell a non-dragged grass stain from a dragged grass stain. But anyway, no, there's no evidence of grass stains anywhere. Not even on the pants. Not even on the pants. At the last trial, it was all red-brown stains. Red-brown stains. She tested red-brown stains from various areas on the clothing, and it all came up blood. It all came up blood. There's no dirt, no grass, nothing like that. There's no evidence of it anywhere. Jen's Nefarious 507 called a Coco. I'm wondering if the fight was out the front and John O'Keefe hit the top edge of Brian Higgins' plow as he went down. Yeah, I've been thinking about the plow. And is this part of the explanation? Brian Higgins explaining that he didn't see John over there in the corner because he had the blade down. He was paying attention to the plow and he didn't see over the snowbank. Was this like building up to a cover of an accidental, if we could prove John got hit by a plow or, got hit by something, we'd be able to say it was an accident. It was just while I was going by, I didn't see him. I don't know. I would think the sharp, the top edge of the plow, it's sharp. Like it's not like slice your hand open sharp. I mean, I don't think most of the time, but it's fairly sharp because you do cut the snow and ice. It gets very compacted sometimes, and so you gotta kind of cut through that. I don't know if the injuries would match that or not. I mean, I don't know. To me, that seems like a medical question. I don't know if I have the answer to that. It sounds like these injuries are a little bit more linear than round. Okay, we know that. Mr. Alessi was trying to get Dr. Scordi-Bello to say if he hit his head on flat ground, it would create a round type of injury. She didn't agree with that. But seems to be contrasted with what we do have, some kind of more linear energy. So maybe that's consistent with the plow. I don't know. I await the experts to be able to shed that on me. Audrey Sova, differential is a rule-in process. Ruling out is lazy. Thank you for the clarification. So I did not know that. I was just kind of lay sort of guessing how I thought that might work. Ruling out is lazy. I mean, you do have to rule out, don't you? You can't just rule in everything. You have to rule out something. But just a different process. I accept that. I definitely accept that these are different processes. So maybe I'll need to look into differential diagnosis too, exactly what that means. No nudes so far. She's not contradicting. Questions are bad. I'm a forensic pathologist. Her opinion is sound. She called it undetermined because the head injury has many possible causes and circumstances were unknown. Findings help defendants more than Commonwealth. I agree with that. I think the only thing that I questioned whether it was a contradiction is first she was saying that when she was asked about hypothermia, he was asking her, well, did you consider other potential circumstances that could have caused these types of these types of changes, these types of observations? And she said, that's not what we do. I don't consider hypotheticals. But then when it came to, did you consider alternative explanations for, some of the other injuries? She's like, yeah, that's what she did. So that's the only place I thought I maybe saw a contradiction, but I agree that the questioning was not really crisp, in any of this area. And so it may not have been a direct contradiction. It may have just kind of sounded like that, or it may have been just a miscommunication, ships passing, not really clear where we're going and not on the same page. It sounds like she did, in fact, consider alternative explanations for some of these things that she observed, because she acknowledged alcohol can cause the ulceration to the stomach. The Lucas machine can cause the bleeding of the pancreas. So it sounds like she considered those things. She just decided she thought it was more likely that this was hypothermia. And it sounded like she was saying in large part because of the context in which he was found, the information that was provided to her about the situation, the legal side of stuff, less than the medical stuff, which I think is what Alessi was getting at, but just not particularly well articulated. So love having a forensic pathologist in the chat. Thanks for sharing that. Yeah, I'm interested to see how the experts line up. She was pretty much unchallenged during the first trial because she was the only forensic pathologist who testified. Now, we did have Dr. Russell, but Dr. Russell wasn't allowed to offer opinions on forensic pathology, only allowed to opine about the dog bites. But now we know there's a forensic pathologist. We have the whole Dr. Rentschler, and his opinions, what he developed in the scope of his work for ARCA, which, by the way, guys, I know last trial, he wasn't allowed to testify to stuff. He wasn't allowed to testify to medical causation of injury. You have to be an MD was the ruling. As we know, as Mr. Alessi pointed out in the dog bite expert litigation, she's not applying that standard anymore. And so both of them have relied on that to bring in non-medical people to talk about dog bites. Seems to reopen the door to Dr. Rentschler as well, but I think what further substantiates that is that we've heard many, many times this is a new trial, and Mr. Brennan did not move to exclude any type of biomechanical opinion by Dr. Rentschler as being unqualified or inadmissible under Massachusetts law or anything like that. So from my perspective, he should be allowed to testify to the biomechanical implications of what's presented by the evidence. So we'll see. But I'm interested because this is going to be the first opportunity that somebody else has looked at Dr. Scordi-Bello's autopsy report and potentially critiqued it, told us, is it good? Is it sound? Are there issues with it? I'm interested to hear that. Harley 62. Bonjour, Andrea. Bonjour, Monsieur Harley 62. Oh, geez. Says they do. I got hit by a car 44 years ago. Those wider pointy ends? It hit me on my right hip. It broke my hip and pelvic. I was all black on that side and insides. I probably did a pirouette too, dragged in the gravel. Yikes. That does not sound fun at all. My mom was in a car accident. I don't even remember how long ago it was now. Probably in the ballpark of about 10 years. Crossing the street, one of the main arterial streets in town, in the crosswalk, car just doesn't see her, came through and hit her. Same thing, broke her leg, pretty sure broke her hip. I think it might have broken both of her legs. I can't remember now quite off the top of my head. But yeah, just, extremely bruised and not having a real good time. So I know people have had experience being hit by cars. I remember when I was in grade school. I remember, not grade school, but middle school. A kid that I went to middle school with. He got off the school bus and went to cross the street. And this was in Europe, so they don't have the buses with the stop signs and stuff. It's just a whole different scene. It's more of like the tourist coach bus that they would use. But anyway, gets off the bus and goes to cross the street. Car is coming. Car smacks him. And he ended up in the hospital, I remember, with 2 broken legs and up in traction and, a bunch of internal injuries and stuff like that. He was out of school for quite some time. So, yeah, I mean, this is not the least common injury for people to have some kind of personal experience with. It's one of your most likely ways of coming to a premature end, isn't it? A motor vehicle accident. Now, I don't know about pedestrian, but just in general, yeah, cars cause accidents. A lot of people have been in them. Seems like the kind of thing a lot of people might have knowledge about. But the real standout thing with this this set of circumstances we're presented with John O'Keefe, he's not a bruise on him. Not a bruise on him. And that just seems extremely hard to believe. Oh, my bad. On his hands. Bruises only on his hands. So we know he's alive long enough to develop bruising after these blunt impact injuries are sustained. But yeah, you'd expect massive, big bruise. Car hits you at 24 miles an hour. Still trying to stick with the side swipe theory we got from Mr. Brennan. So I don't know how that's going to work with the physics. I really don't. If it doesn't hit your center of mass, I don't know how it throws you anywhere. It's just going to spin you. Your center of mass is going to remain largely unaffected. But I'll be patient. I'll wait and see what they have to say. Harley 62, sorry, I'm not done. Hee, and landed on gravel. So my right hand was really messed up by being dragged. A big shout out to the lovely, funny, smarty mods. Indeed. Big shout out to the mods. Appreciate them so much. Big important part of the cool vibe we got going on in this chat. I really owe a lot to them for that. So thank you, mods. Yikes. Yeah, that doesn't sound fun. Hope everything is better now that you have healed up and mended. And, the human body is a pretty miraculous thing. Its ability to recover gets less and less able to do that so quickly and effectively the more years go by. Recovery starts to become a special skill in your older decrepitude. But hopefully you have not experienced any serious, long-lasting ill effects from that. Isabel Park, I got here late. I also have a stomach infection, so I don't feel good. I blame it all on Bev. Why is she still playing these games? Give it up. We know. She's grumpy today, wasn't she? She was not. She was just leaning full into her full Judge Bev, doing what she wants to do, and what she wants to do is get in the way of the defense. Make it easy for the Commonwealth. Apply the different standards. Not explain herself. Sit up there, expecting everyone to read her mind about why we're applying this double standard here. She may have a reason. But nobody knows what it is. It's just up there in her mind. So if you had a stomach infection and didn't feel good, today may not have been the best day for you in this trial. Not really very pleasant. I wonder, I've always kind of wondered, does Bev pay attention to the coverage? I don't mean does Bev watch my channel? No, I just mean in general, does she watch like any of the reports? the social media, all that stuff that that circulates every day. Kind of see how stuff is landing with the public. Because I wonder if she saw the calling Yannetti an asshole. I wonder if she's aware of that. And if that's what made her mad, if it's not her, but she's being blamed for it. I don't know. But she seems like a decent person to blame. Harley62, just to answer some of your questions, if you don't mind, I don't want to look show off. I was 17, 18, going to college far away from home. It was December 22. Yes, it left a deformity, a dent on my right side, and bad knees. It just goes to show life can change in just a second. Can it? Can just change like that. One day you're just walking down the street. Next day you got bad knees for the rest of your life. Well, sorry to hear that. We all get dealt different challenges, no question. That's not really all that long ago, but dent on your right side and bad knees aside, I hope you've been mostly restored to normal, comfortable functionality. I think one of the hardest things with going through a traumatic injury like this is just it can be life-changing. Maybe you can get function back, but you might be in pain. You might be having to deal with pain. You might be limited in your ability to get function back. Very regrettable when stuff like this happens. Chef 22504, Trooper Keefe said he attended autopsy alone. Yeah, he said he was the only one in his unit. That was his qualifier, only one in his unit. So whoever that person whose name seemed quite unclear was, did that person have a badge number? I wonder. Is there a badge number associated with that person? I don't know. Didn't get followed up on, so perhaps it doesn't matter. But we're always going to wonder, aren't we, all of us out here? Guys, what did that document say? Did it have a badge number? Was it a fake name? I don't know. I don't think we're ever going to find out. Stacy LeBruno, the video of the melting snow is time-stamped around 10 p.m. on 129, so you would not see the same activities as the other videos we've seen. Yes, the part where the snow falls off is later in the evening. It's after it's been sitting there a while. But the part that he showed today, that Hank Brennan showed, which I think is what we've seen before, it starts before her car is even in the Sally port, and it's like an accelerated kind of clock, accelerated time that it's played on like high speed. So you are seeing the time periods when the other people were in the Sally port and doing the shoveling, and Trooper Proctor is over there at the taillight and so forth. That time frame is covered. We don't really see any of that, but I'm not sure that we also have the angle to see it, because you can't really see the passenger, or you can't really see is it the passenger side? Now I'm lost, because I lose track of like what's mirrored and what's not mirrored. I guess you can see both sides. Yeah, I don't know. I don't have an explanation. It could just be the speed that they're playing it, but I don't know. Now I want to go back and look at that again too. Always so many things to revisit, not enough time. Not enough time, kind of a constant complaint. Gets to be more and more of an issue the older I get. T. Shaw, can Alessi ask if MSP Trooper Keefe testified that he attended the autopsy alone? Would that be true, or would Bev say sustained? I said sustained. This is getting close to the edge of what's allowed, because witnesses are not allowed to opine about the truthfulness of other witnesses. That is off limits. You don't get to talk about whether somebody else lied or anything like that. So you can ask if it's inaccurate. Asking if it's true might be a little close to the line. Get sustained. This one, she's going to object to it on the ground anyway, that he didn't say that. It's facts, not in evidence. He said he was the only person in his unit. Looked like Proctor, didn't it, with that bald head? Gladys Kravitz, by all accounts from inside the courtroom, the jurors are engaged in the cross. You may not be, but they are 2 feet away from those two. There's no real substitute for being in the courtroom as far as understanding what's working with them. You know, this is why it's such a bad idea to just assume the jury is taking things the way that you are. We don't know. We're not part of the energy of that room. I've said many times, I saw the first trial. Like I can't take that out of my mind. All of this is hitting me knowing what I know from the first trial and having gone through that experience. So if the jurors are interested, then that's really all that matters. It's good because this is the kind of testimony that does have the potential that they could be getting bored. They could be zoning out. They could be having a hard time in their afternoon lull. But, post-lunch, little nappy state. I know I get in that a lot. So that is good to know. Means they are attentive to the kinds of details that Mr. Alessi elicits. Perhaps he's impressed them. Perhaps they've noticed, hey, he comes up with some good stuff sometimes. That reflection. Maybe we're going to pay attention when he's got things to say to us. Nick TTT, why not just focus on the fact that the injuries don't align with a standard motor vehicle collision? Brennan barely brought up hypothermia and she conceded it wasn't even a major factor because they want to rule it out altogether. Hypothermia implies he was out there for a long time. They want to shorten the time frame. They want to have him, being dumped outside like not long before Karen and Jen get there. Maybe in that 3:30-ish time frame, 4-ish time frame when the Ford Edge is parked out there out front. They're trying to make it more consistent with the defense theory. So that's why I think they're focused on it. We know from the opening their own expert is going to say that this is not hypothermia. These are other causes. And the lack of frostbite is probably going to play a significant role in that. Another thing I guess he could have followed up on with Scordi-Bello. Okay, you didn't observe any frostbite, but that wasn't significant to you. If you don't know the answer, you got to be very careful asking the question. But it seems kind of like a follow-up, doesn't it? If somebody had been out in the snow for 6 hours in these 20-ish degree temperatures with the wind chill and so forth, would you expect frostbite? Minimal clothing, no gloves, missing a shoe. Would you expect frostbite? Lying on the back, right? So your face is all exposed. You get the frost burn on your nose, on your ears, stuff like that. Would you expect that in 6 hours in those conditions? I don't know. When he asked her about the injury, it didn't go well. So maybe you just don't follow up on that if you don't already know the question. Rely on your own expert. But I was curious about that. Don't you care about the lack of frostbite, Dr. Scordi-Bello? Doesn't that matter? Jennifer Devine, a Lucas machine fights a defibrillator. Who wins? I'm going to give it to the Lucas machine on just work rate. The defibrillator has the power, so they're always going to have the puncher's chance, but you got to land it. And so the one who outworks the other one is usually going to be the one that takes the W. So that's my answer. I'm taking the Lucas machine on that purely on work rate. Big Apple Hoosier, please make a video explaining Supreme Court arguments today. I don't know when I'm going to have time to do that. I would have to go get caught up on the issues and the research and all of that, watch the arguments. Guys, it's all Karen Reed pretty much all the time right now. Here we are on almost 9.5 hours today. There was a Kohberger pretrial hearing today too. Got to do some catching up on that, see what's going on with the Kohberger. Might continue over to tomorrow. I'm not sure. It was originally scheduled that way, but it just depends on what they were able to get done today. And I haven't looked at any of the updates, so I have no idea if there's going to be more stuff going on in Kohberger tomorrow. And then there's crazy Alice, and there's old Alice Evans. She's losing her mind out here playing the evicted pauper once again, because her $4,500 a month in support isn't enough for her to be able to keep a roof over her head, as if she doesn't have to work herself. So there's a lot of stuff going on. I'm trying to keep up with. I can't promise you this is going to happen. Probably there will be other creators who will jump on that. If I see anything, maybe I'll bring it up, but I can't promise you I'm going to do this. No nudes so far. In some courts, the manner of death is never brought in. Yeah, and they even mentioned that in the pretrial litigation in this case, that there's several cases in Massachusetts where it's redacted. That was Hank bringing that up to try to argue that the undetermined manner of death shouldn't come in. The defense pointed out, I think correctly, that in cases where it's been redacted, it's because it's the defense requesting it, and the finding is, potentially prejudicial. It's potentially an improper opinion on whether it's a homicide or an accident or self-defense or something like that. So if you go to trial and you're accused of murdering somebody and your explanation is the gun went off accidentally, then if there's a manner of death on the death certificate that says homicide, not accident, it's potentially putting the thumb on the scale. So those are the circumstances where I think it's most common to not do it. But I don't really have a problem with it not being admissible. I'm not really sure that it should, because it isn't a medical determination. If it was the cause of death, no problem. This is your job as a doctor to sort out the medical, the physical, biological types of questions. But what does it mean? That's supposed to be for the jury to decide. So a cool breeze. Bobby is taking the gloves off. Side note, Andrea, I love your glow up since I first saw you break onto the YouTube scene. A lawyer crush. Well, thank you for that. It's nice of you to say, because I just feel like I get older and older every day. I stop having any expectations of, hotness or anything like that. No, we're past that, guys. Not in that stage of life anymore, but I'm not gonna lie, it's nice to hear from time to time. So thank you. Duncan, Idaho, the jury's got to be rolling their eyes at the notion that the frozen ground broke John O'Keefe's skull when he fell back and hit his head in the middle of a lawn. The soil grass was rock solid, frozen. I roll 100%. I mean, especially people, they're native to this area. Probably many of them lived through this storm. They remember this storm. Gonna slip and fall and crack your skull open on lawn, really? I don't think anybody's gonna buy that. What's interesting is I wonder if it's caught their attention that he was allowed to ask them about these types of questions. Okay, is it possible that these injuries consistent with bashing your head on a frozen lawn? But not allowed to ask questions about, are these injuries consistent with being bit by a dog? You think they've noticed the discordance there? Why do we get to consider this? We get to consider this like completely ridiculous idea that the frozen grass caused this massive head injury. But the seemingly plausible explanation that this could be, these are dog bites, we're not allowed to think about that. I gotta wonder if the jury is noticing that distinction. And Cat 100, apologies. I acknowledge HB is savvy. I was contrasting Alessi's vocabulary with HB's use of example experiency, which isn't an actual word. Sorry. Oh, I think this is going back to your earlier super chat about Mr. Brennan. I wasn't trying to argue with you. I think that yes, they have different types of intelligence. Mr. Alessi is the vocabulary man. He's the vocab man. Mr. Brennan seems to struggle a little bit more with that type of thing because that's not his type of intelligence. His intelligence isn't in the planning and and the setup and the clarification and so forth. It's getting out of trouble. His wisdom is getting out of trouble, and you don't necessarily need a big word for that. You just need one that gets the gist of what you're trying to communicate, which is stuff like experiency. So I definitely agree with you on that. Kelly Prosecution Witness Amnesia Support Group. Body's cooled at approximately 1.5 to 2 degrees Fahrenheit naturally, per hour naturally. So between 9 to 12. F in 6 hours. If inside, but excessive cold will greatly speed this up. He wasn't outside 6 hours. Surely somebody has done this math. You know, they have some sense of, okay, here's the gradient, here's the temperature differential. Because it's not a constant rate of heat loss, it's a process of reaching the equilibrium that's going to start faster and get slower the closer that they get to the same temperature. Surely somebody has done that math and figured out, because if it's just a fixed rate of 1 to 2 degrees Fahrenheit per hour, he dropped 16 degrees. He wasn't out there for 8 hours. We know that. So it can't just be a simple flat add a few hours together and get a rate. It's got to be more complex than that. Jonna, re-hair. Didn't Nathan Reed brush Karen's car off at Meadows, yet hair remained? Somebody did. Yeah, we did see that, didn't we? We saw him brushing off the snow off of that back windshield. Yeah, we did see that. Maybe that's just not exactly where the hair was. I don't know, but this is a good point. Good observation. I had forgotten about that detail, but you're absolutely right. Matthew Madu. So before you filed your report, the police primed you with their narrative of what happened, causing you to exclude other inquiries. Touché. Touché. They'd take issue with the causing you to exclude other inquiries, of course. She didn't, at the end of the day, she didn't buy the police's explanation, did she? She didn't buy it. She could not find that this was a homicide, even though they were trying to pitch that. That was their theory. She could not find that this was a homicide based on their theory that Karen Reed hit John O'Keefe with the car at 12:30 the night before. I think the problem is that she's got limited information to be able to consider other possibilities, right? If they're not investigating other possibilities, then she's not considering them. And I mean, I don't know to what extent, I'm not a forensic pathologist. I don't know to what extent you consider hypotheticals. You try to imagine possible scenarios and then, rule them out. To me, that just seems sort of like that's what you do in an analytical process. You look for possibilities and then you try to narrow them. But if people aren't telling you what you need to know to be able to evaluate different circumstances because they're not asking those questions, what, if anything, did they ever say about the amount of snow that was on the front, or the amount of blood that was found on the front of 34 Fairview? What, if anything, did they say about the placement of the blood, that it had dripped from the top of the snow, but there was no snow at 12:30 in the morning? Do you think they communicated these facts to her? Of course they didn't. Like you said, they only presented the one-sided version of events, but even that wasn't enough. So I'm not sure that foreclosed her from considering other possibilities, like inherently. I think her testimony indicates like she can't go along with theirs, so she can't rule out. I mean, if theirs was the only way that it could happen, then then maybe she's stuck with it. But that's not what happened. So I'm not sure that she totally excluded other inquiries. It's just that she can only garbage in, garbage out. She can only work with the information that she's provided. And so if they're not looking for other facts that she can rely on, then that's going to limit her for sure. Denmark Radar, all new phones default to synchronized time with network. Good to know. I think the issue here is the in-car, the Lexus system. That's what I got from this argument. There is a disconnect, I guess, between the Lexus clock and the phone clock. And by the phone clock, I assume we're talking about the display clock and not the Waze clock. Apparently runs on a whole different one. I mean, I know that my phone, my computer, all of my things that are connected to the network, they all, show the same time. If it's not connected to the network, like the microwave, for example, you got to go in and put it in manually. My car clock, I still got to put in manually. Then it will, yes, it will drift. It will be different. So I don't know how the Lexus fits in with this. If the Lexus, I would assume the Lexus connects with the network. It's got, Bluetooth and stuff. But I mean, I don't really know. Does it have a Wi-Fi connection with a network somewhere? I have no idea. But that seems to be the nature of the problem with the clocks. My Mini 67, the heroic hair. If John O'Keefe's phone, which is linked to both a cellular network and GPS timing, is out by any number of seconds, I'll remove my... Those look like... what's that dessert? The little French dessert. Profiterole. You remove your profiteroles with a rusty spoon. Don't do that. Don't do that. Yeah, it's linked to all this stuff, and that's where it's drawing the clock information from. The synced clock or the display clock, you would think is going to be... It's going to be the one you would use as like your common denominator. And so, yeah, if other clocks are off, okay, other clocks are off, but that would seem to then point to the problem is the Lexus clock, not the phone clock. If there even is a Lexus clock. I mean, I don't know. I don't know how we're getting to these times. We didn't have the times in the last trial. All we had was the number of key cycles, and then we had to count them. Now there are times associated with them somehow. So this is all going to be new, and I don't know how this is going to flesh out. Meatball Morrissey's Sketty Stain. I love Alessi. He's like, I'm just going to fix you here real quick. Lay them out, my dude. Yeah, just give me a minute here is all I need. Another second. Just got a few points to make. Oh, it's okay. Just one more, and then we're good. Just go ahead and stay there in that corner. I got another few combos for you. Jason Bites. I took Antabuse years ago. It totally works. If you drink while on Antabuse, you immediately get completely sick. It's one way to quit drinking. It's very effective. I've had more than one client that has gone on Antabuse. I've also had more than one client that has continued to drink on Antabuse. Alcoholism can be just extremely debilitating condition. Yeah, that was just me throwing out, spitballing. Ooh, what if? But clearly that's not what they were looking for in John's medical records. It just did make me wonder. Some kind of indication perhaps of an alcohol issue? No, an indication of a stomach ulcer issue. Pepsid. Tara Rayner. Peter Griffin throws himself on the floor, kicks and cries. My next meme with Brennan's face. He was second chair for Whitey for good reason. Yeah, that tantrum. I can see it. It's very obnoxious, isn't it? But she lets him get away with it. She's just been reinforcing that it's been working, so he's going to keep doing it. Very irritating. And to be doing that while he is at the same time, I mean, the audacity. You're going to drop a report on a Thursday, your third week in trial, new information, new opinions, and you're going to have the audacity to sit there and argue about how your expert doesn't have time to go over their stuff. Yeah, unbelievable, but he gets away with it. Tara Rayner, concessions for the corrupt Commonwealth voir dires and financial hardship because the Commonwealth case has clearly bombed. Bev knows it or is not fit for the privilege. She's giving them every opportunity to win this case. She really is. She really is. Everything she thinks she can get away with. She can hamstring the defense. If she thinks she can get away with it, she's doing it. She thinks she can give them an extra privilege, extra opportunity. They can ask questions that the defense can't ask. Today was the kind of day where she's just going to give them every advantage that she can. That's what makes me wonder if she's pissed about being blamed for calling Mr. Yannetti an asshole. I'll show you. I'll show you thinking Mr. Yannetti is an asshole. I don't know. Andrea McBurnett. Andrea, what a shame that every time Alessi speaks, he has to apologize for taking the court's time due to always being rushed or interrupted by Bev. It is his style to be very differential, not challenging, not confrontational, very different from Mr. Jackson, for example. Mr. Yannetti took it a little bit personally when she was in the last trial, when she's kind of accusing him of playing up to the cameras. Mr. Alessi is far more deferential. That's his style. Not sure it works with a judge like this. I really don't. That said, I've said before, that seems to be what she likes. That seems to be what she's feeling out. Are you gonna kiss my ass and suck up or not? Mr. Brennan has been obsequious. There's a nice Alessi word. He's been obsequious various times in this trial. I'm trying to think of an example. There was a mea culpa. Oh, when he didn't he didn't have the witnesses. He didn't have any witnesses scheduled for the afternoon. And he just went in and you know, very obsequious. I'm so terrible. I'm so bad. Awful. I wasted the court's time, you know, play it up. And she loved it. She loved it. Didn't even chastise him. Jury, it's fine. We got plenty of time. We're right on schedule. No big deal. Just an unexpected half day off. So on the one hand, she seems to like that, but it doesn't seem to be getting Mr. Alessi anywhere. So gotta wonder if he's gonna change strategy at some point, but I doubt it. He seems to be a high road kind of guy. There's not really a good advantage to arguing with the judge unless you think it's going to actually work. It's going to actually get you what you want, but most of the time it's just going to piss the judge off. If you got an argument with the judge, take it up to the higher judge. It's really all you get to do. So I agree. It's unfortunate he has to do that, but that's how she's kind of programmed the situation there. Are you going to tell me what you're going to say and then tell me you told it? Mr. Alessi, I'm not rushing you, but can you get to the point? There's been so much of that. She's communicated. She thinks he's long-winded, so he is trying to accommodate that. Summertime, best moments for Commonwealth today, best for defense. Oh God, best for Commonwealth was for me probably that laundry list of Brennan being able to go in and do his preview of his closing. You know, you considered this and you considered this and you considered this. And part of the reason why that was effective is because Mr. Alessi was objecting. It was being overruled. So it makes it look damaging, right? Defense doesn't want this in, but she's letting him ask the question. And they've already heard most of this stuff. So I don't know, like from a substantive standpoint, that it's all that helpful, but it is presented in a way that, you know, makes it sound like there's some weight and heft to this case. My goodness, all these statements. Yeah, if you don't consider the fact that, you know, Jen McCabe is the kind of person who lies to the FBI and Katie McLaughlin's story doesn't add up with, you know, the evidence, so on and so forth. if you don't take any of that into account, it sounds like a pretty meaty case, meaty theory. So I think them taking advantage of that opportunity to kind of pre-close, make it sound like we have all of this indication of a motor vehicle collision. I think that's a strong moment because that's the weakest point of their case. You don't have car accident injuries. So how are you going to get there? You're going to get there with all this other stuff. And it was his chance to kind of put it all out there front and center. What was the defense's best motion, best moment today? We had some good ones. What did we have? I think honestly, just that close, the very final question Mr. Alessi had for Dr. Irini Scordi-Bello, in spite of considering all of that, you still reached a determination of undetermined. You could not determine a manner of death. In spite of all that stuff the Commonwealth just did. That, I think, really helped to neutralize that benefit that the Commonwealth got from being able to lay it all out, side by side in that systematic manner. But also just, highlighted the point here from the defense standpoint. If it's a car accident, it's that simple, that's the theory, then surely the medical examiner should be able to make that determination, and she couldn't. And that should say a lot. Because you would think the body would tell that story. You wouldn't need to rely on all this other stuff that other people are talking about. That's the kind of thing that cops look into. But the medical examiner has that special expertise with the body. And so if she's looking at the body and she can't say this is a car accident, that's pretty significant. So that's my thought. What's your thought? Chat, what's your thought? Share me some of your thoughts about what are the high and low points for today. Factual lie. The time change would mean Karen Reed would have had to make it home in 4 minutes. How is that possible? Good question. Good question. I'm not sure. I'm not sure exactly which clock we're adjusting, how it works. If we're adjusting John's clock, does that mean that we're also adjusting the home Wi-Fi time? I don't know. I don't know. But I think that is going to be part of the defense case. It doesn't seem realistic. Certainly not under these conditions for Karen Reed to get home from 34 Fairview to 1 Meadows Ave in that short of a length of time. Jen C, has anyone discussed if Jen or Brian Albert could have broken off the taillight while Karen's car was at Fairview? Karen was at the hospital and her car was still there. Brian Albert could have then scattered them as the snow melted. I don't think anybody has raised this, but yeah, I think this is feasible, isn't it? Are there other sections of the ring camera, perhaps, that are missing? It would have had to have been before Karen, of course, got back from the hospital. We know that a police officer is there at what, 8:20? 8:23, before 8:30, that's when we have the dash cam and the welfare check. And we know that Buchanan found out about this pretty quickly because he said that was part of what he relied on when they're, switching their theory from maybe he was hit in the face with the cocktail glass to we need to go look at John's injuries in Karen's car. Cited the dash cam footage, so they knew. Yeah, I think that seems like a possible window. If Karen didn't notice, I don't know. Would she have noticed when she got back? Looked at her car, brothers brushing it off. Would they have noticed the big old chunk of taillight was missing? I would think they would. But I don't know. Stranger things have happened. So I think this is a possible theory. Be interesting to see if there's more missing ring camera footage at any point during that morning before Karen came back and got her car. Matthew Madu, he wants to associate frostbite with damage caused by being pressed against a compressor, but being put outside is otherwise the same as in a freezer. Yeah, a burn from touching something like really ice cold is gonna be different. It's like the Christmas stories, the tongue stuck to the frozen pole kind of situation. A little bit of a different injury than just your tongue getting really cold. I don't know why he brought this up. Why is he bringing up? Is he trying to characterize the defense argument as they put John in a freezer? Who has ever suggested John got put in a freezer? It's just bizarre. The point is there's no frostbite injury, right? If there was some type of cold burn injury on John, maybe then it would be appropriate to look at what's the cause of that and was it a freezer? But it's just bizarre, out of nowhere. Michael Milano, kind of funny to me that Hank essentially asked the doctor if she knew how slow to die in cold. Yeah, he kind of did, didn't he? He kind of did. Wasn't clear to me if he was talking about how long does it take to get cold in the cold when you're alive versus how long does it take to get cold in the cold when you're dead. He didn't actually make that distinction, I don't think. How slow to die in cold. Yeah, he did kind of. There's a differential in temperature gradient, depends on the conditions. Starting temperature of the body, that's where I think she was starting to think, are we talking about a dead person or a live person? But if a person is alive, then it's also, it's going to be confounded by the fact that you have your internal processes going on to try to maintain your body temperature, right? It's not just a passive heat transfer. How slow to die in cold. Little Philly, aren't dog treats too made with pig ears? Often, yep. I have fed my dogs pig ears on many occasions. They are crunchy. My old dog Wally, he used to love a good pig's ear. The bully stick, another popular one, but those stink so bad I can't hardly stand to have them anywhere near me. A lot of good dog treats, and yes, a lot of them pig based. Bird, can Karen Reed team move for immediate mistrial if she allows? Is it important to ask, even if just for appeal, knowing Bev wouldn't grant, but this is insane? Oh, I wish I knew what point this had happened and what we were talking about. I think we may be talking about the new evidence, from the Aperture, the new Aperture report. I mean, you can ask for a mistrial, but if she's going to allow it, she's not going to grant the mistrial because she's already finding that it's okay. And whatever prejudice there is to you from the late discovery, it's not critical. It can be mitigated. It can be remedied or whatever. So I don't think it's a situation where you have to request a mistrial to preserve that right. They've already opposed. They've requested the remedy that they want. The remedy that they want is to exclude it. And that does seem like the appropriate one given the posture and the timing of where we're at right now. I don't know how you contemplate a continuance. You have a sworn jury. I don't know how you do that. Sentient Dreamer, could you walk us through what reversible error is? So reversible error is just an error that requires the conviction to be vacated. And 99% of the time, that means you're sending it back for a retrial. Maybe 1% of the time, it means that it's getting thrown out altogether. Usually, if the remedy is throwing it out altogether, it's because the reason the conviction is being reversed is because of insufficient evidence to support it. That implicates double jeopardy. So if the state failed to present legally sufficient evidence to convict you in a first trial, they don't get a second bite. And that happens by, the trial judge doesn't recognize that there is insufficient evidence. Sometimes the parties don't recognize it. It gets raised on appeal. We can raise it on the first time in appeal in Washington. It's rare that it happens, but it does sometimes. Otherwise, a reversible error is just an error that is found to be harmful. It is not harmless. So any sort of error, admitting evidence, questions being sustained, not sustained, granting or not granting continuances, discovery allowed, not allowed. All of these things are potential reversible errors if, number one, the decision is wrong, it's legally erroneous, and two, it had a practical and identifiable impact on the outcome of the trial. If it doesn't meet those two things, it may still be error, but it won't be reversible because they will say it's harmless. You're not entitled to a perfect trial. You're just entitled to a fair one. So if it didn't affect the outcome, it's not going to get you a reversal. So it has to be a legal error, and it has to have a practical effect on the outcome of the trial. That's generally what's required. Summertime. If Commonwealth was ready first trial, why ask for more time now? Well, because they had to modify that theory from the first trial, didn't they? They've had to scramble to come up with a new theory. Unbelievable. 3.5 years in, and they're still figuring out what their theory is. 3 weeks into their trial, and they've changed their mind about what their theory is. It's just ridiculous. Had all this time and still have the nerve to try to act like that's the defense's fault. It's your burden. It's your burden. Just like it was the first trial. Why indeed? Marcelo, I respected the defense right to a fair trial and counsel for their egregious violations. They lied to me and I wanted to pull out the attorney's pro hac vice. I won't exclude this Commonwealth evidence for this tiny violation if there even is one, Bev, soon. She's gonna give them what they want. She's gonna give them something. She's clearly leaning on the continuance, which seems to suggest her expectation is going to be something like ARCA can deal with this in 2-3 days. And so I really hope that ARCA, doesn't give her that. No, they're professionals. They need time. They need to evaluate. They need to respond. They need to, rebut, whatever. I do not see, just take a couple days. It's the equivalent. It's the equivalent of, this brand new witness, go out and interview him in the hall and deal with your case accordingly. A whole new expert theory and basis. Take a day. Don't rush. Yeah, I could see it being something like this. Hold it against the defense, those previous violations that she found, and then act like she is somehow being, fair to the Commonwealth by being tolerant of them. AC75, AB, they pull this shit all the time. Oh, indeed. Yeah, they do. I lose track of how many trials I've even had, guys. At a certain point, like I stopped counting. There was not really any point. But so I'm trying to think through in my head, like how many times did this even happen? It happens all the time. I'm not going to say it happened every single trial. It didn't happen every single trial, but routinely, it just routinely happens. It's like one of the most normal things in the world. Here, the prosecutor shows up the day of trial with a new police report. New evidence, a new witness that they've gone down and they've hunted down and they've interviewed at the 11th hour because they didn't think you were going to go to trial. They thought your client was just going to roll over and plead, and you told them, no, he's going to trial, and they're like, haha, good one. And now the trial date is approaching and they're like, oh shit, we have to make a case. And forget about your client's right to the speedy trial. We'll just do it now. And, if it's late, whatever, you can ask for a continuance. Forget about your right to a speedy trial. Happens all the time. Shauna Michelle, those 2 dots look like they were punctured at the same time. They are the same size, not an IV puncture for sure. They're very peculiar, aren't they? I'm just racking my brain for what that could be. I mean, do we know that they're punctures? I mean, she said so, right? She said they are. They're not just like weird moles or something. Very strange. I can't think of anything. I can't think of anything that would produce something like that. Just thinking maybe the taser prongs, but they don't do that. They give you more of like a little burn. I don't know, guys. We got to brainstorm this. If you think of something, let me know. Pro Farrier, maybe I'm not remembering correctly, but I feel like they attempted intraosseous fluid on John O'Keefe, not IV access. Also in trauma, you would never use the hand. You are absolutely remembering correctly. I don't think they brought that up in this trial. If they did, it was very brief, but they brought it up extensively in the first trial. They did it in both of his legs. Through the bone, it's horrifying to hear about. Oh God, they drill straight into his bone and stick a big needle in there, like a big large gauge needle, and run the fluid straight into there. Sounds awful. Yeah, they went into it at length in the first trial. So I think you're correct. Josh H, as a dog owner, to me, the arm looks like a dog attack. Teeth bite first at elbow. Front claws just outboard, back claws, the deep scratches further out. To me, I mean, yeah, it looks like any of it could be attack stuff, any combination of teeth and claws. To me, it looks like potentially a lot of teeth because they grab and then, you pull and you move and they readjust. And so they're getting in different ways. And then the strength of the bite depends on, how deep it gets and all that. It looks like a series of bites, a dog, mauling and trying to keep its grip is what it looks like to me. Dr. Russell said scratches. I mean, she is definitely more of an expert than me. If she thinks some of these are scratches, I will buy that they are scratches. That would seem to imply that, he's down on the ground when they're doing that, wouldn't it? Or is it maybe the dog jumping up? I don't know. But to me, what I envision is, the dog jumping up on the arm, just like when you see the police dog training videos sometimes, and the guy wears the big jacket, and the dog goes and grabs the arm, and you like swing him around, and he still holds it and stuff, and he continues to work his bite. Get a different bite. You slip him off, he'll get his bite back. That's what it looks like to me. Is just kind of the chomping on the arm to try to get the good bite. Definitely looks like a dog, though. Alyssa Ramirez, this tainted glove you given, take my tears, and that's not nearly all. Tainted glove. Oh, good one, Alyssa. Good one. Tainted glove. More Smarter Sass became a YouTube member. Welcome to the channel, More Smarter Sass. And Starry Dust has gifted. I saw Starry Dust has gifted a few memberships. Thank you so much for this. Here's 10 of them. Really appreciate your generosity and your support for the channel. Thank you for that. Annie Abramson, McCabe's seeing Jeep proves that Higgins was outside and moved his Jeep behind Karen after Ricky's truck left. I think they unwittingly stated that. That might be an interpretation. It doesn't fit the timeline, though. The timeline has Higgins getting to the house first, swiping out the driveway with his plow, then going and parking at that mailbox area. So it would have to be he parked somewhere else and only went and moved his Jeep after Ricky's truck left. It's not part of anybody's narrative. But it could fit. Maybe that's a way to reconcile it. I don't know why they're so fixed on putting the Jeep there when it just really seems like the Jeep was not there, could not have been there. I don't know how much time there was between Ricky driving away and Karen also driving away. I don't know. But that could possibly be a way to reconcile it. I could see that. Patricia McLean, new report. There is no remedy to the prejudice. Karen Reed has the right to know the case to meet too late. That's my view on it. 100%. You do not get to be underway in the trial and then shift what the defense has to answer to. They have already established. They've already committed to their defense. They have relied on you. Reliance is a important principle in the law when you're dealing with fairness. The whole equitable power of the court is power that arises out of the just general ability to make sure the process is fair. Everybody's treated fairly. And so there's a lot of non-legal rules that come out of equity, things like unclean hands. If you're going to come to the court and ask for them to do something for you, ask them to find that somebody else did something bad, you better have clean hands and not yourself be a wrongdoer. There's no law that says that, but it's just a basic principle of fairness that gets applied. Reliance is one of those too. If you have represented something or made some kind of commitment and somebody else has relied on that to their detriment, that can be binding on you, even if it's not like ordinarily the type of thing that would be a binding contract or something. Reliance is very important for fairness. They have relied on the disclosures that they were provided and the representations by the Commonwealth of what the case was. So for that to switch now when they have already started to carry out their defense, it's not fair. Shauna Michelle, I'm hyper fixated on those hand punctures. If those were from IVs, the size would have been no larger than 25 gauge, which is nonsensical for CPR. Thank you for kind of confirming my gut instinct was it looks like it would be a very small gauge, and that's not what I remember being stuck in my hand when I was put under general. But I don't totally trust my memory about that because I'm sure, it's blown up in my mind because I'm so horrified by the needles in general. But they did look very small, and they also looked very straight on. Like you don't put a needle on straight on the skin, right? You do it at the angle. You do it at the angle. You don't poke it straight down. I'm very curious about these punctures myself. Very curious. I'd like to solve that mystery, but I don't know if we're going to. Just jurors. I know it was way earlier, but what about this morning when she wanted to correct yesterday's testimony? Free Zachariah Anderson. You don't get to do that. Sorry. You're there to answer the questions that you're asked. And if you made a mistake, that's, I guess, on you. And now the jury is just going to wonder what it was and possibly assume it could be anything. Could have been anything that you said that was wrong. So it seems like a great way to kind of undermine your own credibility. But no, you don't get to volunteer information, statements, or whatever as a witness. You're there to answer the questions you're asked. So if they didn't ask to clarify or to correct, too bad. That's what the jury gets. Luann Johnson is gifted 50 memberships. Holy cow, Luann. You are a rock star. Thank you so much for that. Thank you for all of those people that turned green in the chat. What a great day. Really appreciate you and your support. Sarah Maki, thank you for everything. Loved you calling out Bev for not remembering Aperture wasn't part of trial 1. Sorry, I had to let a dumbass out. I could not help myself. Are you an idiot, Judge? Of course they weren't part of trial 1. ARCA was barely part of trial 1. We had Trooper Paul in trial 1. Remember? What do you mean by scientific evidence, Trooper Paul? How could you forget that? I think she has a difficult time keeping facts straight between trial 1 and trial 2. It makes me wonder how much attention she even paid in trial 1. Some of these things. It makes me really question how much attention she's paying in trial 2, particularly when she says things like, oh, well, based on the prior question, I'm not going to allow you to ask a completely different one. They're different questions, Judge. I don't think you're paying the close attention that you want us to think you are. FKR, they were all hoping she'd take a plea. Billion percent. That's why they didn't even send stuff to the lab until, well into March. Didn't even bother to create a chain of custody for anything that they had collected before then. Did an interview. They ran right out and talked to those Aruba sisters. But the folks that it would be obvious would be coming in as potential witnesses, Heather Maxson, Ricky D'Antano. Don't even interview them. The other people in the house, Colin Albert. Yeah, they never thought this was going to trial. They thought they would be able to just lean on her and get her to plead. And they revealed as much in that group chat, didn't they? That was the plan all along. And it works. Most of the time, it's going to work. If you had picked anybody but Karen Reed, probably a pretty good chance it would work. They don't have the resources to go hire a David Yannetti and an Alan Jackson. And just the stomach for the fight. A lot of people think, it just might be easier, especially if they make the deal really tempting. Well, you don't have any history, so it'll be a felony. It'll be a felony manslaughter conviction, but we're not going to recommend time. We'll just recommend probation. It can be very, very hard to turn something like that down. Anybody but Karen Reed, and they might have gotten what they were expecting. TB85, did you see Hank as Judge Bev stood up to leave the bench? He aggressively slammed his laptop shut. Also love the Tulsi Gabbard gray streak. Well, thank you. I get what I get. So I'm not real into fighting the aging process. Do some basic stuff. I've always been a sunscreen person, and the retinoids. I will talk up the retinoids for anybody and everybody. Start them early, start them often. They're great. One second. Choked myself a little bit. But yeah, otherwise not real into trying to dye the hair or like get the injections and stuff like that. Not my thing. So if I go a little gray, I go a little gray. And it's kind of fun, right? A little like spray, just the one spot. I'll enjoy it while I got it. I missed Hank having a little temper. I don't know what he has to have a temper about. I think he's gonna get exactly what he wants. So, but we'll see. Maybe he thought he was going to get a ruling at the bench. Maybe he thought she was going to share his outrage. Those terrible violations with respect to ARCA. Don't know. Get another drink here. Abacus Flinch. Is it just me, or is practically every witness Commonwealth has called has become a witness for the defense? It's not just you. The defense has very effectively neutralized almost everybody. And even if they haven't turned them into a defense witness, they have pretty successfully managed to undermine whatever, significant point that the Commonwealth was hoping to get from them. Nuttall, I think, is a good example of that. I don't think they ever turned Nuttall like full on into a defense witness, because I don't think I don't remember them getting anything from him that was like, ooh, that's an important point for the defense. But they very successfully neutralized him and his vivid memory. It's not what happened, not how it went down. Your description doesn't match the video. By the way, you had this whole other vivid memory. You should have learned the first trial about your vivid memories, but you didn't. But they do have a skill for it, don't they? Getting their own information, especially from the experts. When there's something in that report that the defense can use, they're getting it out and they're using it to their advantage. So they've done that with Ian Whiffen. did that with Hartnett. Now they did it with Scordi-Bello. So it is a bit of a theme. I would agree with that. David Lyons is a new member. Welcome, David. Welcome to the channel. Terry Cece, was Ryan Nagel's buddy who drove him that night called as a witness? Ricky D'Antano has not been called at this point. He is on, I know he's on the defense witness list. He might be on both. Ricky D'Antano is on both witness lists, but nobody has called him. I don't recall that he has anything to add to what Heather Maxson had to say. Don't recall that he had anything substantially different. So I don't know if they're going to, but he has not so far been called. He was called during the first trial, but that's because Lally called everybody under the sun. If you had 5 minutes connection with this case, Lally was calling you as a witness. Josh H., to give Trooper Keefe any defense to perjury, Proctor is no longer in his unit at the time of his testimony in this case. He can claim he wasn't lying. There you go. The wiggle words are always the way out. The wiggle words. Nobody else in my unit was there. Well, he's not in my unit now. I was thinking about right now. Who's in my unit now? Yeah, because perjury requires knowing falsehood. It's got to be intentional. And that's how people always wiggle out of it, or it just doesn't get charged in the first place because they're like, well, here's I just forgot. I just forgot about those 3 people I called. Can I disprove that you forgot it? Not really. I mean, I can point out that seems highly unlikely under the circumstances. But I can't prove that you didn't forget it. Maybe some circumstances you can, but not in this one. So that's where the defense always is. It's in the gray area there. Those wiggle words do a lot of heavy lifting when it comes to being squirrely with your testimony. Patty Scabby, any opinion on Hank being on Whitey Bulger defense team? I mean, not really. That's one of those things it's been on my list since this trial started, and my free hours have shrunk significantly. One of the things I did want to look at was just get a little bit more grounded in the Whitey Bulger prosecution and the overall story of the case. I know like some of the 10,000 foot view stuff, but just as far as the real detailed things that would be implicated by Hank being his defense attorney, really not familiar with it. In general, does it trouble me? Not really. No, I mean, he's entitled to a defense lawyer. What would potentially trouble me is just seeing how Hank is and seeing where his principles, to the extent he has them, seem to be. I've always taken being a defense attorney very seriously. It is an important job, but your job is not there to just get somebody off. Your job is not there to just get a win. I take very seriously things like you are not there to lie to the jury or help people lie to the jury about the case. You can not mention stuff, but lying is not how you need to be defending. So I am not convinced that just from what I've seen of Hank and his methods and his approach, I don't get a real comfortable sense that this is a man with a lot of integrity that I would trust to be ethical in that type of position. Can't say I get that impression. So I suppose that could be a little bit troubling, but like I said, I just don't know enough of the details about that prosecution to really have a strong opinion one way or the other. Capisi, 0 signs of frostbite, and it takes around 30 minutes to get frostbite on extremities. Case closed. Why is this even a case? Yeah, I'm waiting to hear more about the frostbite. I really am. It was one of the first questions I think you have when you think of somebody dying out in the cold. I read into thin air like back when it first came out. We have mountain climbers in my family. Nobody ever did Everest, but people have done some impressive climbs. So I read Into Thin Air way back when it came out in the mid 90s, and of course one of the features of that story was Beck Weathers, the climber from Texas. He was a doctor, I think an anesthesiologist, but I forget. He was some kind of doctor from Texas. He got lost, separated on the way down to Camp 4 from the peak, and like wandered off and kind of fell asleep in the snow, and then by some miracle like woke up hours later and was able to stumble his way back into camp. So he survived, but he was very severely frostbitten. And so one of the things I remember was they grew him a new nose, like on his arm. I remember a documentary about that. I feel like that's sort of normal now. It's not that uncommon. If you're going to do like a transplant, they attach the thing that's going to be transplanted, so that it starts establishing like blood flow and connections with your blood vessels and things like that. So now I've seen stuff like somebody like has a hand grafted to their hand, and I don't know. But at the time it was really disturbing, like seeing this nose growing on this guy's arm. But they did because he lost a lot of stuff. So anyway, yeah, frostbite exposure hand in hand. Don't really know how long it takes. I assume, yes, it would depend on some different factors. Colder it is, windier it is. I don't know if the humidity makes a difference, if it's wet versus it's dry. I really don't know. But don't get the impression it takes all that long being out in bad conditions to start to get frostbite. Waiting to hear about that for sure. Carolyn Smith, what's your best guess as to how judge will rule on the new clock info? Thanks so much. I think she's going to try to force them into agreeing to continue, a continuance. Just whatever needs to happen for ARCA to have enough time to deal with it so that she can let it in. That's what I think she's going to try to do. I don't think she should. I think the fact that, like Alessi has pointed out, the defense has already relied on it. So we're done. Because if you have to shift stream and shift strategies now, if anybody on the jury has noticed, wow, they made a lot of points about this time frame, but now the time frame is shifted and that argument is taken off the table. Who are they going to hold? Are they going to hold that against the defense? Like, did you not know what time frame you were working with? You got some basic things wrong. It's just too much of a risk that you were doing something perfectly correct. You were relying on that information, but now the information is going to change midstream. It shouldn't. It absolutely should not. It shouldn't even be a hard question. Of course, you should not be allowed to present a fundamentally different fact and opinion 3 weeks, almost 4 weeks into the trial. Of course you should not. It's your job to get it done earlier. But are judges generally going to hold prosecutors to that standard? Almost never. So I think she's going to bend over backwards to try to find a way. If they can't do it with a continuance, then I think she might be cornered. She might have no choice but to exclude it. But that's why I think she's going to try to bully him into, well, surely if they had 2 days, 3 days. I guess if the defense asks for a continuance too, that waives, they could just get rid of the jury. Start the trial over. Is that what you want, Judge? I don't think that's what she wants. But if the defense made that request, that would theoretically waive any issue with double jeopardy because they're asking for it. They're asking for they're inviting, what would come from that. So she's going to try to bully them into making that request. I think Alessi has pretty clearly resisted that so far. That's not what they're asking for. They think the remedy is exclusion, but she's trying to push it in that direction. So if she can get anywhere that way, I think she will. J-Man looks like a cattle prod injury. I would not know what a cattle prod injury looks like. Let's take a look. Oh, you're right. It does look a little bit like a cattle prod injury. Just a couple quick things that that come up on Google. Yeah, it's kind of similar to that stun gun, right? Or not quite the same as the taser. The taser typically has the loose their prongs that attach to a wire. And so they can connect closely, they can connect far apart. It's not fixed with when you have the stun gun, it's the two, it's like a box that's got the two, usually the two prongs, and you press them both into the person. Might be. It's still, that would still be a burn though, wouldn't it? Because it's an electrical. It's not a puncture. I don't know what to make of these injuries. I really don't. Michelle Bellinger, I think Bev is pissed about the buffer zone. Oh, good call. I didn't even think about that. Oh, I didn't even think about that. Yeah, good call. Not only is she pissed about the buffer zone because she's wrong, and she's wrong about these free Karen Reed people, and she's wrong on violating their First Amendment rights, but then she had this deadline. She got really put in her place by the Superior Court. You're gonna take care of this now, not on your time. Oh, I didn't even think about this. Yeah, this could be it. This could have her in a mood. Having to drop everything and deal with that and acknowledge you don't get to do things the way you want to. There are constraints on your authority. The First Amendment is one. Go fix it. Prime Finder, if I was a juror in that courtroom, I would be repeating in my head over and over again, biased judge, biased judge, biased judge. So hard to know what the jury is thinking. You know, the jury tends to look up to the judge. And it's not always clear that they see bias. Sometimes they do. But the risk is always they see disparate treatment and they don't think bias. They think, oh, that person must deserve it. That person must deserve the snide attitude they're getting from the judge. They must deserve the objections being sustained. The other person gets to do whatever they want. No limit on them. That's the risk you have. I think for us, looking at it from the outside, we've been with this case for so long. We've seen the pattern for so long. It's really easy to see bias. But if you don't have that, might you think, wow, she's really mad. It must be these people's fault. I don't know. Jana Bell, my first thought when puncture was shown was spider bite, and Google Images confirmed basement dweller. Thank you, Andrea. It's a big spider, isn't it? I could see spider bite. I mean, it does look like that kind of fang, right? It almost does look like fangs. I could see that. Let's look at spider bite real fast. Yeah, maybe something with a pair of fangs, and it's real fresh. So if there's any venom in it, it hasn't had time to get, get all infected and gross the way it gets. That could explain it. It's probably a big spider, or maybe it's two spiders, 2 bites. Just one fang, but I don't know. That's a possibility. Good thinking. She was very incurious about it, I guess, because it didn't seem likely to have contributed to the cause or the manner of death. But I wonder if there is testing that could have been done on that. Can you test for like venom, spider venom? I mean, not every spider and not every snake is going to, even if they are venomous, they don't always inject the venom. So I don't know if it's going to be there, but I wonder if there would be some way to verify. Is this an insect bite? Some type of allergic reaction to it, maybe? I don't know. Good call on this. That seems plausible to me. Some type of insect bite, maybe. Lucid Visionary Girl 88. How come no one has asked if he was outside from 12 to 6 what his body temp should be, or at least a range, or why there wasn't dirt found in his wound? Well, they asked about the grass, right? They did ask about no grass anywhere in that that head injury. She confirmed nothing like that. But yeah, they are, huh? They're really not going where it might seem logical for them to go, which is that whole time frame and the temperature. It's being left so ambiguous by both sides, and that's part of what's confusing to me, because you'd think it would be in at least one side's interest or the other side's interest to get a little bit more precise about the time of death and the processes, and so this is consistent or not consistent. But we really haven't seen any of that. Maybe the answer to this is just it depends, but surely we could consider this hypothetical. He's a normal, healthy man. Assume he's 98.6 degrees, gets hit by the car, dies outside, lies out there in these conditions. I mean, we have the weather report in evidence. Assume that that's what the conditions were locally there on the front lawn of 34 Fairview. What would you expect to happen? What would you expect the body temp to be? Would you expect frostbite? Would you expect hypothermia? I don't know why they're not going down this road. I wonder if we're going to get more of it from the defense expert. If the defense expert is going to opine about this, then I would kind of expect the Commonwealth to pre-butt it, address it in advance with one of their experts, but obviously not, not Scordi-Bello. She's done her part. She's done in April of 2022. I don't see the neurosurgeon being qualified to answer that type of question. So I don't think the Commonwealth's going to get into it. And if they're not addressing it ahead of time out of the gate, I'm not sure if the defense is going to either. Just not sure. A Cool Breeze is gifted 10 memberships. You guys, the whole chat is going to be green at this rate. Very generous. Appreciate that. Patty Scabby, potential primer. Hank appeared as a win at all cost attorney, along with an ironic case theme of cops are corrupt. So that's what I get to look forward to, huh? He win at all cost doesn't surprise me. That's the impression I get from here. He doesn't care about principles. He doesn't care about standards. He cares about what is to his advantage, and so that's why it's perfectly fine to go in and malign and dehumanize the ARCA witnesses while critiquing the reliability of your own expert is maligning and dehumanizing. There's no standard that everybody applies to. It's just whatever is convenient for him in the moment, whatever is going to support what he wants. So it's definitely the read I have on him. All right, you've got me intrigued. I'm going to have to find time to look that up. I saw there is a question about, could the injuries maybe be from an electric dog collar, like a shock collar, one of those shock collars? They use those shock collars to keep the dog from barking, right? Or I think that's the most common one, but it's also can be for the invisible fence is electric as well. And it's very similar to the stun gun, just, probably less voltage. I would certainly hope it's less voltage. But same general type of construction. It's got a couple of prongs on it, and whatever triggers it causes it to send the electrical impulse in, and it shocks the dog. If it's the bark, shocks the dog. When the dog learns not to bark. Maybe it's just that these look like punctures. They don't look like electrical burns. They look like punctures. I gotta say, after hearing everybody's theories and comments and everything, I think I might be leaning in favor of that insect bite. I don't know, though. I don't know. It's a big mystery. Yeah, the problem with things like the stun gun, the dog collar, they're not that close. I mean, could there be one out there where the prongs are that close to each other? Sure, maybe. Maybe a toy dog. Maybe there's a toy dog shock collar, where they have to be closer together. I don't know. It could just be a design feature. But it's more just the injury itself. It's not a burn. This isn't a burn. It really looks like a fairly clean puncture. I'm leaning in favor of the insect bite, but I'm very curious to know. I've got a lot of folks in the chat, you guys with medical knowledge. I don't know. Oh God. And now Jeff's bringing up, yeah, it's winter. It's winter. Well, I guess if the spiders are anywhere in the winter, are they in the basement in the garage? And we do still find them from time to time. We find a way to sneak in, but definitely not on the grass outside, not on 34 Fairview. Guys, I don't know. I'm as perplexed as you are. Don't know if we'll get an answer to it, but definitely interested in what you guys think. Definitely interested in your thoughts about this. Yeah, winter spiders would have to be the basement. It's a good point. Yeah, winter means there's not a ton of spiders around. So have to be in some kind of protected and probably heated area. Well, guys, been another fun day. Another fun day. I feel better now, going through having this conversation, the comments, the questions, being able to talk some stuff out. I feel better about the day. Feel a little bit more just relaxed, not so worked up, not so angry, not so outraged, not so indignant about how the process unfolds in front of us sometimes. Really easy to burn yourself out on outrage in the criminal justice system. There's a reason why there's a high burnout rate. Reason why, often people don't last. I put in almost 20 years, almost, and it's been enough. It's been quite enough. Because it can be a lot. It can be a lot to have to cope with and deal with and tolerate. And at some point, you might just get too sick of it to handle it anymore. Just too much. Everybody has a breaking point, right? At some point, you're going to go home and turn your excavator into a bulldozer. And no, I'm not gonna build a killdozer. But I understand some people will do that. Everybody does have a breaking point. TB85 really wish they'd get someone to assume he was already dead and a body temp of 80 degrees, not diagnosed as hypothermia. Well, I have to wonder if that's where they're going to go with the defense expert, right? Because they're clearly ruling out the hypothermia. So if they're ruling out the hypothermia, then the 80 degrees seems like it would be related to, some combination of the process of the body cooling and being out exposed to the elements. No frostbite, would tend to suggest he's already dead, wouldn't it? Do living bodies get frostbite? I don't know. Not living. I know living bodies get frostbite. We're past 10 and a half hours, guys. I'm running out of my words here. We know living bodies get frostbite, but I don't know if dead bodies get frostbite. If he was dead at 12:30, is that a reason why he wouldn't have frostbite? I don't know. Waiting to hear more from the case. I like to reassure my husband from time to time. You know me very well. You know I'm not going to build a killdozer. Oh, guys. Well, double Alessi Cross, and then it wasn't really the joy fest that we might have hoped for. Definitely had fun with Maureen Hartnett. Felt like that went really well, but then things started to go a little bit astray. during that first part of the cross of Dr. Scordi-Bello. Just got a little in the weeds with the hypothermia, but came back strong after lunch. But then Bev had to go stir things up. Had to go do that bad reffing. Suddenly the strike zone is anywhere Hank Brennan wants to put the ball. And that very aggravating motion, even just, knowing that type of thing is still going on. They're still playing that game, the late discovery. Just dribble it in as you see fit. They're still playing that game. They got away with it through the entire first trial. Still playing it. That in and of itself is aggravating enough that it's not an instant shutdown. Of course, you don't get to bring that in. It's far too late in the game. It's also quite aggravating. And so now we're in this uncomfortable position of trying to anticipate, what is she going to do and how is she going to justify it? And it's uncomfortable. It's a bad limbo position. So guys, my advice to you today is to just remember that those things, those anticipations, those expectations, they're not real. None of it's real. None of it's happened yet. She hasn't even ruled on it yet. We don't actually know what the reality of the situation is going to be. So there's really no point in forcing ourselves to suffer over it unnecessarily. It may never happen, but even if it does, it's not happening right now. So don't let it deprive you of the opportunity that you have to enjoy what you do have this moment. Enjoy the good things about this moment. Scored some good points on cross. Defense has been fairly effectively neutralizing pretty much every witness that's put forward. Still no evidence that John O'Keefe was hit by a car. And tomorrow's Friday. We're getting close to the end of the Commonwealth's case, closer and closer to the defense case every day. So plenty of good things to focus on. We don't have to get upset, get ourselves in a bad mental and even physical condition, guys. Stress, anxiety, very physically damaging. We don't have to do that to ourselves unnecessarily. We'll just wait for Judge Bev's ruling and then we'll roll with it when we get it. We don't have to let it ruin what we have right now in this moment. So with that, guys, do take some time to recover from today. Take care of yourselves. Give yourselves what you need. If you are feeling anxious, if you are feeling disturbed, if you are feeling angry, sometimes just a deep breath is all you need. That nice deep in through your nose. It's a yoga trick. Anybody who's done yoga knows the trick, but there's some good science behind it too. It has to do with the vagus nerve, and breathing in through the nose tends to help slow the heart rate and just stabilize some of those internal processes associated with stress. So sometimes all you need is a deep breath. Sometimes you just need a distraction. Go think about something else. Go for a walk. Read a book. Watch a documentary on TV. Whatever you need to do, but just do take the time to look out for yourselves. If you found today troubling or disturbing, infuriating, any of the above. Tomorrow will be a new day, Friday, last day of week 4, closer and closer to the end of the Commonwealth's case. So lots to look forward to, guys. Then a whole weekend, plenty of rest, sleeping in, all that good stuff. So with that, guys, do appreciate all of you. Appreciate the chat, all your ideas. CH, I'm not going to build a killdozer. But hey, I'm not, not sure I'm going to advocate for doing that if that's what you need to do. Really, there are better ways. But hey, do what you need to do. Try not to reach that breaking point so that the killdozer doesn't need to be necessary. And appreciate each other. You know, that's an important part of keeping a good, healthy perspective on everything. It's just appreciate the good people around you. We got so many good people in the chat, wonderful mods, wonderful crew, great insights, great ideas. We're all fixated on the punctures now, hoping we'll find out what they are. Maybe tomorrow will be the day, guys. Maybe we can look forward to that. We'll see. We'll see. So with that, everybody, thank you so much. Appreciate all of you being here. Appreciate your support. Look forward to seeing you bright and early tomorrow, and we'll see what Friday brings.